Well, good morning, everybody. Welcome to day one of the hearing by Willowbank Trustees Limited in relation to a series of applications to both the Greater Wellington Regional Council and the Porirua City Council. My name's David McMahon. I've been asked to chair these proceedings, and joining me on the panel to my far right is Commissioner Liz Burge and Commissioner Nigel Mark Brown. And we'll have some full introductions from the panel momentarily. But there's a few administrative matters that I'd like to undertake first, and I'd like to start with some health and safety announcements that Ash will deliver.
Good morning, everybody. So in the event of a fire, we have got a fire exit right down the back of the chambers just over there. And it should be unlocked, so we can just take the stairs down, and there's a car park at the very base of them. Event of an earthquake, please get underneath your desks. We've got fire wardens who will be up to help us if there is a fire or an earthquake. COVID protocol, so obviously mask wearing, please, if you can. In the chambers, it's fine to leave them off, but once you leave that door, please just put them back on. Microphones, you'll see that you've got a little push button on your microphones just here. Please ensure that you do actually turn them on. And the reason for that is just so that we can hear you, and also for our people on Zoom as well. And then toilets, obviously very important. We've got toilets down the very end of the corridor to the right. There's male and female there, and then every stairwell going up and down has got alternating male and female as well. So you can use those if you need to. Thanks.
Thank you, Ash. Right. As I mentioned, this panel has been delegated by both the Greater Wellington Regional Council and the Porirua City Council to hear and determine submissions on the three applications that have been lodged, generally 2 land use applications to the Porirua City and a series of discharge permit applications to the Greater Wellington. I'm also conscious that there have been applications under the NES for soil contamination lodged that are being dealt with by the Porirua Council. So this is a joint hearing, but it will involve separate notices of decision on the 3 applications, probably referencing a combined decision report. I think there's some economy in adopting that approach, but it's important that the decisions that this panel reaches on the 3 key applications are recorded separately. Before I go too much further, I think it's useful to have a record of appearances, and there is a register just outside the door to this chamber, and I'd encourage everyone on a daily basis to fill in that register just so we have a record of who's attended at what point in the proceedings. But apart from that, I think it's good to eyeball people. So I'm going to invite, firstly, the applicant to just introduce their team. Mr. Matheson.
Te Maria Commissioners, Bell Matheson, Council for Willowbank and Fulton Hogan. So on my left I have Mr. Peter Walsh, so he's Fulton Hogan, Paul Nation from Willowbank, Amy Brown to my right, and Wade Robinson, and we have some more people in the back, and Glenn Pope, who's here as well.
Mr. Pope.
Mr. Baker, Kimberley, who's trustee of Willowbank Trustees, here as well.
Welcome.
Philippa, yes. Dale Eastham from Fulton Hogan, and Simon Dine from Fulton Hogan.
Thank you. And do you have anyone online, Mr. Matheson?
Oh, sorry, Brad. Sorry. Hiding over with the nasty councillors, no.
Bram.
Yep,
Welcome.
Bram Mulling. And do we have anyone online? No.
Okay. Thank you, Mr. Matheson.
Thank you.
Just so that people know, we're going to take a little bit of time just in this first 15 to 20 minutes to set the scene. So before we ask Mr. Matheson to open the case, so there's no rush. I think it's important to set these procedural matters out first. Can I just now invite, firstly, the Porirua Council to introduce their team. Ms Williams, welcome.
Kia ora koutou. So I'm Karen Williams. I'm the consultant reporting planner for Porirua City Council for the 2 land use consents. With me today I've got Mr Malcolm Hunt, noise advisor behind me, and online I can see I've got Dr Jamie Mackay. I can't see who else is there, but I'm expecting our other advisors to be there. Yes. So
we'll go to the wall presently. Well, just on that, Jamie, do you just want to introduce yourself and make sure we're hearing you and seeing you?
Hi, Dr. Jamie Mackay with Wildland Consultants representing PCC as an ecologist. So I've reviewed the applicant's ecological reporting and the various submissions, and I'll sort of just be lurking until required.
Thank you, Dr. Mackay. And we have you fully on the screen now, so thank you for that. Anyone else, Ms Williams, anyone else representing Porirua that's online?
As I understand it, some may be on the YouTube channel as well, watching in as opposed to actually participating within.
Well, let's hope it gets lots of hits.
Yeah, that's right.
Okay, good. Could I go to you, Ms Walker, and an opportunity to introduce yourself and your team, please?
Kia ora, I'm Genevieve Walker. I'm the reporting officer for Greater Wellington Regional Council, and with me I have Anna McLean, our team leader for Earthworks and Coastal.
Lovely. Welcome, both of you.
We've got Deb Ryan, who's just listening in. She's our air quality expert.
Okay. Ms Ryan, can you just confirm that we're coming through loud and clear?
Oh, yes, all got at my end. Thank you very much.
Thank you. No one else, Ms Walker, at this stage? Thank you. Okay, now I'm going to just check the room for any submitters in person are present. No, but may well be some submitters online. I think I'll go to you, Professor Irons. I see your name there. Welcome and good morning. I think you might be on mute, Professor Irons.
Oh, goodness, yes. So this is just good morning, this is just my laptop. And
yes.
I did, with a dodgy...
Hope you're coming through. We have visuals, Houston.
Yeah, sorry about that. I will be, whenever when I actually present on Wednesday, I'll be there in person.
Okay, thank you.
I should have joined the YouTube and just be watching.
Okay, just before you go, any of your witnesses present online at the moment that you can ascertain?
It looks, I can see only 3 others, 3 other names in this. You've introduced Deborah and Jamie Mackay and the hearing administrator.
Thank you. And you're hearing us all right at all?
Yes, perfect. It's
good.
Really good. Thank you.
Thank you. Just before you go, just for the benefit of the gallery, we've received this morning, and it's been copied and circulated, the final opening submissions from Professor Lyons. On Friday, we received a draft version. When you come to present these on Wednesday, it'd be good if you could indicate the particular changes between the draft and the final. And
I can let you know. All I did, and I mentioned that in the email to Ash. All I did was add that section at the end on commenting on the draft conditions, because that's what JEP still needed to check. And then since the Friday ones came in, they had a meeting yesterday, which is why it didn't come through till this morning. Okay, so yeah, I deliberately did not change anything in advance, just so you didn't have to trawl through it, wondering what had changed.
So if I just make a note on the front page that it's just the last section on commentary on conditions, that's new.
From page 17.
Page 17. Thank you for that clarification. And we'll see you later in the proceedings.
Thank you very much.
Okay, now have I missed anyone? I see Mr Voss present. Welcome, Mr Voss. Can you just use the microphone, please? And I should add, please everyone push the button when you're speaking and turn it off when you're not.
Good morning, Commissioners and everybody. I'm Derek Voss, Resource Concerns and Compliance Manager here at Porirua City Council.
Yes.
I'll introduce myself, so I'm not the only stranger in the room. So kia ora koutou, I'm Nick Etheridge. I'm the General Manager for Policy Planning and Regulatory Services, so obviously taking a keen interest in the hearing, and we'll be ducking in and out throughout the week to see how it goes, so thank you.
Thanks for your attendance, Ms Etheridge. Okay, well, I think it's only fair that we reciprocate now and let you know who we are and what we bring to these proceedings, and I'm going to ask Commissioner Burge to kick us off on that.
Kia ora koutou. Well, you know my name, obviously, so I won't repeat that. I'm from the Wairarapa. I have maybe 25-ish years of experience in resource management, various roles, including working with the Waitangi Tribunal. So Māori consultation is one of my key themes. I've been an independent commissioner for about 13 years, mainly in the Wellington, Manawatu and Upper South Island. I specialise in planning and policy, including plan development, plan changes and consent hearings. I do have a focus in subdivision and land use on a variety of projects and resource uses. And in relation to this hearing, I was involved in the Windstone cleanfill operation on State Highway 58 a few years ago. So that's probably the most relevant to this. Thank you.
Thank you, Liz. And Commissioner Mark Brown.
Good morning. My name's Nigel Mark Brown. I am a civil and environmental engineer by training. I've had over 40 years' experience in a wide range of civil and environmental projects. I've been working as a commissioner for 13 years, a large number of consent hearings, including large quarries and a range of other activities or consents involving discharges to water and to air. Thank you.
Thank you, Mark. Nigel, sorry. Well, as you can see, I'm pretty privileged to be sitting with two high calibre commissioners that, through their experience, cover the range of issues that this application brings to the fore. So I'm very pleased in that respect. As to myself, I'm a planning practitioner, so really, as my dad would say, a jack of all trades and master of none. God rest him. But as a generalist, I think I bring a sort of a broad understanding of the proposal and the issues here. I'm in private practice. I've been in private practice since 1991. Started my career in the mid-80s with the Ministry of Works and Development. It's a great training ground for a young graduate to learn the ropes, and then moved into a state-owned enterprise, practising in the field of planning until 2001, when myself and two colleagues left and formed a bespoke planning consultancy known as Resource Management Group. So I spent my first 10 years in that company based in Christchurch, and then 3 days after the Christchurch earthquakes in 2011, I shifted to Wellington, and I've been here ever since. And I must say I'm loving the Wellington environment. In terms of my planning expertise, I've been involved in resource consents, plan changes, designations, plan reviews, from three perspectives: preparing and lodging those for the private sector and councils, as an independent processor of those matters for councils, and as a decision maker, as an independent commissioner on those types of matters. So I'd like to say that, modestly, I bring a 360-degree range of experience on matters such as the proceedings today. So having prepared, processed and decided similar matters. Of particular relevance to this proceeding is I have been involved in previous quarry decisions, none in the North Island, all in the Canterbury region, one involving Fulton Hogan in the Yolthurst area. I've also been involved in a number of landfill applications. I know they're not quarries, but they bring similar issues to the fore. Probably my biggest one was the Cape Valley Regional Landfill in Canterbury, North Canterbury, in 2002, 2003. And I guess more recently, the Bonnie Glen landfill in Fielding Martin area, where I sat with Commissioner Mark Brown. So that's the consenting regime. From a planning point of view, I've been involved in the Greater Wellington Natural Resources Regional Plan hearing, and I was part of a 3-member team chaired by Mark Sinclair that involved myself and Commissioner Burge, and that was between 2016, 2018, I think. I'm also a member on the panel for the review of the Porirua City District Plan, and I might have seen some of you involved in that. I know Ms Williams, you've presented, and I think Greater Wellington have presented also. So that's given me a very broad understanding of the statutory framework that's affecting these applications. Okay, so that's enough about me. Just going to concentrate on a few administrative matters, and I'm then going to end with some general observations about the issues confronting this hearing, and then I'm going to invite an indication of any procedural issues from the floor. So just bear with me as we work through these. For those that don't know, and I imagine most of you do, the batting order is that the applicant will proceed. They'll present their case, starting with legal submissions. In an overview, they'll call the company witnesses, and then they'll work through their expert witnesses in a logical sequence. We've allocated the first 2 days for that. Now, in the event that we don't use those 2 days, you can be assured that the panel will use their time wisely, and both in terms of reading and possibly further site visits, and I'll touch on site visits in a moment. Come Wednesday morning, we'll kick off with the first of the submitters, and I think Waka Kotahi are the first cab off the rank, and that will take, the presentation of submitters will take the full day. And then on Thursday morning, we have a small recess because this room is not available. So we'll commence Thursday at 1 p.m, and that will be with Greater Wellington, followed by Porirua City Council. And that'll take us through probably to mid-afternoon on the last day, in which case I'll invite Mr Matheson to give us a verbal right of reply with the opportunity to distill that into writing at a time to be determined. But we can discuss that further, Mr Matheson. It's traditional for the applicant to exercise a right of reply. Mr Matheson will know it's not an opportunity to relitigate or re-summarise the proposal. It's rather an opportunity to respond to matters that were presented during the course of the hearing, and it's not an opportunity to introduce new evidence. In terms of the breaks, and we won't stick to these religiously, but around 10:45 for morning tea, 12:30, 12:45 for lunch, 3:30, 3:45 for afternoon tea, and generally we'll finish around 5 o'clock, but if we're making some progress, I'm happy to go a little bit later, particularly if it means we're going to get through everything. In terms of the presentations, we've had a multitude of paper, and all of the expert evidence, including the 42As, have been pre-circulated, and they will be taken as read. Last Friday, I received from all witnesses, with a couple of exceptions, summary statements as to their expert evidence, and in some cases rebuttal statements. And it's our expectation that they will be the focus of the presentations for witnesses over the next few days. We'll certainly be focusing our questioning on those, but we will return to the evidence in chief where required. As you know, or hopefully you do know, no cross-examination is allowed or has been requested. If there are any questions of clarification from the floor or from the wall, the process is to indicate that by raising your hand. I'll decide whether we entertain the question. But what I would say is please use that process sparingly. You'll all have your opportunity to make your presentations in due course and at the relevant time. And so really just genuine cases of factual clarification. I guess I just want to say that in terms of the way the hearings run, I do expect a degree of courtesy and common sense to prevail. Please don't interrupt witnesses when they're talking. I guess the rule of thumb is treat them with the respect that you would expect others to treat you when you're making your presentation. In terms of the style of the proceedings, and this will become apparent during the course, I've developed a portfolio approach to questioning, and I won't indicate who's got what portfolio, but that'll become apparent through the questionings, and I'll ask the appropriate person to lead off on the questioning on the appropriate portfolio. But that's not to say that there won't be questions across the board from all three of us. And I've worked with this panel before. We generally adopt an inquisitorial approach to questions. So that means that we may interrupt from time to time, usually at the end of a section of a statement, rather than leaving it to the very end. And we hope that that's helpful and not too disruptive. I mentioned site visits earlier. Yesterday, the panel undertook a site visit in two respects. We were given the opportunity to visit the Quarry and the Quarry environments. We were escorted onto the site by Shane Haggai, who's the Quarry manager for Fulton Hogan. Shane's presence was solely from a health and safety and guidance perspective. There was no discussion about the hearing or the proceedings at all, and we would not have been able to conduct the site visit without Shane's assistance. So we're very grateful for him making himself available, coming over from the Wairarapa on a Sunday afternoon. We also undertook after that a locality visit, which essentially involved driving along Harris Road and Murphy Road, citing the different properties along that road, not going onto the properties, obviously. And that was, we were assisted in that task by Mr. Voss, and again, the same protocols were applied. There was no discussion about the hearing. Mr. Voss was available to do this because he had an understanding of the area, and we were grateful for his assistance and also giving up his Sunday afternoon to do that. Quite clearly, there will be a need for further site visits. Really, yesterday was a matter of familiarisation and reconnaissance, really. It gave us a feel for the quarry operation. It gave us a feel for the proximity of submitters' properties to the quarry. And to that extent, we had some very extensive mapping prepared by council staff that showed us all of that matters, and we're very grateful for whoever produced that. Okay, just a couple more things. Last week, the panel received 1, 2, 3, I guess I call them letters, indicating two from submitters and one from a non-submitter. First was from the Department of Conservation, and it was addressed to the both of the councils, just indicating that they had withdrawn their request to be heard at these proceedings. Mr. Matheson, did you receive that? Yes, you did. Okay. So that's a request, that's a withdrawal to be heard. It's not a withdrawal of the submission. Submission remains live. We also received an email from Mr. Gow from the Guardians of the Patanui Inlet, just indicating, well, I think it's indicating that they endorsed the Section 42As and that they're not attending. Did you see that email? No. Okay. We'll arrange for Ash to do that. And the third letter was received from Ngāti Toa. It was providing a joint position between Ngāti Toa and the Taranaki Whanui, and they were, as I understand it, neither are submitters to the application, but they've expressed some concerns in their role as kaitiaki over their respective areas. and the concerns relate to engagement with the applicant, and they express support for proposed draft conditions, particularly from the Regional Council, I think. Mr Matheson, have you seen that letter?
No, we haven't seen it, and it is from a non-submitter, and none of our witnesses have had a chance to respond to it. So, being from a non-submitter, and that's not to say that, we'd like to see it and would like to understand the concern so we can engage with them. It's just as a matter of process, I'm not sure whether it's intended to be part of the hearing record or not.
Well, I've introduced it, and I'll give you the opportunity to tell us what way or how it fits into the jigsaw, if you like, at the appropriate time during your legal submissions.
Yeah, well, as I say, I'd like to discuss that with Willowbank and Fulton Hogan, and again, it's not, we would like to hear the concerns and understand them so that we can discuss that with them, and they'll be, key stakeholders that we want to work with.
Yes.
I am concerned about sort of non-submitters writing to the commissioners, not being evidence and not being submissions. So we'll respond to that.
Okay, thank you. And I'm just providing you with that opportunity. Okay. Okay. I just want to very briefly outline what the panel see as the key issues that they'll need to grapple with over the next 5 days and beyond. And really it comes down to ascertaining whether the statutory tests of the Resource Management Act for both sets of applications are met. When I say statutory tests, I acknowledge that one application is for a non-complying activity and one's for a discretionary. And Mr Matheson, I'll ask you at the appropriate time to comment on what that means in terms of bundling, if at all. So the panel would be very interested in understanding the applicant's view on that, and I'll provide the same opportunity to the 242A officers to discuss that. But as I said, we need to understand whether the statutory tests are met in terms of, firstly, the nature of the effects, and secondly, the consistency or otherwise with the policies and objectives of the relevant district and regional plan. And essentially, it's in terms of effects, it's really a matter of determining whether the potential effects, which have been well documented on the operation of the quarry, can be appropriately avoided, remedied or mitigated. That's a straight quotation from the Act. To an acceptable level through the imposition of conditions. And on the policy front, it's really how the proposal sits in the context of the policy direction in both plans. And when I say both plans, I mean the NRRP, which is largely operative, but I also, in terms of the Porirua plan, both the operative and the proposed plan, where those policies do have to be considered in terms of their weighting. And our findings on those two matters will really determine the outcome. And really the range of outcomes are a range of decisions ranging from approval through to decline. And in between, in between is approval under restrictions, and those restrictions can include duration. And two applications that are before us are to the Porirua Council, at least for a 5-year duration and a 25-year duration, and I believe the Greater Wellington application is for a 35-year duration as applied. In considering those matters, our decision will be based on the evidence, our testing of the evidence, our understanding of the evidence. We will not and are not required to introduce our own evidence. Rather, what we do is we use our expertise to test the veracity of the evidence. No evidence has particular primacy, and I know Mr Matheson comments on this in his legal submissions. We consider all the evidence and weigh it equally, and that includes the Section 42As. There's no obligation for us to be bound by the recommendations in the 42As. I think it's an important point to note. Okay, so at 10:30 I've exhausted my notes. I don't apologise for the length of that. I think it's important that those matters are made clear. But I'm going to just check whether there are any matters of procedure that any party would like to raise, starting with you, Mr. Matheson.
No, thank you, Commissioner, but it would be good to have a talk about the traffic conferencing and whether directions have been made or whether that's occurring.
Okay.
And I have one update in respect of Mr. Rowe.
Okay.
When you have a moment.
Well, we can do that now. Late on Friday afternoon, I issued Minute 9 while travelling back from New Plymouth. I did that in light of knowledge that some of the traffic experts had begun administrative arrangements to commence conferencing this morning. I also was made aware that that the traffic witness for JEPS, Mr. Wanty, may not be available, or that his client may not be agreeable to attendance by Mr. Wanty in conferencing. So the minute that was issued on behalf of the panel gave a very strong encouragement for conference to occur with all 5 traffic experts. That includes Waka Kotahi, Porirua, and the JEPS and applicants' own witnesses. My expectation is that that will commence this morning, and that it will carry on for as long as it needs to carry on, and we can defer your traffic witness to the end if that assists Mr. Matheson. What I haven't done is made a direction, an absolute direction, and I've done that out of courtesy, but the panel was very keen for all 5 witnesses to conference, and based on reading the rebuttal statements and the summary statements, it seems to me that there has been a number of matters agreed since the 42 was prepared, and it seemed to the panel that there was an opportunity to further nuance some agreements, or at least anchor in those areas of disagreement. So that's what I'm trying to facilitate there. Does that answer your question, Mr. Matheson?
Yeah, thank you, Commissioner. I'm sure the experts be aware of their obligations to the panel and the importance of expert conferencing and working with other experts to narrow issues, so I'm sure everyone's familiar with that, or should be. Mr. Rowe, unfortunately, is not going to be able to participate in the hearing. I can provide further details if you need to in private, but I'd rather not do that now.
Understandable.
But Mr. Andrew Murray, who's a technical director and reviewed his report, is able to adopt his evidence and speak to the model. I didn't understand from the council's traffic expert or Wakatai's expert there was any issue with Mr. Rowe's evidence, and in fact they found it helpful from what I understood in terms of understanding the issues.
Yes.
Mr. Murray is familiar with the model and did review the report. So the request would be at the appropriate time that Mr. Murray essentially adopts Mr. Rowe's evidence, and then to the extent he didn't actually do it, then that would be a question of weight for the panel that you should feel free to do how you wish. But that's where we're at.
And I don't think I need to inquire any further as to the reasons for Mr. Rowe. Obviously, they're confidential and personal. But I would like a written statement from Mr. Murray, just adopting Mr. Rowe's evidence.
Yeah, we'll get on to that, and he can confirm his involvement to date and make sure he's comfortable to answer any questions.
Yes. I'm going to come to you now, Ms. Williams, just on that in terms of your understanding of what I've just said and the availability of your traffic witnesses.
Yeah, my understanding is Ms. Fraser is all scheduled and available to participate in that joint witness conferencing.
Yes.
She has confirmed that with me, so
thank you.
That's my expectation.
Yes. I'll be coming to you, Professor Irons, in a moment. Just before I do, Mr. Matheson, what about Mr. Kelly?
Well, he should. He's still. Yeah.
That is good.
Yeah.
You hadn't mentioned him.
Oh no, he's he'll be
Good
there.
to go.
He'll be there with bells on, I'm sure.
Good. Okay. So from the applicant, Mr. Kelly and Mr. Murray, Ms. Fraser from the council. Now, Professor Irons, I see you've got your hand up.
Thank you. Yes, I just thought I should clarify that I have forwarded your minute to David Wanty, the traffic expert.
Yes, thank you.
He's a very experienced expert in this area, has appeared at lots of hearings here. He understands the importance. Of course, that is up to him. I don't know if you're aware that he has been scheduled early before all of the JEPS experts on Tuesday afternoon, purely because he's off overseas on Wednesday for another hearing. And I understood that he actually was unavailable. So I've left that to him to see if he can organise, and it's not really my role to order something. I guess, I mean, I know with any hearing there are late things like this that arise, but I just think he was unable to accommodate it is the difficulty.
Okay, okay. That was not my understanding, but I'm happy to be corrected on that. I guess what is important as counsel for JEPS, and I guess because Mr. Wanty is your witness, I think we would prefer that you are able this morning to convey to him the desirability of his attendance at those proceedings, hopefully today. When he presents tomorrow afternoon at around 4 p.m, will he be presenting in person or via Zoom?
No, I believe he's coming in person, and so and is more than happy to to do that. Everything he needs to. Then it was literally I got the impression it was time allocation.
Yes,
before he disappeared.
Yep, there's a day and a half available between now and then. The panel would be very keen to have his involvement with the other 4 traffic experts, and we'd be very keen to see a draft joint witness statement being produced as soon as possible. So I'll leave it in your hands to convey that to Mr. Wanty, but as Mr. Matheson said, he will understand his responsibilities to the panel as an expert witness, agreeing to abide by the Code of Conduct. Thank you.
Thank you.
Okay, Ms. Walker, any procedural matters? No?
No, nothing from us.
Thank you. Nothing further from you, Mr. Matheson? Just check with my colleagues. I think the message is shut up and get on with it. So I will do. Okay, Mr. Matheson, we're in your hands. We have a huge pile of summary statements in rebuttal. We have your opening submissions, which we've read, but we would appreciate some synopsis of those, just to warm things up, if you like.
Thank you. Good morning again, Commissioners. So I won't read these out. I will just speak to them. I think the key issues are reasonably well confined. Just starting briefly at the executive summary, and I started deliberately with positive effects. There's a paragraph or so in the PCC and the GWRC on positive effects. In my submission, that is an effect which is not only relevant but essential to be taken into account. And positive effects are often the poor cousin at resource consent hearings, and they often get nary a mention. In circumstances such as aggregate supplies, which are a significant regional issue, not just in Wellington, in Auckland, in many places, and in circumstances where a region cannot provide its own aggregate supply, it's carted in from elsewhere. And I think Mr. Walsh's evidence, certainly my understanding, is the cost of that aggregate doubles every 30 kilometres or so. So if you're taking aggregate from 80 or 100 kilometres away, it's not only inefficient, creates greenhouse gases, and it has all the traffic safety and other efficiency effects on the state highway for the distance between where it's used and where it's taken from. So, I think in circumstances where there's objections to quarries based on traffic efficiency effects, one does need to look at the counterfactual. You can't build motorways, you can't build houses, you can't build runways, You can't build anything without aggregate, and that has to come from somewhere. And that's just, until we find a better solution, that's what we've got. Certainly the applicant makes no apology for wanting a long-term certainty of resource, not for Wellington. And if you don't have that long-term certainty, there is a concern around, well, where is the aggregate going to come from? The other two, if the other two quarries in Wellington continue, they may well not continue certainly not past the life of this quarry. Auckland's now down to about 2 or 3 main quarries, that's it. There's a couple of small ones up north. Unless you plan long-term for quarries, you do end up with a serious problem. Areas of exposed aggregate that are able to be extracted efficiently and sensibly get built out. Houses get built too closely, rural residential lifestyle gets built over the top of them, and then they're gone for good. And then you end up hauling an aggregate from elsewhere. So I don't make any apology for putting that front and centre. And it is recognised in the regional policy statement, and it is an essential regional issue. There doesn't also seem to be much disagreement about the applicable objective and policy framework, and geotechnical stability seems agreed. The areas of dispute really come down to transportation effects, and that's really the intersection that, if you haven't seen, I'm sure you'd be aware of where it is. You've seen the photos of it if you didn't actually go. Did you go to the intersection? Did you get
Yes,
yeah,
we did.
Okay, yeah. The experts have their view on that. I've seen quite a few quarry intersections around New Zealand. That's one of the biggest, most well-formed intersection I think I've seen. In terms of the hours of operation, and I'll come back to that, but there's 2 issues there. There's the allowing traffic movements before 7 o'clock in the morning, and then in the 6 p.m. to 10 p.m. bracket, and I'll come back to that. Dust effects have been raised. Some ecology effects have been raised. The landscape effects, again, for a quarry application, the fact that the landscape disagreement talks about whether you should plant up the top of a mitigation bund along an access road, I think is testament to how well hidden effectively the quarry is. This is not one that has widespread landscape effects, and you would have seen that from the site visit, I'm sure, the very enclosed nature, enclosed visual catchment of the quarry. And there is there's not really any disagreement about landscape effects. And then the term of the consent's obviously at issue is between Greater Wellington and the applicant, noting the PCC recommendation is for 35 years for its consent. Turning then, so 1.3, the conditions really just outlined the discussion we've had in terms of those outstanding matters. At 2.2, just in terms of the introduction, and Mr. Walsh and Mr. Nation will talk through this in more detail. At 2.3, just making the point at 2.2, and the JEP's legal submissions picks up on some of the background hearing as well. The quarry was operated by a JV for the Transmission Gully project. As explained by Mr. Nation, Willowbank became frustrated by the way the quarry is being operated, and there are some legacy non-compliance issues that are needing to be addressed. They are being addressed, most have been addressed, and I think there's 1 or 2 matters that more work needs to be done, and I think it's the end of this year that those will be finally addressed. Willowbank, at 2.5, Willowbank did see the importance of the farm having a separate income stream that could come from the quarry, as well as being an essential regional resource. Again, Willowbank had several unsolicited offers, people saying we want to come and continue to operate the quarry, which again is reflective of the desire of people and the need they see in the region. At 2.6, just noting, Willowbank took their time. They had a look around. They considered carefully who might want to operate it. Mr Nation didn't want another cowboy on the farm, and they took their time. Fulton Hogan's a very well-respected New Zealand-owned company, operates some 40 quarries around Motu. Senior management at Fulton Hogan have participated in the consultation, and as noted at 2.8, two of the directors from the founding families went to Willowbank and met with the principals to discuss how they might work together going forward. This has very high visibility within the company, and the company sees it as a strategic investment long-term for Wellington. Turning at 1.9, in terms of appropriate locations for quarries, a dedicated access road connecting directly to State Highway 58 is a very positive feature. A couple of quarries I've been involved with recently in Auckland have long local roads before they get to arterial or state highways. That causes difficulty travelling along local, with lots of quarry trucks a day travelling along local roads. A dedicated private road to a state highway, especially one as, and then being able to get on a transmission gully is a very positive aspect. Very good separation distances to adjacent neighbours, more than 400 metres to the closest and much further than that for most. Again, you probably would have seen that when you're out on site in terms of not only the visual enclosure, but to the extent you can see them, just the distance to the neighbours.
Yes, the material that we were given, the factual material, estimated the distances from properties to the quarry and to the access road. Now that information is available to any party that wants to see it, but I understand it was derived from the base material.
Thank you. A lack of visibility into the quarry's working areas, which from either proximate neighbours, long distance views or views from the park, which I've discussed about, ample room for water management and available areas for ecological enhancement. At 2.2, I do, and it is important to record this, both Fulton Hogan and Willowbank are conscious of the Pauatahanui Inlet and the fact that it is a tonga to Ngāti Toa, and I'd apologise, that should be a kiwa, not kiwi, and I made the mistake in the following paragraph as well. It's cut and paste for you. So if I can just correct that. But that is acknowledged, and the importance of reducing sediment in the inlet is acknowledged by both Willowbank and Fulton Hogan, and you'll see the conditions of consent specifically addressing that point. And I will come back to that because that's really a key issue when it comes to term. But that is acknowledged. The ecology and offset proposed in the Pig Gully area will actually help. And I want to return to this at the end, but in my submission, certainly from a water quality perspective, within 10 years, once the quarry is essentially largely up and running, in my submission, it's going to be an improvement. I mean, even leaving everything else aside, based on current operations, having a working quarry, it can deal with a lot of the water inside the quarry pit itself. The fill area, once that's up and finished, that's a very short-term project. And turning to fill site 2, so you were able to get to that area?
Yes.
Yeah, good. So fill site 2, some of it drains onto pasture. There's 2 sediment retention ponds. Some drains into pasture. One does drain into a stream that will eventually come down to Te Awa Kairangi, which again Fulton Hogan and Willowbank acknowledge as a tonga of Taranaki Whānui and the Port Nicholson Block Settlement Trust. So they understand the importance of water management, and they understand the importance of addressing sediment. That's what they do. That's a key part of quarrying, is dealing with water. Fulton Hogan and Willowbank also acknowledge that neighbours may be concerned about the prospect of a long-term quarry operation on the farm. Both companies have worked hard with their team to develop conditions that balance the need for a commercially viable operation that will meet the increasing need for the Wellington region while minimising effects on neighbours. But I do say this, it is inevitable that there will be some long-term change to the environment as a result of a long-term quarry. That is inevitable, and it's simply not practicable or feasible for quarrying activities to continually internalise all of their effects. I'm sure that the commissioners will be aware of was one of the Winstone cases, I think it was Papakura Quarry, was one of the very early reverse sensitivity cases that went to the Environment Court. And the court made the point there that quarry operators have an obligation to reasonably internalise their effects, i.e. it's not carte blanche, you can do whatever you like, but equally they acknowledge that you will be able to hear some noise. That doesn't mean it's an adverse noise effect just because you can hear it. So there needs to be some degree of reasonableness in terms of effects from an activity such as a quarry. So that deals, I think, with 2.14 as a summary. At 3, and I think it's worth just briefly talking about this, an unusual aspect of the hearing is there are two separate land use consent applications. And I need to explain that because it is unusual. And this is explained as follows. The existing resource consents for the quarry had 2 separate expiry dates. So the PCC land use consents expired 31 December 2020. The Greater Wellington consents expired a year later on 31 December 2021. Not entirely clear why there was a year's difference, except potentially for some completion works or rehab works. I'm not sure.
But they were both lodged at the same time?
Yeah, I think they were.
2018?
Yeah, so Greater Wellington may know, but anyway, whatever the reason, there was a year's difference. Because Willowbank wanted to continue to operate the quarry after the expiry of the consent, it was necessary to lodge a resource consent prior to the expiry of those existing consents. And at the time the land use consent was lodged, so this is June 2020, which needed to be at least 6 months before December 2020, Fulton Hogan and Willowbank had not finalised their long-term quarry plan. So they didn't want to lodge a regional consent until they'd got a proper application together. So the only option was to put in a land use application for a short term on the basis of preserving their rights to use the quarry, which I'll come back to shortly. So then by the time of the Greater Wellington resource consents a year later, Willowbank was in a position to finalise a long-term quarry plan, and so it lodged a long-term consent application for Greater Wellington, and then a short time later a long-term consent application for Porirua City. So those applications lodged in June 2021 and August 2021. Frustratingly, Willowbank cannot withdraw the short-term consent application. And the reason for that is if we withdraw the short-term consent application, you can't continue to do anything you might need to do at the quarry because you no longer have the protection of Section 124 of the Act. So as odd as it seems, we are rather stuck with it. The only option would have been to place the short-term application on hold, but there was a desire, I think, to just proceed with hearing it, which is fine. What we have proposed, though, because there's certainly no intention, and it would be a nonsense to have 2 resource consents to do the same thing, is if the long-term land use consent is granted and becomes effective, i.e. all appeals are resolved, etc., then we have proposed a condition which will require that short-term consent to be surrendered. So there won't be a situation where there'll be 2 overlapping consents. As a matter of law, that would happen anyway, but just for the sake of completeness, we just wanted to make that very clear.
Yes. Are there any other options available to the panel in that respect? And I'm thinking hypothetically here, if the panel found that a longer term duration was warranted and granted consent, could they by default decline the short-term application to deal with that matter at that time?
The difficulty is if you decline the short-term application, that would have to be appealed. Otherwise, none of the existing works, like no prep work or anything, could happen in the meantime. So, I mean, yeah.
Yes.
I mean, it would.
Okay.
Yeah, I mean I mean, we did have a think about different ways we could do it. The trouble is, I'm certainly not assuming the outcome of any particular process, and there's appeals to come as well. So I guess we just needed to make sure that the options are on the table. But we certainly didn't want to make things more complicated than they already were, and also there's no intention to exercise both, and it's no cunning plan to somehow get more or something. It's just a quirk of the law that we had to do it that way.
I think the panel understands that. We're just sort of testing what our options are on a without prejudice basis. And what you're saying at 3.6 is really the best solution in the event that there is a longer term consent granted, would be to surrender the short-term consent at the appropriate time.
Yeah, and it'd be at the date the consent was exercised, because at that point, I mean, the Sutton and Mole case, the Court of Appeal decision effectively confirmed that overlapping land use consents that are mutually incompatible will act to extinguish an earlier consent anyway. So it would do that as a matter of law. It just makes it tidier from an admin perspective.
Okay.
So, and then at 3.8, just so the experts weren't completely confused as to what they had to do in terms of the evidence, I did suggest that they focus their evidence on the long-term consent and then added in their evidence to the panel any particular issues that might be better or worse from a short-term perspective, just so that we didn't end up with two sets of evidence, which seemed a little unnecessary. So hopefully that's as clear as it can be. I want to briefly talk about some of the legal principles, and I guess to start off, risk and uncertainty have been used reasonably interchangeably, and just checking I'm not at risk of going into smoko break.
No, you're fine. We would certainly, as coffee aficionados, would certainly let you know.
Good. So starting then with risk, and I use risk and uncertainty interchangeably. It's often said that the RMA is not a no-effect statute, and that's that people mean that virtually every activity has some adverse effects, and society can't function without some activities that cause some effects. In a similar vein, people will say that the RMA is not a no-risk statute, and this recognises that any assessment of future effects will ultimately be subject to some uncertainty or risk that reality will not unfold exactly as predicted. And any people who have sat on hearing panels or considered future events understand that any element of prediction involves an element of uncertainty, and it's unavoidable. And the definition of effects certainly includes those potential effects, and the Act also specifically recognises a potential effect of low probability with a high potential impact, which is important to bear in mind. There was a range of cases on risk. The first one was one of the inevitable or flood of cell site cases, which were addressing the exposure of non-ionising radiation when that was a particular concern back in the day. And in Shirley Primary School decision, the court recorded actually an American Supreme Court precedent which noted perfect safety chimera regulation must not strangle human activity in the search for the impossible. And it was basically a recognition that you can regulate as much as you like, but there will always be some risk. There's some subsequent cases below. There's the contact energy case, which was the risk from subsidence caused by geothermal extraction for power generation. The Borstal, correctional Borstal cases within the community and the risk of essentially people escaping. The Longbow Kura case was the risk of sedimentation adjacent to a sensitive marine environment. So it's another example. And then a very recent example, which you might have seen in the paper, was the declining of the installation of a digital billboard on a 100k section of Hutt Road. And the concern there was distraction from people watching billboards at 100k zooming past, which you can sort of understand. I've distilled at 4.9 some general principles which largely have come from those cases. Firstly, fair can only be given weight if it's reasonably based on real risk. The RMA is not a no-risk statute. Discomfort by some individuals to the presence of an activity or facility does not in and of itself amount to an adverse effect on amenity values, and expert or other evidence of fears must be reasonably based on real risk if they are or where they are substantiated. At 4.10, I don't need to necessarily take you through the R.J. Davidson Family Trust case. That was it ended up going to the Court of Appeal. This was the High Court judgment on the, I want to say mussel, but I don't think it was. I think it might have been oyster. Anyway, It was in the Sounds, and it was the potential effect on king shag, New Zealand king shag.
Yes, Commissioner Burge and I sat through part of the proceedings on the Court of Appeal on that case. It was during the Greater Wellington Natural Resources Plan, and we needed a break. So we...
I would say nerd, but I won't.
What better way than to spend a morning?
I would say I had no choice.
Yes, well, yeah, it was. Well, that's good. So I guess that, and I mean that case is interesting because it was the first case, and certainly still the leading case on risk. It was the first case that really tried to sort of deal with this. How do you assess future adverse effects, and what's the standard of proof or onus of proof, and who has to prove what? And I guess, I mean, where the court got to, which wasn't overturned, with this aspect wasn't discussed in the Court of Appeal, and it broke it up into a number of steps. The first one was the assessment of existing factual situations, including assessment of actual effects, must be assessed on the balance of probabilities, and must also consider potential effects which cannot be assessed on the balance of probabilities. In terms of the potential effects, you have to assess existing facts on the balance of probabilities and consider whether any evidence is proved to that standard. The assessment of a potential effect then depends on an evaluation of all the evidence, but does not depend on proving that the potential effect will be more likely occur than not. So, and then this is really the key. The law requires the consent authority to be satisfied on the balance of probabilities that the risk of some future event occurring is likely, albeit that it is a low probability event. That's not the same thing as requiring that a future event is proved on the balance of probabilities. So it's probably best to illustrate that by way of an example. So if we take the silica issue, so the RCS issue, so I would say that you would apply that test in this way with on the balance of probabilities, will RCS be present? Is a question that you ask. Will it be present on the balance of probabilities from the rock? Question. Will it reach the nearby houses? Question. Will it reach nearby houses in sufficient quantities to cause an effect on the balance of probabilities? So that's a factual matter. Will it reach there? And you ask yourself that, and is that proven on the balance of probabilities? And then will it do so in sufficient quantities for a sufficient duration of time on the balance of probabilities? All of that leads to the future effect of potential carcinogenic or cancer concerns that people have raised. But it's those four elements that need to be assessed on the balance of probabilities. If those are not able to be assessed or proven on the balance of probabilities, then you're obliged to put the risk aside as negligible. So it's not proving whether or not you will get cancer on the balance of probabilities because of RCS. It's each of the individual elements that are necessary to get to that risk that need to be proved on the balance of probabilities. So that's the way that the High Court sort of separated out that and you apply the same analysis to a traffic. You know, yes, a truck pulling out turning left will require a car to slow down. On the balance of probabilities, are they likely to be going so fast with such little sight distance that they'll hit them at a sufficient speed to cause a serious accident or not? On the balance of probabilities.
What happens though where the factual is not clear cut? So and where there's dispute, like, I mean, I'm aware of the Shirley primary case. I was a witness in that case. And, you know, there was contested evidence about probability from epidemiologists. What does a panel do in that situation where the facts don't lead to a clear-cut answer on those 4 matters?
Well, that's why the court said you've got to assess those on the balance of probabilities, and you know, balance probabilities is more likely than not, but an effect is often a combination of a number of different things that have to happen, and each of those have to be assessed on the balance probability. So my suggestion is that for a risk like that, you work through what are the factual what needs to happen in fact for a certain effect to be able to occur, leaving aside the likelihood of it occurring. What are the type of facts that must arise in order for that effect to occur? So, and then what the court is saying is if those effects on the balance of probabilities may be likely to occur, then you can have regard to that effect at the end, even if it is of a low probability, or even if that's not necessarily proved on the balance probabilities. So that's the distinction the court was trying to make. But I agree. I mean, you know, there will be disputed elements into that. But I think that's why, for those key issues where people raise risk, it's to try and impose some rigour and not just saying, well, it's an adverse effect, you know, because someone might get cancer or it's carcinogenic, which is not to downplay the importance of that, but you need to sort of look behind that and say, well, what are the elements that might lead to that outcome? How likely is it? Mm-hmm. Or what are the individual elements? And work through that. And I think that came particularly home to me, I suppose, when you know, reading Mr. Noonan's rebuttal evidence, particularly on some of the on his response to some of the RCS issues raised, and in particular the assumption that had been made by Mr. Kirker that the concentration leaving the quarry is essentially the same as it arriving 400 and something metres later. Now, as a matter of fact, that doesn't happen because concentrations disperse over distance. So that would be an example where you'd sit there and say, well, the concentration leaving a quarry is not the same as it arriving 400 metres later. It must, as a matter of physics, be different.
Yes. So what I'm hearing from that, Mr. Madison, is that the panel needs to test the facts first, particularly where there's dispute, before we can turn our mind to the nature of effects and their likelihood.
Yeah. And so for the traffic safety risk, you'd sort of sit there and go, well, yes, a traffic safety risk on a state highway, particularly one like State Highway 58, is an important element, but it needs to be more than just saying, well, a risk of somebody dying is obviously an effect of high potential impact, but you can't just jump to there. You need to look at the facts that might lead up to that and ask yourself whether each of those are proved. And then ultimately, at the end of that process, of course, it's still a question of weight of all the effects for the panel. But it does help to have a framework for sort of helping work through that, particularly for some of those effects of high probability but low potential, high impact, low probability. That's a good segue into competing expert evidence, and you do have some competing expert evidence in this case. That's listed at 4.14, and I won't take you through that. 4.15, in terms of the weight to be given to any evidence, including expert evidence, and that's absolutely a matter for the commissioners to apply. I do think it is helpful to have a framework or some guidelines, I suppose, or rulers. One of them, and I've got some here, there's any number that you could use. I think one is the extent of an expert's recent experience directly relevant or experience with RMA processes more generally. In my submission, that's important because the expert evidence does need to be applied within an RMA framework. ultimately, and that's your job, but it does help if the expert does have that experience. Evidence that the expert has reviewed all the relevant material. The extent of independent analysis or research to support any conclusions reached. I mean, that's particularly important. For example, if someone does a desktop study versus somebody who'd, been on site for 6 months and done, it's not to say that the peer review or the desktop study is not evidence, it's just a question of weight. Whether the evidence is presented in an objective, impartial manner. It's particularly important for experts in my submission, if they do consider there are significant adverse effects, to think about what advice they might give the panel on conditions that might ameliorate those concerns, rather than just saying, no, it's all... and I'm not saying necessarily that was the case here, but it is important for experts to suggest that. The absence of any unsupported assertions and the absence of any flavour of advocacy, and just the code of conduct issue, which I think most experts in this case have confirmed their agreement to. At 4.17, and I will take this section as read, it is helpful, and Willowbank and Fulton Hogan acknowledged that lay submitters can provide very helpful evidence. It's their amenity, it's their environment, they live there, and that's certainly acknowledged. It's also useful in this case. Sometimes proposed quarries can come into people's neighbourhoods. Willowbank are part of the neighbourhood as well. They're on their farm, they live there, Paul lives there. So that's also useful in terms of getting that flavour. I've got the Harwood Gravels case there, which the High Court confirmed the importance of lay evidence. And then at 4.20, and I definitely won't go through this, but that's just a very useful section that I found from the Meridian case, both on the importance of expert evidence and I guess the privilege that experts are given in a hearing process to be able to offer an opinion to prove a fact, which is the essence of expert evidence, which is a privilege. Normally people can only give evidence on facts they know, as opposed to an expert that can provide an opinion on what they think a fact should be. Consent conditions, and I guess I put this section in because there's some of the disputes about the conditions, particularly around the noise and the vibration monitoring, is around the degree of conditions and whether all the conditions are necessary. In my submission, a condition should address an adverse effect identified by a planning document. An adverse effect is an effect that's not anticipated or permitted. It would be odd for a consent to attempt to restrict through a condition something that was otherwise permitted by a plan. I guess that might not be the case if there's some sort of synergistic effect, but it would be odd in my submission for a condition to limit a noise limit to 40 dB and the plan permitted level was 45 or 50. Would seem an odd outcome if the plan's been through a process and they've determined that an appropriate level is X and then a condition is imposed saying it should be less. It would seem to be an odd planning outcome. Unnecessary constraints and costs on resource users should be avoided. And I guess there it's, in a perfect world, everything would be monitored. The quarries would be surrounded by noise monitors and there'd be 20 of them. And at some point, there does need to be a degree of pragmatism and saying, okay, well, if we're going to measure noise, how do we measure in an efficient, sensible way? And then the last point, and this is, I suppose, consistent with broader themes in the RMA around efficiency, is, in my submission, a condition should be the least restrictive necessary to achieve the environmental outcome required. At 4.23, and I don't understand this to be necessarily disputed. Certainly, the Court of Appeal's decision in Barry remains being applied across New Zealand, and that's that a consent authority is entitled to assume that an applicant and its successors will act legally and adhere to conditions of consent. From a practical perspective, given the role of conditions in ameliorating effects, it would put hearing panels in a virtually impossible position to be able to assess the effects if you couldn't assume that an applicant would comply with the conditions. Because you'd be forever guessing will they or won't they, and the Act's quite clear that you need to have regard to the remedying or mitigating as imposed by conditions. So in my submission, it's not open to submitters to say, well, this might be okay if they comply with conditions, or it won't be okay because they won't comply with conditions. That's a compliance issue for the council. Turning then to question of term. So the starting point's section 113 of the Act, which you'll be familiar with, and that's that a decision must be in writing, and where a consent is granted for a shorter duration than requested, the reasons for deciding on a shorter term. So that's a specific requirement of section 113. So the difference here is 35 years for Willowbank, 10 years Greater Wellington. For ongoing quarry activities, including water permits, discharge permits associated. This issue, the issue of term, particularly for regional consents, has been much debated up and down New Zealand. These are some themes that have come out of the various decisions. A decision on what's an appropriate term must be made for the purpose of the RMA, in other words, to promote sustainable management. One commissioner, one panel recently phrased it as there is no resource management reason for giving a shorter term, was the way they'd phrased it after working through the effects. So it's the same question, it's just phrased slightly differently. Assessing an appropriate term of consent is not a process of calculation but judgment. Uncertainty for an application of a short term and applicants need to protect investment for as much security as is consistent with sustainable management, indicate a longer term. Contrary, I think, to a suggestion in a Greater Wellington report, the investment that is made is a relevant factor for term, and the courts have confirmed that, and in fact the Act now confirms that for the renewals. So any replacement resource consent, the council have to have regard to the level of investment already made. The life expectancy of the asset for which conditions are sought, and the decision maker must consider the lack of efficiency in requiring consent holders to submit new applications. And there's the older case of Brightwood and Southern Regional Council. In that case, 15 years have been suggested by council, 25 years was sought, and ultimately the court went with 25 years. The planning tribunal, the medical officer of health case was a much older case. Some of the earlier cases, I guess, focused on the ability to use the Section 128 review process. More later cases have focused on what are the resource management reasons for a shorter term, efficiency and effectiveness, and investment, and the need for investment certainty seem to be more the recent themes. I was interested to see the quality planning website, often visited for answers. And it recognises there, which I think is a fair point, is that it says that shorter term conditions are often imposed to deal with uncertainty. And I will come back to that question later. This is not a case where I say there is uncertainty as to effects. And then the quality planning, the website actually says a condition limiting duration of consent may not be the best way to address uncertainty. Assuming there is no further information to reduce the uncertainties that are not so significant, the consent application should be declined. A range of adaptive management monitoring, reporting and review may at times be more appropriate. And then this was the point I made. A replacement consent application is not considered on exactly the same basis. The investment and development involving an application for a replacement must be given specific regard under 104.2a. So I guess what the website author was saying there, which was a fair point. If you have repeated short-term consents, the applicant would be entitled to turn up and say, well, I've got all this investment, and you have to have regard to that as well, which makes it more likely you'd get a replacement consent anyway because of that investment. I've got the Genesis Energy case there. That's the High Court decision. The Environment Court issued a 10-year term because Ngāti Rangi in that case had opposed the application and essentially wanted time to talk. The phrase used in the Environment Court case was, I'm going to grant a 10-year term to allow a meeting of the minds. The High Court didn't think that 10 years would necessarily provide that opportunity, and the High Court didn't agree that that was an appropriate rationale to say that's why we're going to impose a shorter term consent. And the court also specifically noted there the powers of the review condition to check and make sure that the effects can be managed over the longer term, and essentially noted that limiting the resource consents to 10 years is indeed to wield a blunt instrument. I'll come back to the question of term just briefly. Just speaking to the non-complying activities and discretionary, and I guess in answer to your question, Commissioner, I'm not aware of needing to bundle resource consents between district and regional plans. I think it becomes particularly problematic where you have quite a different objective and policy framework. And it would be odd because if you bundled it, if you had to bundle it, you could only assess the objectives and policies of the plan under each plan. You couldn't assess them across plans, which again brings me back to it seems very little point in bundling between plans. So I absolutely agree that the regional consents are bundled, for better or worse, as a non-complying activity. But I certainly don't see the need. Actually, I don't think it would matter because I think this seems it's fairly clear from as my reading of the 42A planning report that it's consistent or certainly not contrary to the district objectives and policies anyway. So even if you were to bundle and assess it collectively as a non-complying activity, it would certainly meet the objective and policies threshold. And of course, as you're aware, for the Greater Wellington, you only need to either meet no more than minor adverse effects or not contrary to the objectives and policies. And in my submission, there's certainly no suggestion that overall it's contrary to the objectives and policies. And I deliberately didn't, and I can return to it and reply if we need to. The case law is very clear that the contrary to objectives and policies it's 2 points. One, it does not include the MPSFM. That is not a matter for Section 104D. It's only the regional plan, and it does not include the regional policy statement for a 104D test. It's only the regional plan. So while MPSFM policies are relevant for a broader 104 assessment, they're not relevant for a 104D assessment.
And that's directly through the wording of 104D.
The plan or proposed plan.
Or proposed plan. So that does include higher order documents such as the RPS or a national policy statement.
Yeah.
What would you say in terms of, those higher order documents are supposed to be given effect to through the lower order plans. Quite often they're out of sync. What would you say in that case?
Yeah, well, we're all having this issue, especially with freshwater documents up and down New Zealand at the moment that seem to be being put out. Well, I'll take the opportunity to make a comment about the MPSFM 2020. The objectives and policies are relevant matters under 104. You don't have to give effect to them under 104, and they're not relevant for a 104D. They're simply a matter to be had regard to. the other point about the MPCFM, and I acknowledge that it says that the objectives and policies are relevant to all aspects of resource management, so I accept they're relevant to resource consents. But a number of those objectives and policies relate to plan-making processes. They're designed to direct regional plan-making processes, particularly when you talk about defining Te Mana Rota Wai, and the implementation section of the MPCFM specifically has a process for defining what Te Mana Rota Wai means in any particular catchment. That has not yet happened here. That is due to, I think, come out mid-23 or mid-next year. Yes. So that has not yet happened. And so obviously Te Mana Rota Wai as a single objective has a degree of prioritisation, but exactly how that is intended to be defined in any of the particular catchments, and the two catchments we're talking about here, has not yet happened. So I do have some concern with submissions or suggestions that things are contrary to Te Mana Rota Wai when that process hasn't actually happened yet, and in circumstances where it's very hard to put any sort of flesh on the bone of something that says prioritise the health of the water first. I mean, that must mean something other than you cannot divert any stream ever or discharge anything into any stream ever. I mean, that just simply can't be what that means. And that's why it's so important to go through that process of defining what it is in a particular catchment, having regard to the mana whenua and community values of that catchment. So, so for the 104D test, just regional plan, objectives and policies for the assessment, and likewise for the district plan. And then in terms of the broader 104 assessments or 104.1B assessments, they are one matter to be had regard to, and that's where they start and finish.
Yes. And does that 104.1B apply to the regional policy statement also?
Yeah, it'll be a list of plans, policy statements, and other documents. I will. Are you able to? Can we stop at 10:45 and then I'll get through these?
I want to get through this before.
Yeah, good. Okay. So in terms of look, in my submission, and I can address it and reply if I need to, but in my submission, there's nothing in the 104D threshold test that I think would be any barrier, either on an effects perspective or on an objective and policy perspective. And then the last thing about the objectives and policies is they do need to be assessed as a whole. So you can't fail a 104D objective and policy test if you're contrary to a single objective, unless in the very rare circumstance where you might be doing something in a very defined catchment with a very defined objective and policy and you're directly contrary to that, maybe, but that would be a clear exception. And the case law has been very clear. You need to have regard to all objectives and policies and assess them as a whole to assess that degree of contrariness or turning your face from it. And ultimately what is proposed here is a quarry in a rural zone. Like it's hard to think of a zone that's more appropriate than a rural zone. In fact, it probably is the zone that you'd want a quarry in. The effects assessment at 5.7, I've dealt with those there. I don't think there's much debate about those. I've talked about the positive effects. Turning then to the traffic management and safety, and just noting there, Willowbank had originally proposed a maximum number of 45 loaded trucks per hour, so that's 90 movements during the day. That's now, for the purpose of this hearing, is being reduced to 60, so that's 30 loaded. There's often a confusion about movements and numbers, and so just to be clear, so it's 30 loaded trucks out, 60 movements. And I think I'll leave any further comments about that traffic until the experts have had a chance to report back. I think it's fair to say that I think potentially with the exception of Mr. Wanty, the other traffic engineers seem very close. I think there's some minor stuff that no doubt they'll report back on, but from my reading of the various rebuttal statements, they seem very close. The substantive matter which Mr. Wanty had wanted was the acceleration lane. And just to reiterate, Waka Kotahi said they did not want an acceleration lane, and Waka Kotahi run the state highway, and you can't do anything on a state highway without Waka Kotahi's approval. So, you could understand why Willowbank and Fulton Hogan, when Waka Kotahi said, we're not going to let you put a acceleration lane on, they'll go, okay, there's no point us agreeing to a consent condition because we won't be able to build it because you won't give us authority to be able to do it. And as noted, they have had experience elsewhere around New Zealand and decided that from a traffic safety issue, it's better not to have one than to have one.
Yes. Mr. Matheson, when you refer to acceleration lane, are you referring to both acceleration and decelerate?
Yeah. So in contrary to Mr. Wanty's sort of the theme of the evidence, and in fact almost an express statement, this isn't sort of some conspiracy. Literally, it was Waka Kotahi who were very clear about their expectations, and as a sensible consent applicant wanting to do stuff on Waka Kotahi's state highway, they're in the best position to say what works for them.
Yes, and we're hearing from them on from Mr. Chow and Ms. Jenkins, 9 a.m. on Wednesday. So we'll be able to put that proposition to them.
On the noise and vibration, again, and there's some small remaining level of debate on the noise. The vibration, the number of blasts that are proposed are very limited. And there's proposal for notice, etc. And the limits that are proposed, aiming for 3 and a limit of 5, is very conservative in my submission. To the extent neighbours or residents say that sort of prior blasting, etc., caused effects or didn't cause effects, there is a difficulty in proof in that respect. What do you do? Going forward, the applicant in this case is proposing monitoring, so there will be a clear assessment of what the actual effects are. There's one debate in terms of whether the roving monitor, I think, should be permanent or not. That's just a matter of cost efficiency, and if it's not if it's not providing useful information, it's just additional cost. Why have it? So that would be my question. The hours of operation, I do want to briefly speak to that. There seems to be an acknowledgement that at rush hour there is a lot of traffic on the roads, and a lot of aggregate hungry activities do benefit from getting aggregate early in the morning so they can get started with various things. And the concern is, and the benefit of having quarries opening before 7 is trucks can get in, some get loaded up and get out before some of the worst of the traffic, and then come back again once they've unloaded. So, this is about actually trying to operate on a state highway outside of peak hours, or getting some early work underway. From a noise perspective, Ms. Wilkinen will be able to address that. Yes, there will be vehicles on the accessway. Yes, it will be before 7 o'clock if that's granted. That is for the very good reason to be able to get trucks out and using that time efficiently. There is a limit to the number of vehicles able to use that in that period, so it's not unlimited. And again, I do stress this point, and it's the same with the 30 per hour loaded. That's a maximum. People don't take aggregate away from the quarry unless there's somewhere to sell it. So don't just randomly run trucks up and down the road. So there'll only be up to 30 a maximum when there's demand for it. And if there's a demand for it, then presumably it's doing some good somewhere and doing something. So it is an up to. It's not that there will be 30 trucks every hour, or 60 every hour, every day, all year. And likewise for that 6 a.m. to 7 a.m. It'll only be if there's the demand for it. And then the second area of dispute is the nighttime operations. So this is between 6 p.m. and 10 p.m. There's a suggestion about whether it should be 10 nights or 60 nights. The applicant has asked for 60 nights per year, per calendar year maximum. So again, some years there might not be any. If there was a large evening job or a job that requires aggregate outside of main hours, and it might be a road job, it might be some works that you don't want to do during rush hour and you want to start it at 7 o'clock at night and do 3 hours or something before, or get the aggregate there. So the proposal is to have 60 nights per year maximum, and that's 7 or 6 till 10. And again, that's for the very good reason that it gets the aggregate out where it needs to, and it will let the jobs be finished sooner, and that's better than stretching it out. Acknowledging that there will be, for those periods of time, there will be some additional movements on the accessway. But both Ms Wilkinnen's evidence is both the morning and the evening periods will comply with the noise limits. And again, it's not every year or all day, all night, every day. It's a maximum of 60 per year. So it's 300 nights per year when there's nothing. Maximum. The landscape and visual, I don't need to talk too much about that. I think that's largely been addressed. As I said, there's one issue about whether the top of the noise, the mitigation bund should be planted or not. Dust effects, I think I've largely dealt with. The ecology, again, I think we'll see the evidence from Dr. Mulling on that. There is quite an extensive offset proposal proposed as part of this, which will be discussed, and I think that will have some really great outcomes long term, and that should be encouraged. I want to briefly talk about the compliance bond. Dr. Sturman recommended a compliance bond. I read the papers she referred to. I think a lot of the examples that were given were subdivisions. And the reason I say that is that there was a lot of talk about consent notices, and there was a lot of talk about, which obviously are imposed on land uses after subdivision, because the subdivision consent disappears, so you end up with consent notices. It wasn't particularly clear, but I think a lot of those cases where she said that that there was a risk or non-compliance with future offsetting is for subdivision proposals where the offsetting obligation was ongoing and it relied on consent notices to enforce. And in my submission, that's quite different from a situation like this where you have an ongoing operation with a quarry applicant with the ability to wield a very big stick, which is if you don't plant up that area and maintain it, we will stop the quarry operating. So in circumstances where there is the ability to effectively stop works, there is, in my submission, no need for a compliance bond, because there is every avenue available for the council to actually ensure that any offsetting obligation is done. That's very different from going to a landowner who purchased a bit of land and said, well, 4 years ago somebody was meant to have planted this and didn't. And I can understand that's more of a compliance risk. So I would ask just to focus on what's the actual risk we're talking about here, and does the nature of the activity demand it. And the only other point, often people don't understand what a compliance bond is, or just think it's some money that sits in the bank account of Greater Wellington and can be used whenever. There is a formal bond calling process that needs to happen. It's a formal instrument that's registered. There needs to be a chance to fix it before you call on the bond. It's not just a random chunk of money sitting around. Quickly on the term, I've set that out in 6.27. This is really the just a summary of the reasons from the Greater Wellington's report. Mm-hmm. And then at 6.29, I'll briefly go through my response, and again can deal with this and reply if I need to. Firstly, I will. Sorry, I just got a correction to make. 6.28. That second paragraph, it finishes at mid-20. That should just be 2023. The end just fell off. At 6.29, in terms then of the reasons in the case law, the plan change give effect to the NPCFM is expected to be lodged about mid-2023. In my submission, that's not a valid reason for a 10-year consent. The proposed consent conditions include a specific review condition to address changes in regional plans. So we've specifically volunteered one. However, there's one in the RMA anyway, and it's 128 anyway, but we've proposed a specific one. Assuming that the NPSFM plan change proposed significant changes in sediment load, and this came into force in 2025, it's likely that it would be inappropriate to wait 7 or 8 years for the consent to expire before addressing the sediment issue. In other words, if there was a sediment issue that came in 2025, Greater Wellington's not going to wait 8 years, i.e. the expiry of this 10-year consent, before they reviewed the consent. Or they shouldn't. So, and then on the basis if they do issue a review prior to that 10-year period, then there might be a review and then 3 years later or 2 years later the consent expires. So, in my submission, a better approach would be to have a full term of consent and allowing that to review to occur when it needs to occur. That outcome would be administratively efficient. And that review would allow an assessment to be made against the provisions as they are then. The Whaitua process and the community expectations, I'm not aware of any case law that supports the proposition that community expectations are valid or appropriate resource management reason to impose a shorter term. None of the cases that I've seen refer to that. Any outcome of the Whaitua process can and should be addressed through a review. In terms of the precautionary approach and the sensitivity of the receiving environment, if a receiving environment is particularly sensitive, that might warrant a shorter term. In this case, the quarrying activity has been occurring and the effects of quarrying on downstream water bodies, particularly as regards the discharge of sediment, are well understood. The extent there are concerns about sediment being discharged, and this can be addressed by way of proposed adaptive management sediment conditions. I guess just pausing there, it is sometimes different if you're having a brand new activity that no one's ever done before in a sensitive environment. And I'm thinking in this case of the wave turbines in the Kaipara Harbour, for example. Brand new activity, never been done before, unsure of effects, very sensitive receiving environment. You might sit there and say, well, that might justify a shorter term to see what the effects are. That's not to denigrate from the importance of the Pauatanui Inlet at all, or the importance of it. It's simply to say, for a quarrying activity, we know what the effects are and we can manage those. In other words, what will the benefit of a review condition actually be, of a new consent actually be over a review condition? Willowbank and Fulton Hogan respect Ngāti Toa's statement recorded in the 42A report that they oppose a 35-year term. It's not possible from the information I have to ascertain why a 10-year consent is acceptable from a cultural perspective and a longer period is not. From the description, it appears to be an in-principle position taken. The case law does not support such in-principle positions as being a valid resource management reason. While a reporting officer refers to a shorter term, ensuring consistency with relevant objectives and policies of the PNRP as they relate to mana whenua, there's no analysis of which objectives and policies these are or why that might be the case. And I guess my only point there is, say, if there is such an objective or policy, then it would be good to see that, because I couldn't find it and it wasn't clear to me. I won't go through the amendments to the consent conditions. Those are there and will be discussed in the evidence. As noted, there is a hearing version of consent conditions, which hopefully the panel do have and are aware of, and they should use that version rather than earlier versions. So that has hearing conditions set 12 August 2022 at the start. So if you do have a set that you might be looking at or marking up, then I'd encourage you to use that version.
So that's a version that the applicants...
yeah, that was sent last Friday. Friday.
Is that attached to Mr. Baker's evidence.
It was sent with it. I don't know if it was attached. It was part of your bundle of material.
Yeah.
I'm sure you'll be able to. Anyway, I just wanted to draw it to your attention just in case you were confused, because there are multiple versions of conditions lurking around.
Yes, it does raise the issue, Mr. Matheson, and I'll point this out to everyone, particularly the traffic witnesses. If there are changes to conditions, and we really need to have a common set of base documents to work from. Now, you're suggesting it should be the 12th of August set. I imagine, Ms. Williams, you've got your own set too. So I'm going to...
Well, just to be clear, this marks up the 42A reports version.
Okay.
So the updates made by the applicant, so they're based on the Greater Wellington or the PCC. The updates made in evidence marked on blue, and updates made in most recent changes are in green.
In green.
So everyone's comments should be in there. Okay. So I'm reasonably confident that you can safely use this, and if you want to see what was originally proposed, you just look at what struck out, and that was what was originally proposed. So anyway, the council officers can have a talk about that. And
yes, Ms. Matheson, just if you can just pause. Ms. Williams, Ms. Walker, are you comfortable with using the 12th of August document, bearing in mind that you can, through comment boxes, indicate where you disagree with presumably the green document, the green markups?
Yes, look, I think the track change version will make that acceptable. I think it'll be quite clear to all parties where there's any remaining areas of disagreement.
Yes, and that could be the basis for expressing that level of disagreement, where a comment box merely indicates it's a matter of disagreement and a separate document expands on that. Ms. Walker, are you comfortable with that approach?
I'm comfortable with the same route for the citizens, Karen.
Thank you. Matheson, was there anything more?
Thank you. Coffee time, I think.
Well, it is. We will take the coffee. I know I've got a handful of questions arising that will be of relevance to some of your witnesses, particularly Mr. Baker. And I'm sure my colleagues have got some. So we'll come back at 11:05, and we'll put those questions to you, and then we'll hear from Mr. Nation and Mr. Walsh.
Yeah, I might. I will ask Mr. Walsh to go first. He's got a project description, and then if there's any other questions about his evidence, and then probably Mr. Nation. So, thank you.
Fine. See you all back at 11:05. Thank you. welcome back everybody. Sorry for the slight delay, just a couple of administrative matters that we had to deal with. Thank you, Mr Matheson. We're going to go to some questions of clarification to you from a legal perspective, and in doing so we're probably going to raise some matters that some of your witnesses will want to comment on, so we'll just highlight those at this point too, and the same will apply to you, Ms Walker, and you, Ms Williams. And we tend to just feed out those little tidbits along the way so that you're well primed to respond when your turn comes. So we'll start with Commissioner Burge, I think.
Thank you. I just had a couple of clarifications, really, and mainly it's perhaps to do with your language too. So just referring to 210 of your legal submissions, you say in your submission, the measures proposed in the consent conditions will maintain the long-term water quality and will enhance the ecology of the site, especially Pig Gully. So later on you talked about policies and objectives and the overall relevancy and overall balancing effect that you need to give. And I just wanted to flag there, the policy direction for a lot of freshwater policies is to maintain and where degraded, enhance. So I don't sort of see that flavour coming through.
And I guess that's what it would be good to talk to the witnesses. I mean, my expectation is that overall, from a site perspective, it would actually be improved. But I think we need to hear from the specific witnesses on that. I mean, given what's proposed and given my experience elsewhere with, riparian planting and planting up areas, it does seem to ultimately end up in better water quality. So it would surprise me if at the end of doing everything we're doing, it hasn't improved, but I think the witnesses should address you on that, because I do understand the point. Because I agree that the inlet is degraded, and where it's possible to do so within, to the extent this site can assist that, then it should, and I accept that.
So your language about maintaining, I'm not sure that assists in improving the sensitive receiving environment.
Yeah, I understand that.
So, some of those questions are directed at your witnesses, but it's coming through in your legal submissions, so we're talking there. And I guess following on from that, does an overall net gain predicted in the 10 years from biodiversity offsetting constitute enhancement? So that's something else that your experts might want to think about.
Sorry, was the question within 10 years or so?
Well, the prediction is in 10 years there will be a net gain. So what I'm asking is that enhancement, or is that that's net gain as in terms of offsetting, as in terms of an effect, isn't it? So is that enhancement in the true sense, or is it offsetting an effect?
Yeah. No, well, let's. I think we hear from the ecologists. I mean, it's quite a rabbit hole to get down, the difference between offsetting, compensation, and mitigation. But certainly the proposals that have been put forward, my submission will enhance the ecology, and how you slice and dice that from an environmental perspective, I guess the position is it will be better. The ecologists will hear that.
Yes, so just on that, Ms Burge, I guess we're trying to helpfully signal for is it Dr Mulling, and I guess also for Mr Baker too, ultimately, in terms of the condition framework. Mr Baker. Sorry.
No, that's all right. Just my other one I just wanted to talk about. At 422, you sort of, just one moment while I get there myself. So you're talking about conditions not going beyond what the plan says. So you're saying that the plans are the baseline, if you like, for a starting point, and conditions can't be more restrictive than the standards that are directed in the plan. Is that what you're saying?
Yeah. Well, from a I mean, if your assessment has to be against, the rules in the plan, then it's not to say that you only talk about an effect of 1 decibel. You still look at the total noise, but I guess in terms of weighing assessing the degree of effect or the degree of impact, I think it is important to have regard to that baseline, and if you call it a permitted baseline or a rule in a plan or whatever. It does get more complicated when you get to amenity effects, because amenities are a human reaction to a range of different things. So I accept that becomes more difficult when it comes to amenity, but I think you still have to inform an assessment of degree of effect against what the plan anticipates.
So if the plan doesn't have standards and you rely on industry standards or best practice, there I'm assuming you would say that there is a degree of movement, either up or down, should I say?
Well, if we're talking about dust, I'm not sure we're talking about dust, but if we're talking about dust, then the difficulty with dust is that it's a more qualitative standard in terms of a permitted activity level. So then it does become more difficult when there's no quantitative standard. But I guess in those circumstances, again, it's, what's the existing environment, in fact, as opposed to what the plan says it is, and then what will the impact of this activity be? So if the plan doesn't have standards, I mean, the position at law is if the plan doesn't restrict something, then you can do it, of course. Most things will have standards, even if they're qualitative standards. Certainly dust, noise, vibration.
Yeah, I was thinking of vibration because there aren't any standards in the plan for that, but there's industry guidance, if you like.
Yeah.
That's all I had at the moment. Thank you.
Just before I go to Commissioner Mark Brown, just on your last comment regarding the more qualitative standards relating to dust, are you referring to the no objectionable beyond the boundary?
Well, that's a normal permitted activity standard, which is a little fraught in itself, but rather unavoidable given the nature of dust. It's just hard to get a quantitative standard for dust.
It's got its genesis in the Act too, doesn't it? Yes. Okay, thank you. Nigel?
Mr Matheson, just got one question, and that's on the compliance bond. So my experience of bonds is that typically they'd be required for the likes of a landfill, where they would be triggered in the event of the operator or the consent holder sort of ceasing operations due to some commercial problems and is leaving the site, which then requires the regional council or someone else to come in and make it good and avoid the effects. So you're saying, it seems to me what you're saying with this situation is that the scale of the effects of the proposed quarry are not sufficiently significant that it's required for that sort of situation.
Yeah, well, I suppose two things. That's right, and normally in the situation of the concern, and whether it's a landfill or a tailings dam or something like that, it's a circumstance where the effect is, the cost is such that the consent holder would walk away from any economic value in the consent at all and just disappear and be wound up or whatever. For an ongoing operation, so that's more a sort of an end-use sort of compliance bond, rehab type bond, as opposed to a compliance bond, which is comply with your ongoing conditions of consent. It seems a much more practical and feasible way to address that is by simply saying you have to shut the quarry, because every day you can't quarry is costing you money. So from a compliance perspective, that's a much better stick. The point I was making with some of the research that, well, certainly the research that was referred to in those consent conditions seemed to be about subdivision consents that had a requirement to do planting and then maintain it over a period of time that was then enforced through a consent notice on an individual lot owner who may have only just moved in there. It's probably never done any weeding in their life.
I understood that difference. I guess it was, and in terms of the bond, it's only really been raised to my knowledge and to your knowledge perhaps by Dr. Sternman. Hasn't been raised anywhere else.
No,
and in your view, it's not needed.
No,
just generally, it's not needed.
That's right. There's more effective measures to ensure compliance.
Yeah. Okay. Thanks. That's all I have.
If I could just ask a question on that last matter, Mr. Matheson. We understand your position on the first reason for a bond and compliance with conditions, and you're saying enforcement action is the remedy there. What do you say about the latter matter that was just discussed about the risk of flight or the risk of closure or bankruptcy or whatever in terms of ensuring rehabilitation occurs? You've been largely silent on that matter.
Yeah, well, I think I'm just trying to think back. I'm not sure. I mean, if there was to be a bond, then it would have to be at the rehabilitation stage. So I suppose the difficulty with some, but then in deciding whether that's necessary, I think you also need to look at the nature of the consent holder, and the nature of the operations, and what might be required in terms of setting that bond. So it all sort of needs to be reasonable as well. I'm just trying to think whether the last couple of quarry consents that I've done had a bond, and I don't think they did. Partly it's because there's economic value in a quarry while it's operating, and if it gets to the point of being shut down, then there's a rehabilitation plan which you need to go and get signed off from the council and discuss what you're going to do. So...
is there an element of the first issue there in terms of enforcement? If there is a rehabilitation plan, does it then become an abatement or enforcement matter through the courts?
Well, what if it didn't get complied with?
Yes.
And then, so, I mean, that would be the only circumstance. And then ultimately the landowner, is the one responsible ultimately if it's on their land.
Okay.
And a land use consent will run with the land. So unless they actually sell the land or somehow dispose of it, it would ultimately be able to be enforced against the landowner.
Well, I guess where we're at is one submitter has suggested it, Dr. Sturman's. As far as I'm aware, neither Ms. Walker nor Ms. Williams have suggested it as a condition of consent. Well, that's correct. It would be useful to complete the loop for both of you to comment on that in your reply at the time as to the need, both in terms of those two elements, compliance with conditions and the operator going out of business and rehabilitation, how that might be enforced, and just bearing in mind Mr. Matheson's comments about the need to look at the consent holder and the operation. Thank you, Mr. Matheson. Nigel, just before I come to myself, I'm conscious that there was a matter of clarification in relation to finished ground levels that you wanted to just signal at this point and get some advice later on.
Well, yes, that's right. Thanks. So what I was thinking, Mr. Matheson, is that to signal to you that there seems to me a bit of uncertainty, well, there is uncertainty in my mind about the finished levels in the quarry pit. And I'll perhaps just go over a couple of reasons for that uncertainty in my mind. And it's not a criticism. I mean, the whole thing's been moving in terms of the planning and that sort of thing, but just in my mind, there's a bit of an unanswered question. So if we start with the erosion sediment control plan in September 21, talked about the the level of the quarry going down to RL 182. And in the RSC geotechnical report, it showed a whole lot of cross sections of the pit going down to RL 180. But the latest information that I can see is the Erosion and Sediment Control Plan of July 2022. Stage 4 just talks about being below RL 242. And the reason that I'm raising this is to do with groundwater, effects on groundwater. If the pumping of the pit does go below adjacent ground levels, then in my view there needs to be some assessment of effects on groundwater. There is information elsewhere that says that the groundwater level out by the road was at a certain RL and that the pit is not expected to go below that. So I think it's just wanting a bit more. I'm not sure who can address that, but I'd just like some more information on what, if there is going to be a certain minimum level, if you like, maximum hole depth, but minimum RL, what that is. I think that needs to be perhaps, set out so we know what we're talking about. And it's also said that there is a condition that if groundwater is encountered, then some action will be taken. That's the groundwater GWRC consent 20, which seems a bit vague to me. So I'm just wanting some more information from the relevant expert or from someone about that.
Thank you. We will. It's on our list.
Who might that be, Mr. Matheson? Mr. Pope might have a role there, but either Mr. Nation or Mr. Walsh?
Mr. Walsh, or we will find somebody to address it if we need to. But
yes, because there's you're not leading a geotech witness, are you?
No, well, those matters are largely agreed. Yeah. But in terms of design, pit design, Mr. Walsh would be able to talk to that.
And obviously, Ms. Walker, there's something there for you too. I guess there's two issues. One is, does it raise the need for any new consents through the intersection of excavation with groundwater? And if so, how do we deal with that? And is it something that you've turned your mind to, or your witnesses, in terms of effects?
Just to be clear, we haven't applied for a groundwater diversion.
You haven't?
No.
And that's the very reason that I've raised.
No, it's a fair question, but we haven't applied for it. So if we did need it, then we would have to apply for it at some point. But we will confirm depths.
Yeah, I'm just trying to ascertain. And maybe you could work with Ms. Walker on that too, so that just for expediency. Thank you. Okay, is that all, Nigel?
Yes, thanks.
Yeah. I'm not going to prolong this. Just 6 quick matters from me, Mr. Matheson. Firstly, I understand you've received those 2 documents, the letter from Ngāti Toa and the email from the Friends.
Yes, and I'll need to have a talk, and we'll come back to you on that.
Good. Thank you. Thank you for your information on bundling. What I took from what you said is that it's not an issue that it's not appropriate and not necessary to bundle between the 2 jurisdictions, Greater Wellington and PCC. Within the separate components, it's not an issue for PCC because it's a DA, doesn't go any further, and it's appropriate within the bundling, and I think that the more stringent one is the non-complying activity that takes us to that. Just, Mr. Baker, do you happen to know what rule breach takes us to non-complying activity on the GW set?
Yes, it relates to wetlands, Rule 108, I think.
Rule 108, thank you. Okay, thank you for that. We'll cover the ground level matter. In the final 3 matters, Mr. Matheson, one is the quarry supply issue, and then I wanted to just a couple of questions on duration and hours of operation. So going to the quarry supply matter, just wanted to get your clarification of your 2.5 in the last sentence. and you talk about the acute shortage of quarries in the Wellington region. Are you talking about the shortage of quarries or the shortage of aggregate per se?
Well, it's aggregate, but I'm also not sure. I think Horokiwi might have just been extended, maybe.
Right.
Anyway, Mr. Walsh can speak to that. It's an issue, given the nature of aggregate, it's an issue of where it is as well as how many there are, because it's a location, it's very location specific.
Yes. But at the end of the day, it goes to the total supply of that's the key thing. And if that's delivered by 3 or 4 as opposed to 10, I guess for the aggregate industry, apart from the locational aspect, doesn't really matter, does it?
Well, it doesn't. Although, as the quarries in Auckland have found, for various reasons, they tend to be consolidating because of the cost of operating the quarries and managing effects. And it is harder for smaller quarry operators to comply with the degree of effects.
Yes.
Let alone smaller quarry operators trying to apply for consent in this day and age.
Yep, understood. Just on that same theme, and this might be something for Mr. Baker when he presents later, but I'll ask you. You talked in the very opening about the policy guidance in the RPS and that quarries are recognised. Is that as a regionally significant infrastructure, or what's that recognition that you're referring to?
I can get the objective.
So it's at an objective level.
Yeah, but quarries are generally not regionally significant infrastructure. They tend to be regionally significant issues in terms of availability of aggregate. Yeah. It's I think GWRC will be able to. I think it's something around. Is it 30 objective? Anyway, there's an objective in there.
Thank you. Good to know. I'm still on this supply issue and the importance of quarries. Is there any guidance, at least at the regional level, as to a preference for the source of aggregate? And I'm thinking there of the difference between land-based extraction and river-based extraction for aggregate. Are you aware of any preference being signalled at least the regional level or any other level?
Well, I can now take you to so the regional policy statement operative. So section 3.11b minerals.
Yes.
Recognises that as Wellington's region population continues to expand, the demand for aggregate will increase and sustained supply of aggregate will be needed to provide for building, construction and roading projects. Recognises that mineral resources are fixed location, unevenly distributed and finite. Objective 31, my memory's still roughly there, recognises there are benefits to allowing extraction and processing by extractive industries as close as possible to the location of use as the final product to avoid distributing adverse effects across a greater area than necessary to meet the need for those resources, which was really the point that I was making about location. And then policy 60 recognises that for a resource consent application proposing to utilise the region's mineral resources, particular regard should be given to the socio-economic and environmental benefits from utilising those mineral resources within the region.
So I missed that 60?
60, yeah. So explanation 3.11b, objective 31 and policy 60.
Thank you. None of those touch directly on the issue of one source, river source versus land-based source, other than the proximity argument. Is that a fair comment?
Yeah, that's probably fair. I mean, I'm not sure what river sources are available in this area, and but yeah, I mean, they tends to be aggregate in all the wrong places at the wrong time, and rivers, as far as I can tell.
just so you know, the reason I've asked that is I'm aware of other jurisdictions, particularly Canterbury, where such a preference is expressed through both the regional and district regimes, particularly Christchurch City, and that came out of after the 2011 earthquake, where there was a severe shortage of aggregate for the rebuild. So whether that policy preference has survived in latter plans past the replacement district plan, I'm not sure, but Mr. Baker, if you could perhaps have a look at that and give us some comfort on that or a response.
Yeah, can do. I can speak to that tomorrow.
Thank you. Appreciate it. Okay, now that leaves me the two issues of duration and hours of operation. With the duration, you made a comment right near the beginning of your presentation about the term being a reflection of ecological matters, and I wondered if you could just elaborate on that.
Oh, well, I guess it really came down to the point from the Commissioner about sort of benefits and when they would accrue. And I guess the point I was trying to make is that, you know, the quid pro quo of granting a longer term consent is you have a longer term of ecological benefits being able to accrue as well. I mean, it takes time to plant up areas and time for canopy closure to occur and time for the benefits to accrue. And so I guess the point I was trying to make there is that actually, if you're talking about long-term consent processes, and that also comes with long-term benefits that come from those processes as well.
Yes.
So that was really the point I was making.
I would understand that if the condition framework affecting offsetting required, you know, certain actions to occur in year 25, but aren't those actions required to occur in the earlier years of the consent?
Yeah, and most are, and that's for good reason, because the sooner you get them in, the better, so you start accruing the benefits sooner. But the fact is that there is an operator on site who will be able to, you know, that will be maintained and that will be looked after because they're there. So
you're saying that the obligations to maintain those matters will cease once the consent ceases?
No, well, the condition, the compensation areas, I think, are in perpetuity. Well, they're listed, they're described in the conditions. Yeah. I guess it was more a point, you know, there are advantages in having long-term operations as well.
Okay, right. Thanks for that clarification. In terms of the duration, I may have got this wrong, and if I have, I apologise, but in terms of what your clients applied for, there seems to be a mismatch between the 25 years and the 35 years across PCC and GWRC. Is that the case or not? Have I misunderstood?
I'm not sure where 25 years came from.
Okay, so the long-term consent for PCC
35
is 35. Okay, thank you.
Unless I've missed something.
No, it's me that's missed that point. Thank you for that. And moving on to the hours of operation, the way you've explained it and the way I perceived your explanation is that it's largely a response to transportation issues.
Or projects, like some projects will operate, you know, at night, like if you have to do works at airports or other things that are time sensitive, you want to be able to do them at night or certainly after hours. Transport's the main one, you know, for good reason. If you can avoid digging up things in the middle of the day, that generally helps. But it's project specific, and I guess this is the point, is that having, you know, if Fulton Hogan had access to 10 nights a year and it was bidding for a project and they said, well, how, you know, we need stuff to this time, we go, well, I can only do 10 nights. They might go, oh, okay, well, that might not really work for us. Okay. Now, 60 is an arbitrary number as well. In a perfect world, you'd be able to go 6 till 10 all year. But we, you know, in balancing the certainty to the neighbours, we said, well, 60 is about 2 months. It's these 305 days a year where nothing will happen at night, and 60 days a year where something might happen between 6 and 10. So in terms of balancing that amenity with the need to get the aggregate out, we thought that was a fairer balance than 10 nights a year.
Yes, but can we just break that down in the words of that learned MC Hammer? The 6 a.m. to 7 a.m. period, that's purely not having trucks on the network outside peak hours, presumably.
Well, mainly being able to get them out, mainly being able to get them in and out and get started. Yes. But I mean, obviously they're going to turn up at places where it's going to be 7 or 8 o'clock or whenever it is that they turn up.
And is it 6 to 7? Have I got that right?
Yeah.
Yeah. And the evening one, is that more a project reason as opposed to a traffic safety issue, or is it both?
Yeah, well, because it's only 60 days a year, it's hard to see that being sort of
I understand.
That'll be much more.
I understand what you're saying, but what I'm okay.
Yeah.
Okay.
Sorry,
These aren't trick questions, Mr. Feathers. No, I'm not trying to trip you up at all. I'm trying to understand. Okay. So I just lost my train of thought there.
Could I just tag a question
yes,
onto that?
please do.
Just on that, something I thought earlier, whether it's 10 nights, 60 nights, that's not my issue at the moment, but I just wondered about whether you'd thought about notification to people around, just to help with that process. So I'm not concerned about the time, how many nights it is, but I just wonder if you thought of some sort of process to, just like you're doing with the blastings, email trail or however you're working it, might be of assistance.
Yeah, no, that seems like a very good idea, and I could understand why the neighbours might want to understand if they see that there's something happening at night, whether it's going to be a 1 night thing or a 5 night thing, and I can understand that.
Yeah, and it helps them organise their,
Okay, yeah, thank you. No, that's helped me regain my composure. And remember the question I was going to ask. And look, I apologise if these seem basic questions, but I just want to understand. So the 60 nights the 60 periods between 6 a.m. and 7 a.m. and the evening one, presumably that relates only to the loading and dispatch of vehicles. It wouldn't cover the actual quarrying operation itself. You would have stockpiles that those trucks could access and be filled and dispatched.
Yeah, no, that's a very good basic question because I'm just looking at the conditions. So we would need to.
It's about the intention.
No, it is both because it's quarry activities, including heavy vehicle movements, are all 6 to 10. So
about the intention.
Yeah. I mean, and I guess in fairness, given where it is and given the predicted noise levels, it is very acoustically shielded.
Okay, we'll come on to that in a moment, but
yeah.
I'd like an explanation, if not now, but I guess I'd like to see a without prejudice condition that split the two, operation and transportation, even though you might not agree with it. And the opportunity would be there to comment on why you don't think that's a good idea.
Yep. Okay. Just answering the question. So there is already in condition 7C.
Yes.
Notice must be given to the council's compliance officer and affected neighbours by a community liaison group at least 48 hours before evening works commence.
Yes.
So that's already in there.
Okay. It would be very useful if Mr. Baker could liaise with Ms. Williams on that in terms of condition framework. Even if you can't agree on the substance, a drafting exercise would be useful.
Just to clarify, is that to split out operation and transportation?
Yes. Yep. With the ability to comment on why that's not or is a good idea, respectively.
Yep. Thank you.
So the same for both the prior to 7 a.m. and post 6 p.m. The 60 days, could that be cherry picked? Is that something? It's a bundle that you can have access to. It doesn't have to be consecutive or sequential. Is that the thinking?
That's the theory, and it may be that there's a couple of one-offs and then a 2-week project or whatever. I mean, it can't be. It also can't be on Sundays or public holidays, obviously. So that's out.
Okay. So the main effect associated with the pre-7 a.m. particularly is that it presumably takes us into the nighttime hours. Mr. Hunt, I think is it 10 p.m. to 6 a.m. nighttime hours?
7.
To 7 a.m. Sorry, yes. So the 6 to 10 p.m. would be the prevailing rules would be daytime hour rules in the Porirua plan. Yes. Shoulder periods. Yes. Is that reflected in the operative proposed district plan, Mr. Hunt? The shoulder period concept? In terms of the standards, the noise standards? Okay. 7 to 10. Yeah. Okay. Could you just turn your microphone on, Mr. Hunt? Sorry, I didn't mean to put you on the spot there.
The definition of evening has traditionally been 7 p.m. to 10 p.m.
Yes.
But if it were changed to 6 p.m. to 10 p.m., that's completely within what NZS 6802 envisages, that councils
Yes.
are able to devise their own time periods of times of the day.
Yes.
Noise limits.
Okay, I know we're getting onto something substantive here, but what I'm particularly wanting to understand is the extent to which the operative plan matches that guidance in the standard in terms of the existence of a shoulder period, and out of interest, how the proposed plan deals with that. I appreciate the rules in the proposed plan don't have legal effect at this stage, but some commentary on that.
I will come back to you on that at the appropriate time.
That would be good. So the reason I raise this, Mr. Matheson, is I think you've said that who's your noise person?
Miss Wilkinen.
Yes, Wilkinen. Says that there will be compliance with the daytime standards in the post 6 p.m. period. So, and Mr. Hunt, you don't take issue with that, do you?
Actually, I do.
You do.
There is a matter around quantifying vehicle movements per hour.
Yes.
And the national standard, which for daytime only is LEQ 15 minutes.
Yes. Okay, so it's measurement.
It is a measurement of 15 minutes, and so therefore going right to the standard in terms of maximum vehicle movements per hour introduces an assumption that the vehicle movements would be evenly distributed among that hour, and that may or may not be the case. So it's just an issue there.
Yeah. Mr. Matheson, I know you want to comment and you're desperate to, but I guess the solution, well, not the solution, but if we could have some direct discussion between Mr. Hunt and your witness on that matter later today and tomorrow.
No, happy to do that. Just to be clear, the operative plan doesn't have any shoulder periods. And they're in the proposed plan, which, as you say, is still proposed.
Yes.
But I'll get Miss Wilkinen to speak to Mr. Hunt again about this other outstanding issue.
Well, she's due to present tomorrow at 11, and it just seems that there's an opportunity. She's not present in the room, is she? Okay.
If I could just put a bit of information out there around this numbers of movements and compliance. It's all changed now that we're talking different numbers per hour.
Yeah.
So this issue around compliance, around the exact numbers of movements, it's still live, but it's perhaps not as important.
Yeah. Okay. Even more reason for you and Ms. Wilkinen to get together between now and 11 a.m. tomorrow, Mr. Hunt.
Yes.
And see if you can slice and dice this in terms of agreed issues and disagree to. I mean, I'm really wanting the experts to help the panel on this matter, and that's why we're giving that opportunity. So, I mean, I don't see a need for you to be present for the remainder of this hearing unless you ever desire today. I mean.
Yeah, exactly. Yeah, no, that's fine. I'll look into that, and there'll be something coming through tomorrow.
And just on that, so it's condition 29 for the panel, so it's proposed 7 a.m. to 7 p.m. 55, 7 p.m. to 10 p.m. 50, and 10 p.m. to 7 a.m. and they're all LAEQ 15-minute compliance limits.
7 to 7, 7 to 10, is it?
And 10 to 7.
10 to 7.
All at LAQ 15 minutes. So if Mr. Hunt can discuss that with Ms. Wilkinen, that would be good.
That would be very good. And you'll be glad to hear that's exhausted my questions.
I'm off the hook. Excellent. Mr. Walsh.
Time being.
Okay, well, next witness is Mr. Peter Walsh. So he's got a short presentation, I think. And then what I might ask him to do is do the project description and then briefly speak to any additional points from his evidence. And then we'll go to you, Paul. Is that all right?
Right, good morning.
So just on the first slide, the proposal seeks to expand and operate the existing Willowbank quarry. They're not quite close enough. Located on the Willowbank farm and utilising an existing road with direct access to State Highway 58, the Parramatta Hayward Road. The site is set in a depression. Oh, has that changed, has it? Oh no, back. The site is set in a depression surrounded by hills and lies within operational farmland. As you can see, a forestry block borders the site to the north, and the surrounding ground is generally steep and covered in pasture elsewhere. Access to the quarry is via a fully sealed access road, which runs north from the quarry site, largely following a previous farm track down the ridgeline of hills, bordering the forestry block and an area of native vegetation, before reaching flatter land and accessing State Highway 58 from the south. I think you can see that on the attached slide. The Belmont Regional Park borders the southern boundary of the applicant's property and further to the south, and it's located approximately 800 metres from the quarry site. I'll try and keep this as brief as possible. In terms of the project, it sits across two different catchments, the Paotahanui and the Hutt. The quarry footprint will discharge into the Paotahanui stream catchment only, while the temporary fill area 2 will discharge to the Hutt River catchment. We go to that. This is an overview of the operational areas of the site. Overall, the proposal comprises the continued operation of the Willowbank quarry and the staged expansion of existing quarry footprint, which will involve the following activities: vegetation clearance and tree removal within the expanded quarry footprint, blasting and excavation of cut faces, benches and access tracks, processing of aggregate and stockpiling products, construction of a stream diversion channel, establishment of a new overburden disposal area referred to as Fill Site 2, and that's visible on the extreme right-hand side of the slide, and enabling works which will be undertaken to prepare the site for continued use and expansion. These enabling works will include the following activities: establishment of erosion and sediment controls, construction of a bund adjacent to the access track, access to Stage 1 and establishment of a site office, laydown and vehicle parking areas, and an area for biodiversity offsetting, which will be established in a valley known as Pig Gully. Rather unfortunate name. Pig Gully is in the centre of the slide, surrounded by a purplish outline. The quarry development can be broadly broken down into four main development stages. These are shown, the first three on this slide. So Stage 1 is basically the development of Quarry Area 1. So it's to establish a road to upper levels of Quarry Area 1 over the existing farm downs spillway, removal of material from stockpile Area 1. I'm sorry, that is the purple area to the bottom of the slide. Levelling and increasing that area for existing stockpile area. Upgrade access to Fill Site 2, including the haul road. Establishing Fill Site 2, including the development of a bund and an alternative access route for the unformed legal road. This is shown on a later slide. Deposition of overburden from Quarry Area 1 to Fill Site 2. Commencing quarrying of rock and removal of rock from Quarry Area 1. And the crushing of rock to produce aggregates in the floor of the existing quarry area and also on Quarry Area 1. The next stage is Stage 2, and that is largely around the quarrying of Quarry Area 2. So we establish access to the upper levels of Quarry Area 2 by installing a temporary culvert
in the existing stream diversion channel. We also undertake diversion of stream 3 to stream 2 along the base of the finished quarry benches. So that is actually along the base of the existing finished quarry benches in Quarry Area 1. We remove overburden from Quarry Area 2 and deposit that at fill site 2. And we also undertake the quarrying of rock and removal of quarry rock from Quarry Area 2. Once Quarry Area 2 is completed, there will also be the diversion of Stream 2 to Stream 1 across the finished base of the quarry benches in Quarry Area 2. Crushing of rock to produce aggregates in the floor of the existing quarry area and also in completed Quarry Area 1. Third stage is basically the removal of Quarry Area 3. So access into Quarry Area 3 and overburden stripping will be achieved via existing quarry haul roads. Overburden from Quarry Area 3 to be deposited at fill site 2 or sold. The quarrying of rocks and removal of quarry rock from Quarry Area 3. And it's noted that the exact sequencing of the stage overburden stripping for Quarry Area 3 is to be determined. This area will not be open for a number of years following the quarry commencing operations, and a number of factors will determine the exact sequencing and staging of Stage 3 and how it's cut down to RL 242. And this will be outlined in the annual review of the Quarry Management Plan. Crushing of rock to produce aggregates from this area will take place in the floor of the existing quarry area and also in the completed quarry areas 1 and 2. The fourth stage of quarry development is Quarry Area 4, and that is really based around the removal of the remaining overburden from the quarry and the continuation of quarrying of rock. Crushing of rock to produce aggregates will take place in the floor of the existing quarry area. So, while the location of the 4 stages I've mentioned as being quite discrete, the removal of overburden or stripping from any given stage will take place concurrently with the quarrying and crushing of rock from the previous stage. Okay. Initially, we expect there to be approximately 4 permanent staff on site to operate during the operating hours, with this expanding as required for aggregate processing and overburden removal. And the latter activities may well be undertaken by contractors. All quarry staff and visitors to the site will access the quarry in light vehicles via the main access road. The overall design of the proposed quarry expansion and the location of the fill site has been supported by an ecological impact assessment. And that report describes the iterative design process, consideration of alternatives in order to seek and avoid significant ecological effects, and the proposed ecological management. The expansion and operation of the quarry will result in environmental effects, including disturbance of aquatic habitat, loss of some native vegetation, and loss of potential suitable lizard habitat. A package of stream extent remediation and biodiversity offsetting within an adjacent gully have been proposed to address the identified potential residual adverse environmental effects. The area, referred to as Pig Gully, as shown on the previous slide, is situated within the same catchment and very close to the quarry site. The last slide, our proposal, or access to fill site 2, is along an existing farm track, which is the black dashed line shown on the slide up on the screen. And the farm track does cross an unformed legal road and runs along the same route for part of the required access route. Our proposal includes the provision of an alternative route for the ULR while fill site 2 is in use, A short section of the ULR will be used by quarry traffic travelling from the quarry to fill site 2, and the quarry trucks will need to cross the ULR. And that is shown in the light blue circle. The applicant has proposed an alternative safe route to PCC and the submitters who raised the matter of ULRs with us, which would be in place throughout the duration of operations at fill site 2, which is estimated to be for 1 to 2 years. The alternative route will be clearly marked and suitable proposed controls put in place to manage the crossing point. Fulton Hogan will be developing a number of management plans to meet the requirements of consent conditions. Quarry operations will be carried out in accordance with these management plans. Ultimately, the site will be fully rehabilitated upon the completion of quarrying activities, and a condition has been proposed accordingly. That's a very brief overview of the overall quarry operations.
Thank you, Mr. Walsh. Was there anything else you wanted to present before we go to questions?
No.
Okay. We'll start with Nigel.
Good morning, Mr. Walsh. My first question relates to your evidence and talked about auto monitoring of SRPs, and that you'd respond at the hearing on that, this matter of whether each SRP was going to have automatic monitoring.
Okay. My apologies, but I did think this was queries about the project description. If you would like me to give my evidence,
I'll
proceed on that straight away.
So this is not your evidence?
No.
Sorry, that was just a brief project description. I just thought it was easy to have them both together. But if my apologies for not being clear about that. But if Mr. Walsh could, if the panel want to take it together, that's fine. I'm in your hands.
Let's ring fence it and let's have some questions on the project description, and then we'll go to your evidence in chief, Mr. Walsh.
Thank you.
Thank you.
So
yes, okay. Well, I do. If we leave that aside. I do have a question regarding the stages, and my understanding, so what you're saying, I'm particularly interested in this fill site 2, and I guess how long that's going to take and how much material that's going to take. So it's not very clear to me how long that stage 2 is going to be operating. I seem to recall somewhere, but I can't find it now, something like 2 years. But reading what you've just said now, stage 1 and stage 3, so during stage 3, fill site 2 will still be being filled, is that right?
Correct. So in terms of the overburden removal, that goes sequentially from areas 1, 2, and then partly into area 3.
Yep.
So fill site 2 has approximately 500,000 cubic metres in volume. It will take all of the overburden from quarry areas 1, all of the overburden from quarry area 2, and some of the overburden from quarry area 3.
Yeah. So then the expected duration that it's going to be operating for is roughly?
2 years.
It is 2 years.
Yep.
So you're going to be starting stage 3 within 2 years?
We will start the removal of overburden from stage 3
within 2 years. Okay. My next question relates to this the difference between what you can put in the stage 2 fill stage 2, and what you have to take off site. So there's a lot that's going to have to be taken off site.
Correct, there is.
And where's that going to go? I mean, you talk about selling it. What's the market for that? Who would want that material?
So developers, road construction, many sort of activities where fill material is required, and it's a common practice throughout the country to sell fill to such projects.
I guess leads on to a question of what happens if there isn't a market for that material. You've got really nowhere else to put it, have you? So you are you're relying on selling that material?
Correct, we are. So it's really just like any other material from the quarry. So the rate a quarry progresses is determined by the sales, whether that be overburden or whether it be aggregate and rock. Yeah.
Okay. There was a comment, I think, from the council traffic evidence about wanting to minimise the amount of trucks that took the stuff off-site, in terms of the whole traffic issue. Have you got any comment, or can you comment on that? I mean, it seems to me you really have to take the stuff away, don't you? It's hard enough to, we went up there, it's hard enough to get fill areas on site. That's quite evident. So you've got really no scope for doing any more fill, have you? So that has to go away.
Yes, it does have to go away.
Yeah.
And it's just, as I said, it's just like any other product from the quarry. We consider it a product.
Yeah.
The actual removal of it is to actually, and placement fill site 2, is actually to expose rock and give us the ability to actually have a mix of products going off-site. And in terms of the traffic, it's a product. It's included in our traffic projections and traffic numbers.
And you'll have to, adjust the whole operation to fit that. So it's quite a juggling operation, isn't it?
Yes, it is. And it always is at quarries.
Always is, yeah.
Yep.
Okay.
And Nigel, just before you go off that topic, for you, Mr. Baker, the maximum number of loaded trucks per hour figures, do they take account of removal of fill?
Yes, they do.
Okay. Is that clear from the condition?
It could be clearer.
Could be clearer.
Yeah.
Could I leave that with you? Thank you. And Ms. Williams. Sorry.
So I think that's, in terms of the overview, that's all the questions I have. Thanks.
Thank you.
I have some questions on your evidence, but I do just have one in terms of some of the plans that you put up earlier. You've got a stockpile area. I'm not going to be able to find it. And I want to... As you're coming into the quarry, you've got a stockpile area. Stockpile area 1, I think you call it.
Correct. So if we...
Yeah, so that area, that's not an area for crushing or anything else. That's...
Purple area?
Yeah. Is that just an area where trucks would be loaded, or is that an area where gravel or overburden or whatever is stored, or what does that area do?
So that is just an area where material will be stored. And it was an area previously used by the previous quarry operator. So it is an area that's already partially formed. And the intention is, while we're in the initial stages of the development of the quarry, that indeed we would use it for the storage of aggregate and loading out.
And to the same effect, overburden would be stored there? If you were selling it, you would store it there rather than...
No. So overburden, typically being low value, we tend to try and move it as little as possible. So it'd be no intention of storing overburden in that area.
So if you were selling off overburden off-site, how does that work?
Then we would store it elsewhere in the quarry.
Okay. Yeah. So there's no crushing happening there. There's just storage of gravel.
Correct. Yep.
Okay. Thank you.
Just Mr. Baker, coming to you, that raises another question about whether the conditions are directive on the location of crushing occurring. I presume they are.
Probably covered in general condition 1 at the moment through plan sets.
Yes.
So it could be clearer again.
Yes. Is there a role for the quarry management plan there in terms of...
I think so, in terms of setting things out.
Yes. Yes, I think it's important that condition framework clearly states the objective, the content of the plan, the matters that it should address. Those 10 tenets of good condition writing on management plans, certification, loops in the event that there's no certification forthcoming in the first round. Yes.
Just also on that, just if overburden was, if you like, stored elsewhere in the quarry to be sold off-site, I'd just like to understand, how that's managed. I mean, there's quite a lot of management going up into full site too about overburden. So I just want to understand how that happens in the quarry in between time.
Yes, like the storage of overburden is obviously a matter that the quarry management plan should deal with. Okay. Thank you. Was there anything else? No. Mr. Walsh, I've just got a couple of follow-up questions, if I may. I think I understand the sequence of the overburden removal, stages 1 and 2, and part of 3 going to full site 2, and within the first 2 years, I think you're saying, in terms of the stripping off and
over a 2-year period.
Over a 2 period. So okay. So that might not be the first 2 years.
It's very likely to be.
Yes.
But just depending on how this process works out.
Sure.
You do not start stripping in the middle of a winter period or autumn, so it may go beyond the first 2 years, but be a 2-year period.
Yes. And so really that's, have you got a feel for the split between overburden material that will be able to go to full area 2 and that material that will go off-site in percentage terms? Is it a rough rule of thumb that you're aware of?
No, there isn't. It's purely project-driven in terms of the material that goes off-site.
Yes.
And so identifying opportunities. So no real determination.
But that's a commercial consideration?
Yes, it is.
Yes. And presumably the physical capacity of the fill site to take material is also, I think you said 500,000 cubic metres?
Correct. It's approximately that, yes.
Yes. And so it's as simple as that. I mean, once you've reached that quantum, all the rest has to be taken off-site. Is that
correct? Yes. And look, that's not uncommon.
Yes.
So many of our quarries, their rate of development is determined by our ability to move the overburden and sell it.
Right. The slide that's on the board at the moment, showing the different quarry areas, particularly 1, 2 and 3, is something we were able to view firsthand yesterday during our site visit with the assistance of the quarry manager. So we have a definite understanding of where those sites are on the ground. That was useful. What I've written down here, though, was what are the timeframes for the working of those 3 stages over and above the stripping and removal? I thought I read somewhere that the first 3 stages would occur within the first 10 years, and that then the stage 4 and the working of that combined area down to an RL of whatever, 242, would be the remaining 22 years. Now I can't, like my colleague, I can't find reference to that anymore. Is that correct? Is that your understanding, or is that?
It's broadly correct. So if you look at those first 3 areas in terms of the estimated volume of rock, it's about 1.4 million tonnes in those first 3 areas.
1.4 million tonne.
We would certainly hope to sell that volume of rock in the first 10 years of the project, yes.
Right. So that's a commercial imperative.
Yep.
Okay. But it's of that that sort of duration that that's not untypical.
It depends on sales, doesn't
Sure.
it?
Yeah.
But we would very much anticipate that material will be gone within 10 years, yes.
Yes. Mr. Baker, I know I keep coming back to you, but presumably staging is a matter that the quarry management plan will deal with head on?
Yes, yep.
Yes.
And I'm hearing quarry management plan needs to be very clear on setting these things out.
Very clear. As I said, there are 10 tenets of a good plan, starting with what the objective is, what the content is to give effect to that objective, who prepares it, who certifies it, what happens in the event that it's not certified, what happens with recertification, what's the loop process, that activities must be undertaken in accordance with the approved quarry management plan. So those are the sort of things that a good condition should contain. I'm not saying that they don't, but it is a fixation of mine. And I know that Judge Kirkpatrick is very concerned about the quality of condition drafting on management plans. The Institute and the RMLA conducted a condition writing seminar back in 2014, and Judge Patrick commented 3 years later that he hadn't seen a lot of improvement in that time. So, yeah.
If I could just add, I think the conditions drafted probably do cover the bases, but perhaps the difference for this application is the applicant's gone to the trouble of drafting every management plan, I think, so we do have a starting one in front of us, but I'm certainly hearing to make sure those things that you're mentioning are very clear in the management plans.
Sure, and the dialogue with Ms Williams on that would be useful. And that dialogue doesn't have to finish at the time that you present. We have what we use in the industry, the term the running dog, which is essentially the different iterations of the condition framework, which are clearly marked in terms of version control. Yeah. And what I should say, and I apologise, I should have made this point at the very onset, is out of necessity, it's going to be important for this panel to talk about conditions during the course of this hearing. And that should not be a signal to indicate that we've made a decision on this application. The reason why we focus on conditions is that we need to understand whether the mitigation measures that are being opposed through conditions are capable of, in fact, mitigating effects. And there's only one way to do that, and that's to discuss front on the conditions. So, because if we're not satisfied that they can, there's only one possible outcome. So, for those that are present in the room and those that are listening on YouTube and beyond, that's the rationale for discussion on conditions. Okay. Sorry about that, Mr. Walsh. Went on a tangent there. And that's all from me. Now, we have your
evidence.
We have your statement of evidence in chief.
I take it you'd just like me to go through it in summary.
Well,
and hit the main points
in a very cursory manner, because we've all read it.
Yep.
You haven't produced a summary statement because we didn't ask you to do that.
Correct.
So, if you feel you need to take us to any matters, I'm in your hands, but I can guarantee that I know that my two colleagues have read it and have specific questions for you.
Good. I'll just stress some key points around aggregate demand in the Wellington region. So, it is estimated that currently 3.7 million tonnes are used in the Wellington region. And that is compared to the current estimated production of 2.5 million tonnes. So a significant shortfall. And that shortfall actually grows going forward with population growth. So by 2050, it's estimated that the region will require 5.4 million tonnes. I think there are a number of large projects, and throughout my evidence I did keep referring to the Infrastructure Commission and their report. The reason for doing that was that they were very supportive in their report on identifying the shortfall in Wellington region, the difficulty in consenting and accessing alternative quarry resources, and also the difficulties in bringing aggregate in from outside the Wellington region. That is because not only does the Wellington region produce significantly less than the average requirement for aggregates, but the closest adjacent regions also produce less than the national average and the average for Wellington's aggregate consumption. In terms of the alternative aggregate supplies, there are a number of actual key things that increase costs, and also a number of things that are detrimental, I think, to the country overall. And that's the effect of importing aggregate increasing the carbon footprint, definitely the increased cost, the effect on the ability to actually go through and achieve projects, not only for cost reasons, but also for availability and timeframes on delivery. And also that the additionally importing of aggregate increases road usage increases wear and maintenance costs, and actually increases congestion through having trucks on the road to a greater extent and for longer time periods than if aggregate was sourced closer to the demand. Willowbank Quarry, I think, has a number of attractive features. It is noted that 76% of the overburden will be removed from the quarry in the first 10 years, and that 76% of the rock is below RL 242. You will have noted when you were on site that RL 242 is actually a level at which the quarry is significantly surrounded by hills. In terms of our operations, I'd like to stress that Fulton Hogan is very supportive of a partnership approach with local iwi, and we're committed to providing full support that both Ngāti Toa and Taranaki whānui require to successfully carry out their kaitiang activities on the site. Recognise that Fill Site 2 is only operational for the first 2 or so years, and we will ensure that we make it a priority to put in place the early right processes and support in collaboration and partnership with the Taranaki whānui. The proposed operating parameters, there are some key matters in that. I would stress that our proposed hours of operation are for evening work to a maximum of 60 per year. In our traffic, we have taken consideration of the reports and submitters' concerns, with the key things that we've changed being the overall truck numbers per hour, reducing that from 45 to 30 truck movements, truck and trailer loaded to 30 per hour. And then in evenings, reducing our initial application from 24 trucks per hour down to 12 trucks per hour. And, you know, in terms of when we look at a quarry and how it operates, the safe and efficient operation of State Highway 58 is absolutely essential for the quarry. So it's in our best interest, and it's something we would do anyway to ensure that this is achieved. We've also actually limited ourselves in terms of blasting. And in terms of blasting, we have set highest targets for ourselves in terms of the blasting vibration levels than the industry standards. We are undertaking full notification, and we've also fairly strictly limited the hours in which blasting can occur. So limited between 11 a.m. and 3 p.m. So we've gone quite some way in working towards helping to address the concerns of the community. In terms of other matters raised by submissions, I've already covered off the unformed legal roads and how we've gone to quite some extent to, satisfy the concerns of submitters. And we recognise that any quarry does have an effect on adjacent neighbours and the wider community, but we've gone some way to help to mitigate those, and the measures we're putting in place to control and manage effects are quite rigorous, but we also recognise that they're very achievable, and indeed we do this at our other quarries throughout the country. I would like to address the consent term and just make the points that quarries are a high capital, long-term activity, and the very nature of rock extraction requires long-term planning and long-term commitment from a company. The initial costs of consenting and the implementation of consent conditions are high and frequently cost in the low millions of dollars. Remediation conditions at the end of quarry life can be high. The initial stripping of overburden is a costly and time-consuming exercise, and sales off-site or overburden are actually just cost recovery exercises to a great extent. Indeed, 75% of the overburden stripping at the quarry is planned to be undertaken in the first 10 years of the quarry life. Purchase of capital equipment, also a significant cost to a company. The very nature of quarries and the fact that they're overladen by overburden and lower quality rock at higher levels means that the higher grade rock, those that you can process into higher value aggregates, very much come later in a quarry's life. And indeed that will be the case in this quarry too. So I think all of those reasons add up and give a picture of why quarrying, when they're operating, do need long-term consent certainty. And in terms of putting a business plan together and a business case for the quarry, I would struggle to do so and feel confident about putting a case towards Fulton Hogan's senior management for a term significantly less than 35 years. That just is purely the basis of their upfront capital expenditure, when we're accessing good rock, and when the sales are occurring and payback is occurring for a business. The proposed consent conditions, whereby they can be reviewed every 12 months, and Council has that ability. The fact that we would be bound by any statutory and legislative changes as well, I think gives enough certainty for Council to be confident to grant a 35-year consent. I think that's probably as much as I can say, except, the quarry is of regional significance due to an aggregate shortage, and it's of national significance. And I think the shortages faced by large projects such as Transmission Gully are very self-evident proof of why it is additional aggregate supply is a national issue for the Wellington region as well.
Thank you, Mr. Walsh. That's a very economical summary. Thank you. We'll just see what questions. We'll start with you, Nigel.
Mr. Walsh, you would have heard my question before about the finished levels of the pit. Can you comment on that now?
Yes, so the planned finished level of the pit was RL 182.
Yeah, and it still is?
Still is, yeah.
So when I look at, there's a drawing that I've looked at that shows, I think, the ground level near the outlet, or because it's quite steep, you've got that fish ladder going down. I'm not sure whether that 182 is going to be below adjacent ground level. So if it's below adjacent ground level, which ground is that? Because it's also steep around there. So it sort of comes to this question of if it's going to be below existing ground level and there might be groundwater coming in, what the implications might be for that.
So we don't anticipate there to be groundwater entering the pit. The previous operator did actually extract down to that level and didn't encounter groundwater, and the drilling we had undertaken on site didn't encounter groundwater.
There's a bit of scarcity of groundwater information. I think there's in the documentation, there's a discussion of groundwater level out by the road. But there's no discussion of groundwater level at the quarry. So maybe if you could find something that would be provided to us, that would be quite useful. I'm not doubting what you're saying, it's just that there's not much.
Okay, yes, we'll try and find something, but it's often difficult to provide proof of something you haven't found. I suspect that's why there's a scarcity.
Well, sure. I mean, the groundwater level, reduced level, out at the road's quite low, you know, so it could well be that well above it. It's just if there's, a record of a borehole that went down near there that didn't encounter groundwater, for example,
Correct.
It's just that sort of information. And I've come across this before where we had to, the applicant for another quarry had not really addressed that, and it turned out to be a big issue. So I'm not saying it's a big issue here, but it's just something that I've come across before, and I need to see more information myself. So it might be just a matter of something like that.
We'll look for something and provide it, but believe me, we do consider groundwater very seriously.
Yeah. Well, of course you do, because it's an issue for you to deal with. But if there's some documentation that it went down to 182 before and there was nothing encountered, if there's something to document that, or a drill hole or something of that nature would be really useful.
No, we'll provide that.
My next question relates to this SRP monitoring.
Right, so we do have a position, but we were hoping that could be further discussed during
that's fine.
this process,
Well, perhaps
with an answer by the end of before the end of the week with the experts.
With the experts when the erosion and sediment control person's talking?
Yes.
Yeah, okay.
I hope I'm not trying to dodge the issue, and I hope that's satisfactory.
Yeah.
I'm just wondering when that might occur, Mr. Walsh, Mr. Matheson, and who would be involved in particular? Would that be Mr. McLean for the council and...
Yeah, Gregor will speak to that.
Gregor McLean?
Yeah, Gregor McLean.
And from you, Mr. Pope?
Mr. Pope.
Mr. Pope.
Okay. I've got one further question that relates to vibration monitoring for Mr. Stiles' evidence on behalf of council. From what I see that he's saying, that if you monitor the vibration at a reasonable distance from the quarry, and that shows that it is below a certain level, then you can be pretty sure there's no damage to buildings. And then he went on to say that if the panel wanted to consider doing some dilapidation surveys and before and after surveys, he could come up with the wording for that. So I guess my question is obviously leading on from what Mr. Matheson has been telling us, that you guys don't want to be rushing off doing a whole lot of monitoring that's not necessary. And certainly the dilapidation surveys or the monitoring of damage to buildings has to be done, if it's going to be any use at all, has to be done immediately before blasting and immediately after, and it's quite an expensive business. So I just wonder have you had an experience with blasting that you can comment on this sort of thing in terms of monitoring effects on buildings nearby due to blasting?
Not directly on monitoring the effects, but look, the limit of 5 millimetres a second, sorry.
Yeah.
5 metres a second would be rather violent, but 5 millimetres a second is a conservative industry standard set so that damage to buildings does not occur. We are targeting rather less than the industry standard.
Yeah.
One of the difficulties with assessing damage to buildings is timeliness. The fact that seasonally ground shrinkage typically causes damage to buildings, in my opinion, far greater than a 3 millimetre or a 5 metre blasting. And heaven forbid, even very small and slight earthquakes cause velocities well in excess of 5 millimetres a second as well. So we're fraught with a number of complications, hence a reluctance and hesitancy to do building monitoring rather than just monitoring our blast vibration and carefully controlling that.
So have you had any relevant experience elsewhere that you could let us know about that would be relevant here to our decision here?
No, because we haven't had a quarry operating, in my experience and exposure, whereby we have caused damage to buildings through blasting.
Have you had experience with a quarry where there have been houses within, say, 400 metres of the quarry?
Oh, certainly.
And from that, you haven't had any experience of any damage caused to those houses by blasting at a quarry?
No.
That would be similar to what's proposed here?
No, we haven't.
Yeah.
We do have a quarry with houses well within 100 metres of a quarry.
And blasting has not caused problems with that?
Not that I'm aware, no.
Okay, thank you. That's all I have.
Liz?
Thank you. I've just got a couple of questions. I just want to clarify one. You've given us an updated copy of your evidence, and was the only change to that? Could you just confirm what the change was to it? Because it wasn't tracked, so I just want to confirm that I've got the changes right.
So Ms Brown helpfully put that in as just the 30, so it'll be 45 to 30.
Okay, thank you.
That's it. Yep, correct.
So there were no other changes?
No.
Just maybe if you change those in future, it's just easy so we're not reading the whole thing again.
So just to be clear, that was on traffic numbers.
Correct.
Yes.
Thank you. So I just wanted to explore a little bit Fulton Hogan partnership arrangements with iwi elsewhere in New Zealand. And I understand you're wanting to engage in a partnership approach here.
Correct. Yep.
And there's been some suggested conditions in the Greater Wellington consent, which I think you have agreed to as well. I guess that I just want to understand the nature of your partnership agreements in other areas, how this one relates, and there's a note that goes with the condition about cost arrangements. And I just wondered how those are going to get tied together, because obviously an advice note is not strictly enforceable. So for our point, we want to understand how that partnership approach is going to progress.
Right. So the first question was Fulton Hogan as a whole and their arrangements with various groups. So we have a wide range.
A brief overview. I don't want you to run through
don't worry.
Quarry, please.
No. So we have a wide range.
Yeah.
So it ranges from very informal engagement with iwi, particularly in smaller areas where we actually have active local managers involved with the local community anyway. And it ranges from that right through, we do have examples of formal written engagement agreements with iwi as well. Mm. So the full gambit.
Yeah, so what are you envisaging for this situation?
I would never presume to envisage anything, but I will commit to full discussion and consultation with iwi. And you have, the reason I say that is not to prevaricate or anything like that, but quite often groups do not want to be closely associated with any actual contractual arrangement with a process such as Quarry, and that is their right. However, informally, they're quite willing to engage.
Sure.
Different iwi have different approaches, different standards, and we would always just, go along with.
So where are we at this stage, though? When I look at the conditions, and then there's an advice note attached to it, so I want to understand where we are with this package.
I guess I don't feel fully comfortable in commenting on that, only because I haven't had direct involvement.
Sure.
But it'd be fair to say that we're in the very early stages of starting that process.
Is that going to get deferred to you, Mr. Baker?
I think what we'll do is we'll ask Mr. Baker to, Mr. Eastham from Fulton Hogan's been having some direct discussions. I think it's probably best to be reported back by Mr. Baker.
Sure.
I mean, it is difficult because, that advice note, it's not a valid resource consent condition requiring payments to be made, so it can only ever be offered as an OSIA condition, which the company's happy to do. And the commitment's there, but equally, as Mr. Walsh said, the company's not going to presume to know what the end of that consultation process is going to be, because that hasn't happened. So, so what they're saying is they're very happy to engage in that process, and the latest advice I've had, which Ms. Baker can confirm, but my instructions are that Ngāti Toa's preference is to basically come back to us at the end of the process and have the discussion then. So we have been following up, and that's fine. That's a preference. That's okay. But that's sort of where we're at. So, but I'll get Mr. Eastham and Mr. Baker to discuss. It's been a bit of a tag team between the two of them for
give you one very positive example, we have a current consent process underway elsewhere in the country. The local iwi group does have an opinion on our quarrying. They will not object to the consent as we've applied for. Indeed, although they wish to meet with council, they have actively invited me to go with them to meet to discuss the consent. So that's a very good working relationship. We're currently, in terms of achieving things on site, going beyond our consent condition requirements to address some of the things that are of concern to the local iwi.
I guess too, it does lead to an early engagement, and then maybe situations get ironed out before we land up sitting around this forum. So I guess probably hindsight's always a great thing, but it's just I'd be interested to see how that develops. Yeah. So I just move on to paragraph 4.2. So you've got a footnote there for your clause C, and it just talks about other quarry-related activities such as maintenance, dust suppression, sediment control, monitoring that may occur outside of these hours. And I just wanted to know what you mean by maintenance. I mean, I can understand what the other ones are, so I just wanted to understand what maintenance was, and sediment control. And I just wanted to know whether monitoring would also occur outside of hours and regardless of a particular day.
So yes, so that maintenance would be typically if you had a breakdown on a piece of plant, you were partway through the repair process and it required you to carry on and just complete the repair, that sort of thing. In terms of monitoring, yes, depending on events, monitoring could have to occur outside of those normal hours as well.
So there is a commitment to if there's an event that needed to have on-site monitoring, that would occur regardless of public holiday, for example.
Correct. We will put that in place when the quarry is operational, and indeed Greater Wellington did refer to areas of non-compliance in recent times after heavy rainfall events. Both of those occurred in weekends and one on a holiday weekend. Of course, we're not operating, and the activity that did not take place was the sampling within the required time frame.
I'm aware of that. I wasn't particularly putting you on the spot for that. I was just wanting to know from today on whether that situation has got some teeth around it so that it won't happen again.
Correct. It has got some teeth around it.
I brought up before about notification. I mean, obviously you're going to put tenders out for projects, and if you are accepted, you're going to know that you're going to have to supply this, and you may have to work at night. So I talked a little bit earlier about potential of notification of
I'd just like to clarify that we may need to work in the evenings, which is quite different from what the previous operator did in terms of its night works, which did indeed go right through the night. So we have drawn back quite markedly from that. But yes, we would intend to notify them, and I believe there's a proposed condition for that.
Okay. Yeah. Just bear with me a minute. I'm trying my new online system, so I'm rusty.
That worked very well for me the other day until I left my charger at home and I got halfway through the
I don't want to hear horror stories. I'm already nervous enough.
Got your charger in. So.
And it was an Apple one, of course, which you can't use anything else for.
That'll teach you. So just 6.8, 6.9, you talk about the last two quarry consents that have been granted for a term of 35 years.
Yep.
So I just wanted to understand, where were they? Are they in any, apart from extracting rock, how are they similar to the one in front of us?
So they were at Matawai, which is between Opotiki and Gisborne. A relatively small quarry doing 200,000 tonnes per year, but located within a rural community, hence the example. And the other quarry was Royden in Christchurch, which is relatively recent consent. Large amount of, I guess, public interest, I'll say, and a complicated hearing process, and indeed a very detailed consent in terms of the required operating parameters.
So was the Royden one, is it a land extraction?
Yes, it is. So it differs in this one only in the respect that it does not have blasting, but it does have full range of traffic effects, dust, noise, all the usual issues associated with quarries.
Including a discharge to water?
Yes, it does.
And with the other,
but not to the same extent.
And with the other one as well, the Matawai one?
Matawai definitely does have a discharge to water and does have blasting.
And just note that those both have got some sort of discharge to water to varying degrees, obviously. What sort of receiving environment would they be considered? Are they of national, regional significance water bodies, or?
The Matawai quarry discharges to the upper reaches of the Motu River, so definitely of national significance.
And the other one, a lesser?
Lesser, yes.
It's the Templeton Quarry, is it, Mr.
Correct.
Walsh? Yes. So it's generally farmland, rural residential subdivision.
That's right. A large site, and it discharges into alluvial gravels, so
yes.
Somewhat different.
I think the issue there was more about water supply contamination. And
correct. It was an underlying aquifer. Yep.
Sure, thank you. So just two more from me. One, as you say, there's high costs associated with remediation. How does Fulton Hogan plan for this?
So in terms of, we normally have conditions around coming up with a remediation plan, often 5 years prior to the closure of the quarry. But in addition to that, we also actually start actively appropriating money somewhat prior to that to cover what our estimated costs for remediation are.
Sure, so it's built into...
It's built into our business model, so we allocate money on a per tonne basis of extraction somewhat prior to that, depending on the site and what remediation we think will need to occur.
Yeah. And so just semi-related to that, I'm just looking at adaptive management, and it's a key feature of this consent, or these consents. So, with adaptive management, you monitor, you analyse, and then you fix the problem, if you like. So what I'm interested there is funding, once again, to effectively be allocated to fix any potential issues, and timeframes in between identifying an issue and then identifying a solution.
Okay. I guess, I get a bit grumpy, actually, this whole perspective that we're there to quarry and damage the environment. And the converse is actually quite the case. So if we identify areas not only where we're having exceedances, but also areas where we think we can make improvement that go beyond the consents, we would supply the funding and indeed have the desire to achieve those. So, this is a perspective on quarrying that is not necessarily reflective of the true way that certainly Fulton Hogan operates, and certainly the way the larger industry operates either. We're all New Zealand citizens, and having good quality water is very much one of Fulton Hogan's key aims, as much as it is anybody else who lives in our environment.
So just to clarify, that hasn't come to you from any other experience from a quarry. It's come from experience of other consents that are bound by adaptive management. And it's about, if there is a problem, is there an ability to fix this problem within a reasonable time frame? So it's not necessarily a quarry question. It could be wastewater question, or it could be any other question. It's about the type of management of this consent.
Yeah.
Thank you.
Thank you, Commissioner Burge. Just in terms of time frame, we'll go to 1 and then we'll break for lunch. Mr. Nation will come to you after lunch. So, no, that's okay. I'm worried about your digestion. Just a couple from me, Mr. Walsh. I want to go back to blasting. I want to talk a little about remediation and the hours of operation and iwi. So those are 4 matters, and there might be a question from Mr. Matheson and Mr. Baker along the way. With blasting, we only know what we know. So
do I.
Yeah. When is it most like? During the life of the quarry, during year 1 to year, and your proposal, year 35, is blasting a continuous activity, or is it going to occur predominantly in the first 10 years or the first 15 years? In terms of those timeframes, what's its most likely occurrence?
It'll be a continuing activity throughout the life of the consent.
So when you get to stage 4 and you're bringing stages 1, 2, and 3 down to the ground level, that'll involve blasting also.
Yes, it will. So even more so, I would say, at that stage.
Yes, and clearly, from the dumb question file, it's the purpose of blasting is to dislodge rock, hard rock, and to enable it to be sort of broken down and won.
Correct, it is. One thing I would say about Willowbank is the very nature of the rock is that it's a highly fractured rock.
Okay.
So in terms of that, your blast pattern and the amount of explosive you use and what they term the powder factor, the amount of energy you're putting into blasting a given cubic metre of rock, is actually a lot lower than typical grey wacky quarries that you might find elsewhere in the North Island.
Is it predominantly grey wacky rock that you are sourcing your material from, though?
In the North Island?
No, here.
Yes.
Yes. Okay. Just out of interest, does that fractured nature of the rock go to the quality of the aggregate?
Not necessarily, no. It goes to its geological history rather than the quality of the rock. Yeah.
I've heard the term rotten rock. What does that mean?
Rotten rock's usually the interface of grey wackies are often overlain by weathered rock. Okay. So rotten rock occurs on the interface of the good grey wacky from the weathered grey wacky.
Okay. So what I'm hearing then is between year 1 and year 35, blasting will be a common occurrence.
Correct. Yep.
Yes. And
it'll be an ongoing occurrence.
Yes.
I guess we could debate common, couldn't we?
Yes. I guess what I'm trying to understand is the sort of stages or substages that it'll be associated with, and whether it would be, for a certain period, then there'd be a discontinuation, and then there would be another period to allow access to different parts of the quarry.
It will be regular.
Regular.
Yes.
Okay. Daily?
Blasting?
Yes.
No, certainly not. And I think in the conditions we actually have limits on the frequency of blasting.
Yes, you have.
Yeah.
Well, there's certainly limits on the hours of operation of blasting.
And the number of blasts.
Okay, sorry, I didn't pick that up. In a given year?
Correct.
Thank you. Thank you. Now, moving on to remediation. How would you
sorry, Commissioner, just before I forget, and so blasting is limited no more than one blast every 3 weeks.
Okay.
So that's at condition 35.
35, thank you. I knew you would have it. Remediation, Mr. Walsh, what's the final landform going to look like in terms of level, ground cover, contours, elevation? What's it?
Well,
land use?
So I guess in terms of the final quarry pit, that would be a matter of discussion 5 years prior to closing.
Yeah.
But typically, in a hard rock quarry, it is actually putting media that can grow vegetation on the final quarry benches.
Okay. On the benches?
Yep.
Yes. And how significant will be the hole in the ground?
It won't be a hole in the ground as such. It will be the removal of a hillside more than a hole in the ground.
Yes.
So it will end up basically with likely to be, by the way, because we haven't quite planned it out with the landowner yet, which we'll do 5 years prior to closure, hopefully. You would end up with steeper terrain, but with vegetation growing on the benches.
And undulating terrain, presumably?
Correct.
Yes. Okay, and that will be part of a rehabilitation plan?
Yes. Quite typically when you're closing quarry, there are a number of parties who have input to such a plan.
Yes.
And we certainly take those views into account.
Okay, thank you. And in terms of this, in terms of the, I guess, remediation just doesn't start and finish. Presumably it's an ongoing process, and presumably there's some backfilling of the quarry as you go along.
Correct. However, this pit does not lend itself to backfilling as you go along. As you can see, we're extracting at the base at the end of the quarry life. That is not to say that remediation, such as backfilling, cannot occur post the cessation of quarrying.
Yes, I understand.
Yep.
Okay. Okay. Third matter was the iwi matter, and I don't want to repeat my questions that Commissioner Bird's raised, but I note that one of the conditions involves the establishment of a community liaison group, and you'll be familiar with that condition framework?
Yes.
Yes, and I see that the composition of that group includes iwi representatives. Is there a community liaison group currently, or is this a new initiative?
To be honest, no, there isn't a community liaison group at present. I'm not sure what community engagement the prior operator did undertake, though.
Okay. Okay.
I think it was just ad hoc meetings.
Because it was a short term. Yeah.
Okay, thank you. But this will be this is a formalised group and process established by a mandatory condition.
Correct.
Yep. Okay, and it would have representatives from the council, submitters and community group representatives, and I see the number there is 3 iwi representatives, one from each iwi, being Ngāti Toa and the whanui from Taranaki.
Yeah, and we do have examples where community liaison groups have worked particularly well, to the point where after some period of quarries operating, the need for meetings, usually at the community's request, actually declines in frequency.
Okay. What would be the function of the community liaison group in your view?
It's basically for the ability for, firstly, for them to raise concerns, whether they do have any concerns about the operation of the quarry. After those concerns are outside consent conditions, and they're just issues that arise from time to time that are dealt with. I think in a number of cases it's also been where we've looked at matters where we've had initiatives we could undertake and just made them aware of those.
Yes.
And then, last but not least, where they raise matters of community support within the community, and it's an informal sort of avenue for them to request for support for within the community and for various activities.
Such as funding for projects?
Assistance for projects, yes, or funding.
Sure. Would you expect a register of complaints to be an ongoing item on the meeting of the community liaison group?
Definitely.
And
it's usually the first point of discussion as to whether there have been any complaints in the prior period.
Yes.
Yep.
I should have asked this earlier. Does Fulton Hogan have a environmental manager dedicated to sites, or is it more of a national position?
So we have a structure where we have a national structure. We also have regional people dedicated to environmental monitoring, etc.
Yes. And so that person or persons might be part of the community liaison group, or at least attend the meetings of the community liaison group.
They could, yes.
Yes.
Last one. I just noticed that Porirua City Council is deemed to be part of the liaison group. Did Greater Wellington, was that part of the liaison group as well? Was there a reason for just one council?
To be honest, I'm not sure about that. Can I kick that one for touch and come back with a response?
Normally the councils play paper, scissors, rock to see who has to turn up, but if Greater Wellington wanted, I think it's probably just because it was in the PCC consent conditions, I would assume. So
it's a thought to be maybe brought up.
We wouldn't have any objection to them being part of the community liaison group. So, yeah.
Can we leave that with you, Ms. Walker, and to discuss with Mr. Baker? Thank you. Okay, the final matter, and this, I guess it's a matter for you and for Mr. Matheson and perhaps Mr. Baker, and I'm quite happy to share these breadcrumbs as we go along. I'm having a concern with the justification for the 6 p.m. to 10 p.m. time frame, and I want to share that with you so that it's transparent and that so that you can respond either now or in your rebuttal. And what I heard Mr. Matheson say is that unlike the 6 a.m. to 7 a.m. one, which is largely transport related, the 6 to 10 will be predominantly driven by projects. And to me, that raises the question is why can't this be anticipated and programmed accordingly? Why can't there be a supply of rock on site that enables access to that without any operation occurring during that 6 to 10 period to win the rock? Now, there may be good reasons why that is, but it's a question that automatically comes to mind, and it's the reason why I asked about the bespoke drafting assistance between operation and transportation. I've sat on and I've been involved in processing concrete batching plant consents who often want an early morning start-up, but they also want the ability to operate outside of the daytime hours, quite often after 11 p.m. and well before 6 a.m. to deal with projects for early morning pours and that sort of thing. And generally there's been an understanding of that requirement because the nature of concrete, the construction project and the concreting going off. And so, I'm not necessarily seeing the same parallel here with the supply of aggregate. So I need to be convinced, I think the panel needs to be convinced on that as to why that can't be programmed and planned for to avoid, at least in the first instance, the need for operation during the 6 to 10 period. But secondly, the actual transportation of material during that period.
Yeah. Well, you've actually probably hit on one of the industries that drives some of that requirement, and that's the concrete industry. Also, asphalt and sealing. I'll deal with those two sort of ongoing matters first. And that is because they often have relatively small storage capacity at their individual batching plants.
Yes.
And they can often go through and produce more, say, concrete within a shift period, an overnight period, than they have the ability to store the aggregates. That's what triggers the requirement to deliver when they are required to do big pours, such as large supermarkets, and they typically start at 1 a.m. in the morning and start pouring. That triggers the quarry to need to deliver out of hours.
Does it though? Does it though? That's my question.
Yes, it does. So we've had instances of that. Also, typically with large projects, the need to actually produce material is large projects. They are often wanting single product deliveries in large volumes. So that's an ongoing matter of production.
Yes. And you would bid for those projects, though, wouldn't you? Those large,
yes, we do.
As a supplier.
Yep.
And you would know when you've won it. You would know the time frame occurred.
We would, and we, to the best of our ability, build stock.
Yes.
But you're not always able to build enough stock to cope with the project. So project demands can get extremely high, typically for large loading projects, perhaps for airport extensions, things like that. And that requires you to continue producing basically every available hour in order to supply the large projects. They are not frequent, though, but they do occur.
No, but if the consent was granted on the terms sought, that would allow 6 to 10 p.m. to occur on 60 days a year, 1/6 of the calendar year.
I guess I would term that as not very frequent, but yes.
Okay. I hear what you're saying, Mr. Walsh. I'm not going to say whether I'm convinced or not, but I guess some more discussion on that in the right of reply would be useful.
Okay.
It's a matter of that condition framework that I raised with Mr. Baker earlier.
Yeah, it's a matter of matching our productive capacity in the quarry against the demand of a project.
I completely understand that, and all I'm saying is why can't that be programmed and planned for? You're saying you generally do try to do that and have stock available, but it's not always possible to achieve that.
Correct, and there's quite a few logical reasons for it. When you're producing one grade of aggregate, basically smashing a large rock into smaller rocks, you also produce a host of other products as well. So typically you can't just produce and stockpile one product. You have to do the range of products. Hence, by focusing on one product, you actually fill your available stockpiling area with many other products at the same time.
Understood. I think it's going to be useful to have this distilled in writing, Mr. Matheson.
Yes, thank you. And I think it is also, we also need to cover the, as Mr. Welsh said, the transport issue and the storage as an issue as well, which I think is a separate issue. But
and also, I guess, the what that 6 to 10 would actually permit in terms of, I mean, presumably it won't permit blasting because there's a condition on that. It won't permit blasting, but would it prohibit the actual extraction?
Well, that's right, and I think, I guess really need to hear the noise evidence about that in terms of, noise limits that are coming up and there's certainly no suggestion that, Fulton Hogan wouldn't want to be doing that if it was going to breach noise limits at all, and given the nature of this particular quarry, it is well suited to that, and it's not as if we're seeking 24-hour operation either. So
I understand that, but that's why I went to Mr. Hunt, because Ms. Walkering has suggested compliance is achievable. Mr. Hunt's suggested it may not be that simple. So some discussion between those two experts would assist between now and tomorrow afternoon.
Yeah, thank you. Understood.
Mr. Hunt?
Yes, look, I've just been doing some preliminary analysis and we've sorted out with Siri we're going to have a meeting.
Thank you.
But my question is that a key factor is this reduction due to the traffic experts agreeing on a lesser number of movements.
Yes.
But I am unclear.
You want some direction on that now?
Well, the thing I need direction on is that's a limit on left-turning vehicle movements. How does that relate to limitations of use of the main access road?
Yes, that's a good question.
Well, yeah, short of the trucks turning left and then parking up and then driving up to the quarry, every truck that turns left will go up to the quarry, and by and large, every truck that turns in will leave. So the reason the limit's 30 in is that was the concern from traffic perspective, but 30 in per hour is 60 movements per hour. So that's what's been assessed.
But what if they...
Rather than 90 movements per hour. So it was 45 in, which is 90 per hour.
That. Do trucks not come in the other direction? Or go in other directions?
Well, they come and go from both directions, but once they're on the accessway and causing noise, they're travelling either up or down the accessway.
Yeah.
Sorry,
the clarification I'm seeking is how can the noise experts take on board the reduction in traffic movements which have been agreed to among the traffic experts?
Sorry, I understand your question now. Apologies, that's probably me lacking food. So the 30 left in is actually a limit of 30 per hour in on the accessway as well as left in. Yes. So if some come right in, then that comes off the limit. Because the limit on the accessway is now effectively going to be 30 one way, so 60 per hour on the access. So from a noise perspective, it's 60 per hour movements.
Karen sent me a copy of the updated conditions. The only thing limiting vehicle movements as far as I can see is this left-hand manoeuvre. And that no separate limits based on the number of heavy vehicles on the access road.
Yeah, sorry. And the further subtlety, which is why it would be useful to sit down maybe with Mr. Baker as well, is that in the evening it's much lesser amount, of course. It's not 30, it's 12.
Yeah.
Mr. Hunt, you're quite right to raise these matters, but what I suggest is that the four of you sit down, and so Mr. Baker, Ms. Williams, and establish the parameters to start with, so that you're comparing apples with apples.
Well, I think that the council's traffic expert needs to be involved, to be honest, because I'm not a traffic expert.
No, they will. Yes, okay. Well, that's fine. I mean, they're already agreed to undertake some conference, so it's just a matter of finding a window of opportunity there. I appreciate it's a moving feast. People are hungry. But and the timeframes aren't that conducive, but it will hopefully help focus the discussion. So can I leave that with Mr. Baker and Ms. Williams to organise discussions with Ms. Wilkering and Mr. Hunt, and to the extent that it's necessary, Mr. Kelly and Ms. Fraser. Now, it would be ideal that Mr. Wanty was involved also, but that's completely up to him. Okay, it's gone 1:10. I think I'm there. Let me just bear with me for a minute. Here we. Yes, there was just one final matter, and I should have mentioned that an hour ago, and that is for you, Ms. Walker. I'd be very keen when you're presenting on Thursday, if you could have a close look at, let me just give you the references, at Mr. Matheson's legal submissions at 427 to 434, where he looks at the legal principles governing duration, and then at 627 to 629, where he applies those principles to this quarry. And we'll have some questions on that as to whether you share or disagree with those parameters.
Okay, thanks for that.
Thank you. Okay, on that basis, look, I'm conscious that we're not travelling to time, but I think we can make some progress throughout things. So is 35 minutes insufficient for lunch? People like longer? We come back at 1:45? Thank you, everybody. Everybody, slightly late beginning. Just a few housekeeping matters, Mr. Matheson and others. Before we go to Mr. Nation, Commissioner Burge has a couple of follow-up questions for Mr. Walsh, and we'll come to those in a minute. I can also have some administrative announcements. And you may be aware of this already. There's an email here from Professor Irons confirming that she has advised that Mr. Monty will be attending the conferencing. He has some time constraints. Yes, okay. Well, it looks like there's some problems, but an endeavour, it appears that an endeavour will be made for Mr. Monty to be present. Also, you might be aware that there was an instruction that any legal submissions were to be filed on Friday. Ash had chased up Mr. Stephen Irons. He has now confirmed that he does not intend to file any legal submissions and that he intends to endorse those filed by Professor Irons. So that's the latest on that. I hope this doesn't come back and bite me, but I'm pretty confident that we'll get, once we've dealt with Mr. Nation, that we'll get through Mr. Robertson, Dr. Mulling and Mr. Pope before we adjourn. And if we have to sit a little bit longer, I think we'll make that endeavour, just in the interest of getting through everything tomorrow. So on that basis, Mr. Walsh, Commissioner Burge has a couple of follow-up questions just for you before we go to Mr. Nation.
Thank you. We were, just before we broke for lunch, we're talking about, evening activity and what that might involve. But just out of curiosity, do any of your other quarries operate at night? And if so, what sort of hours, parameters and setting is that?
Right, so yes, we do have a number of quarries that can operate through the night and do. And then, but in this case, we are talking about evenings, of course, and we have a number of quarries that operate into the evenings as well. So they range from Auckland City, so quarries there, definitely running through the night, actively running through the night, and both currently not, another quarry currently not operating during the night, but consented to. In the Waikato, we have both quarries that are enabled to operate as of right 365 days a year through to the late evenings. One of them is adjacent to a township, rather large township, Ngaruawahia, and the other is in a rural environment. So it's not unusual.
When you say late evenings, Mr. Walsh, can you be a bit more specific?
That particular one, the rural setting is 9 p.m. at night, for 365 days a year.
Yes.
And the one at Ngaruawahia, I think, is 10 p.m.
Okay. If that's not the case, could you just confirm that subsequently?
Yep.
And just to confirm, none of the ones in Wellington that Fulton Hogan manage operate in the evening or through the night?
I'd have to check that for you. So we have one joint venture quarry.
Okay, if you wouldn't mind checking, that would be helpful. Thank you.
And which quarry is that, Mr. Walsh?
Horokiwi.
It is Horokiwi, yes, okay. What was the situation with the Roydon quarry, Mr. Walsh? Can you recall?
No, I can't recall actually, because we're not actually up and operating.
No,
but I'll check on that as well.
In terms of consenting, yes. Okay. Thank you.
Thank you. Just quite similar to this, and and I could get the consent if we need to, but the Clevedon Quarry in Auckland, which is consented to be expanded, so that was pretty sure 24 hours operation and 60 nights a year. So that was the quarry is in a similar position, and it's very well shielded upper valley. And the issue was traffic movements. They went along Clevedon Road and out onto the state highway. And that was a similar sort of setup, permanent operations, but a limit on the traffic in that case, but to 60 knots.
I could see a site visit being necessary there, Mr. Matheson, for the panel.
Yeah.
Is that Clevedon as in the Oysters?
No, close. Hang a right, not a left. Just one other matter, if I may, just tidy this up. So the letter received from Ngāti Toa and Taranaki Whānui, I've discussed that with my client, particularly, and with Fulton Hogan particularly. They're happy for that to remain on the file, but they will be responding to it. And I think that's appropriate. They do get a chance to respond to it, and I think it's appropriate to be responded to by a letter too, rather than evidence, given it's not actually evidence. The position that will be explained in the letter is that as far as Taranaki Whānui are concerned and Phil Site 2, that was an oversight and that's been apologised for, and that was just where it was sitting on the catchment. It was an oversight. Ngāti Toa contact was first made in February 2021. So that was after the short-term consent application that was put in under some urgency to preserve that. And there was attempts to so that was the initial contact. There was attempts to contact, and the first meeting, I think, was about July 2021 as a result of COVID and the Ngāti Toa person being absent. And just in fairness to Ms Nin, that was a previous person at Ngāti Toa that was involved. And but I think it's important, given the comments made in the letter, that that's clearly set out in a response. I mean, it wasn't helped by absence and COVID and other things, to be fair, but I just didn't. There seemed to be a suggestion there that this was all very last minute and late, and certainly that wasn't the position. So, and again, that's not derogating at all from the desire to actually work together and come up with some conditions, and we want to work together. Fulton Hogan wants to work together, but it is important, given the letter's been sent, that there is a response.
Sorry, Mr. Matheson, when you say a response, would that be a response to a letter to the panel or a letter back to the iwi?
Well, I mean, my preference is that it be back to iwi because and just clearly setting that out. But equally, it should be copied, I think, to the panel. It needs to sit on the record. If the letter's going to be on the hearing record, then that needs to be there as well, I think.
Thank you. And I should have asked this earlier. Was it a reference to a Mr. Easton? Was there?
East Ham,
sorry.
Was that sorry, I normally call Mr. Eastham Dale, and he's sitting in the back, so he's at Fulton Hogan as well. So he was involved in a lot of the consultation as well.
With Ngāti Toa.
Yeah.
Thank you. Sorry, Mr. Eastham. It's as simple as it sounds, is it, in terms of the spelling? And what's your position, Dale? Based in? Thank you. I don't think there's any other matters. Any matters from the councils? No? Okay. Mr. Nation. Mr. Nation, go on. Thank you for your patience, Mr. Nation.
Well, it's just it's good that it's your lucky day because I'm a fast reader and there'll be no questions. So we'll make up a bit of time. So anyway, I've been managing Willowbank Farm for the last 13 years tomorrow, actually. Willowbank Farm is owned by a company, Willowbank Trustee Limited. The shares in Willowbank are held by the trustees of two trusts, namely Willowbank Farm Trust and Willowbank Forestry Trust, collectively Willowbank. So
Mr. Nation, can I just interrupt?
Sure.
You're reading from a brief. Is that part of the summary statement? What are you reading from?
Yeah, this is the summary statement. This is the statement of evidence that I sent through.
On Friday?
No, I didn't. You didn't want one from me.
No, sorry.
Oh, okay. Oh, right, sorry. Yep. Yeah, well, that's going to make it even faster.
Dated.
Yep, that's it.
Sorry, I should have checked. I'm assuming that's okay with the panel. I just thought we're taking that approach with it.
Yeah, no, just let me get a copy of
No
that.
worries.
It was dated the 29th of July, so it's your evidence in chief. Okay. Right.
Yep.
Please proceed.
So pretty much it's 650 hectares as Willowbank Farm, and we've got 78 hectares of mature pines and 60 hectares of native bush. We've gone through an erosion and sediment control with Greater Wellington Regional Council, planting 1,300 poles and poplars over the last, since 2017. I won't go into the details of how many sheep and things we got because it's probably not that relevant. Community involvement. We always use local contractors for everything we do. Helicopters, scrub cutters, mechanics, everything. We support all the local businesses. I'm a member of the Guardians of the Patanui Inlet, as well as the Patanui Residents Association. We support the local garage, the rural trading post, and the general store. Even though we've had no children, we've always participated in the Patanui School Lamb and Calf Day, which we've done for the last 13 years. We sponsor the local golf club as well as volunteer materials and machinery. So we are very community minded and we're actually very active in the community. I don't know how much you want to go into about the history of the quarry, but I presume you've read that. So unless there's any questions that you might want afterwards. Yeah. So the initial opening of the quarry was just done. We were approached by the joint venture, who were investigating disestablished quarries within the Porirua City region because they knew they were going to be short of rock and desperately needed it. It was a long process for us to make our decision, but yeah, the decision was made to help them and get that underway because they were so desperate. It was to be for a short term, there's no doubt about that. Because of the economics of farming, which are obviously not very economical, it was we all sat down and decided that maybe we should look into the long term of quarrying, what triggered that was we were getting lots of phone calls, from various operators all around the country, individuals, contractors, and large companies, and that's what triggered that in our minds. We decided we did a lot of due diligence, went with Fulton Hogan because they had the best track record, they were good environmentally, and they were professionals at what they did. So that's the reason why we went obviously along with them. We've got the Pig Gully enhancement. We've already planted 26,000 native trees in the area on the farm, wetlands and other major gullies, and that will obviously going to continue. It enhances because obviously it is a steep farm, so it's certainly a lot better than the cattle running around the sides of the big steep hills. We do have historic non-compliances that we're dealing with, and we're working through with Fulton Hogan and the Greater Wellington Regional Council to do those. Following the abatement notice, we did send a reply to Greater Wellington Regional Council before the due date, and we've just today got the response to say that that's all taken care of now, so we're all up to date with all that. So there's no outstanding issues. The entrance is obviously a big bone of contention. We did it right away with the kennels. They had a very high accident rate outside their kennels. I don't know if you took much notice, but of their old entrances yesterday, but wasn't very pleasant compared to what they got now. So we've worked them well. We were running 64 trucks an hour previously, and never we haven't had an incident, never had an incident with them or with any other member of the public. Where can we go through? Yeah, so the track was, so going back to the bund that we were talking about at the bottom, which has been brought up before. We worked in with visual experts from PCC and from our side, and it was decided originally that we were just going to integrate that bund in with the paddocks because that's the valuable side of the farm. And now, as I say, there's been mention of planting of it, which I can't really get my head around why we need to do that. So I'm hoping that's going to be pushed back. We've talked about that. So last, I guess the only other bit was my final bit at the end. We are a working farm. We've been there for years. We plan to be there for a lot longer. And working with this quarry is going to ensure that. Otherwise, we're going to end up with Plimpton farms up there, which is not really what everybody wants, really, in a real setting. That's probably that's about it. So let's move on.
Unfortunately, people get to ask you questions and you have to answer them too.
I tried to make it brief so there were no questions.
Commissioner Burge has offered to lead off the questioning, Mr. Nation.
I'll be this very easy.
Yep.
So just in terms of the mitigation bund,
Yes.
on site visit yesterday, so we could see where it was going to start and finish.
Yes.
And there's a row of conifers there now that I'm assuming the farm planted.
Yes.
Yeah. So they will obviously be removed. That fence will remain. Is that?
The fence will be in the middle of the bund now, for instance. So that fence will be removed.
Yeah.
The bund will be built, and then the fence will be put on top of the bund.
On the top of the bund.
Yeah.
Okay.
Yes.
Yeah. And that would slope down into the paddock.
Yes.
Yeah. And that will be regrassed, and you will just
graze it
as you do.
So it'll pretty much just be what's exactly on the other side of those trees.
Yeah.
Yeah.
Sure. Okay. The only other question, I have two more questions, sorry. One was in the next paragraph there, you talk about Willowbank undertaking your own pest control.
Yes.
And so I'm just wondering how that's going to work into the future. If, you're busy on the farm, you've got a new area of pest management that you need to then work. Is that feasible? And how do you do it? How do you work it into your normal operations?
It's good that you asked that because I've actually got 6 children and 15 grandchildren, and they all like to go out hunting. So, getting people to go night shooting and do that sort of is easy. And we also do the we've got those chirp traps that, as I mentioned, with rats and stoats and possums, but not possums, but mice. It's not an issue. I've got that.
So that's the animal side.
Yep.
So there's also plant pests too.
Yeah, we deal with the animal side of it. They'll deal with the plant pest side of it.
Okay.
Yeah.
Yep.
And also we've have talked about it with local school groups, trying to get them interested to see whether they would, if you paid us a certain amount as a donation, they'd come out and get involved with and learn all about the ecological side of the streams and everything as well.
Yeah. So the name Pig Gully, is that going to remain? And is that because of pigs, presumably?
It's been, it was named Pig Gully before I got there, so I have no idea why. Yeah, we actually did used to have pigs years ago, at my workplace, years ago, but we don't have any anymore, so that could have been the reason why. But yes, the name will remain because there's this big sign there. Yeah.
No, it's a very, it was good to have an appreciation of the area yesterday. It's an incredibly steep spot. Yeah,
it is. Yeah.
No, thank you. That was all I had.
Thanks, Commissioner Burge. Commissioner Mark Brown.
Just got a couple from me. At the end of your presentation, you said something about, I didn't quite hear what it was, but you said if the quarry's not there, then something's going to happen. What was it that you said about what would happen to the farm if the quarry didn't go ahead?
Yeah, what we don't want to see is it being another Plimpton Farms.
Plymouton Farms, what's that?
Oh, sorry. So that's a rural farm that's on the northern sector by Plymouton.
Yeah.
And once again, because of the restraints on farming, it's all going to be all subdivision. And
I see.
Yes.
Okay. Yeah.
That's
Like subdivision. Yeah. Okay.
Yeah, that's where I was going with it. Willowbank's goal is to keep it a rural farm for as many years as we possibly can.
Yeah. And my other question relates to land instability. Didn't notice so much going up around the quarry, but driving up Murphy's Road, looking across towards the quarry, it probably wasn't Willowbank land, but there were one or two slips, that were quite apparent.
Yes.
Presumably that just happens after prolonged wet weather. Is that? Have you got anything else you can add about the slips and why they happen and whether that's sort of just a common occurrence around there?
No, you're quite right. That happened after the rain event back in June.
That big one.
Yeah,
right?
the rain that we had. Yeah, it did. And yes, we did have quite a few slips, and the whole of the whole Wellington region is still having slips, as you're well aware. And that's the importance of the pole planting that we do.
Okay.
Any new slips like that come on, we regrass and we go in and plant poles to try and stabilise it.
Yeah, I did notice quite a few pole plantings and gullies up around the quarry, so that seems to work quite well.
It does, yes, it does, yeah. And the only other time that we've had major slips have been a few years ago. We had a big earthquake, and then we had the big rain event afterwards, and that opened up cracks in the ground. And yes, but we're not. Yeah, there's a lot of them around the place, as you know. But yes, we do mitigate those we'll try to.
But pole planting generally successful.
Yes, yeah. And we're planting a lot of them also in, because after 13 years, where all the underrunners and things are, and also in old scars where there potentially is for, so that's why it's such a long-term project.
Yeah. Okay, thanks. Sorry.
Mr. Nation, just from me, a few things just about the history of the quarry, and I appreciate you've been the farm manager for 13 years.
Yep.
So around 2010, 2011?
2009.
2009, sorry, my math's not that good, is it? 2009. You do in your evidence, though, take us through the origin of the quarry going back to the wharfs back in 1993.
Yep.
And I'm just trying to get a feel for what happened between 1993 and 2005. Was there continuous operation through that period, or was there some discontinuation?
It stopped in 2000.
Stopped in 2000?
Yeah, it was the Environmental Court closed it down then.
Yes, so there'd been an initial consent in 93, and there was a long-term consent applied for in 98, but that was withdrawn, I believe. Is that correct?
It was the 98 one, was it? I don't know if it was withdrawn or whether that was...
your paragraph 3.6 says that 98 wharfs applied for a longer-term consent.
Oh, sorry, pretty much what we're doing now. So they hadn't... one for there, and then they applied for another extension for that time, for that quarrying. That's correct.
So in terms of continuous operation, 1993 through to 2000?
Yes.
And what happened between 2000 and 2018? It was when the last consent was granted, what was happening on the site, if anything?
When we bought it, well, pretty much nothing. It was just abandoned, I guess you could say. It was disestablished, yeah.
Okay. So what we saw yesterday was largely a combination of what happened between 93 and 2000 and then between 2018 and today.
Pretty much what you saw yesterday was everything that since we've been quarrying in the last 3 years. Okay. There was a pit there, but it certainly wasn't as big as what it is now.
So okay. So what's there today is really a reflection of the 2018 consent.
That's correct. Yeah.
Thank you. Okay, and just in terms of the bund, did I hear you say that the conifers would be removed to accommodate that bund?
Yes, I know. Very annoying.
Yeah. They just seem to be getting a second growth spurt.
I know.
Going up there yesterday, right?
Yes, I know.
That's just an unfortunate...
It is. It's just the cost of doing business, apparently. But, yeah. We have looked at areas where we might be able to replant them, but whether they're too established, we'll try and do that. But,
okay.
Yeah, no, it is a shame.
Okay, maybe for a greater good.
Yeah, yeah.
Okay.
So were they planted to hide the access road?
That was part of the original
Yeah.
consent condition,
Yeah.
yes. Yeah, that's correct.
So were they part of a consent condition to
Yes,
do
it was,
that?
yeah.
as
Yeah, and that was part of the
mitigation?
mitigation for the neighbours down Murphy's Road there. It was more visual than obviously noise.
Yeah. So the length of those plantings is as per a condition? Because I'm just saying that, obviously some will be removed for the
Yep.
bund, but the plantings go on further from
Yep.
memory. So they'll remain.
Yep, they will. Yes, they will remain. That's correct.
So it's just the bund area.
That's right.
Okay. That was all from me, Mr. Nation. No re-examination.
I just had one follow-up, sorry, which
Yep.
I didn't ask before, but there's been talk about, and from various sectors, about some sort of covenant over the Pig Gully area. Is there a commitment to put some sort of covenant over that, or is that just something that's mooted?
No, I believe that the plantings that we do will be all in perpetuity, yeah.
So you don't know what sort of covenant you would use to protect that area?
No, I don't know what legal... I don't know what it would be, but yes. All the plantings that we've done so far have all been for perpetuity anyway.
Yeah. So maybe if somebody could follow up on that about what the covenant is proposed for that, protection-wise. Thank you.
Presumably, Mr. Matheson, Mr. Bird's thinking about QE2 covenants and the like, or whether there's any other legal instruments.
Yeah, I've had occasion to look at that lately. The QE2 ones are a bit trickier than normal covenants. I mean, the current wording, so it's condition 65, and it says the mechanism will be specified in the management plan to then be approved by council. QE2 covenants for these sorts of things are a bit trickier because QE2 only want them in certain circumstances and they contribute to some costs, and this is more probably be in favour of the council in a normal situation. So, but we can cover that. I'll discuss it with GWRC.
Is it a GWRC or a PCC matter? Both.
Yeah, well, that one in particular I'm pretty sure that was GWRC, but it might be.
Yeah, if I may, it was a GWRC condition.
65. Thank you.
But also,
Ms. Williams?
Yeah, note that condition 83 of the council, Porirua City Council.
The equivalent?
The equivalent, yes.
Thank you. And you're probably wondering, I've now finally got a coloured copy of the 12th of August track change version of the conditions, and I also have Mr. Baker's summary statement, which focuses on some of those conditions also. Mr. Baker, there's no mismatch between your 12th of August summary statement and the 12th of August draft conditions, are there?
No mismatch.
No, thank you. It's a relief. Mr. Nation, I think that's all for you. Thank you for your time.
Off the hook, thank you. Next up, Mr. Robertson, I believe. If you've got his evidence.
Yes, just bear with us. Just to explain, my evidence, even as the chief, came in two batches. I had a duplication of about half the witnesses the first time, and then the second batch was the missing bit. So I'm now just reading your evidence, chief, online, Mr. Robertson. But I do have a copy of your combined summary statement and rebuttal evidence in front of me also. So I'm in your hands as to how you want to approach this. Generally, what we're suggesting is that you paraphrase or take us to the main points in your summary and rebuttal, and we'll have some questions on that. And if we need to go back and backfill that in terms of your evidence in chief, in terms of questions that we've already identified, we'll do that. Does that sit okay with you?
Absolutely. Yep.
Okay. So we're in your hands on your 12th of August statement, which are some 17 pages. Probably the longest summary and rebuttal statement of all your colleagues.
anyone who knows me, Commissioner, probably isn't surprised by that. Look, to keep it brief, briefer than the summary. Look, I think Mr. Matheson hit the nail on the head with regard to landscape, and particularly the outstanding issues between Council's landscape architect, Mr. Button, and myself.
Actually, I'm doing you a disfavour. I was reading Mr. Baker's summary, not yours.
That'll be extremely long, surely.
Yes,
Guilty.
Yes, yours is much shorter by comparison. Sorry for the interruption.
The point of contention between Mr. Button and I is really around the treatment of the bund, proximate to the access way. Hopefully, in my evidence in chief and my summary, I've made a decent enough job of pointing out where we are in agreement and where we are in a disagreement. And in those areas where we are in disagreement, I don't see it being particularly material to where we've both landed in terms of the appropriateness of the proposal and landscape and visual.
Why don't you take us through that?
Yeah, absolutely. So, in that regard, there's essentially three elements of the project that have the potential or are substantive, I guess, in landscape and visual terms. The first one's the Quarry Pit extension itself, where there is agreement that there'll be a low moderate degree of effect. And just for clarification, when I use terminology like low moderate, I am referring to industry standard around assessment of landscape effects in the NZILA's guidelines. So hopefully you've got some degree of experience.
I'm very familiar with that colour chart that comes with that. I've seen the extract used in a number of evidence.
Yeah, well, that's good. So, look, and happy to clarify if it doesn't make sense anywhere in terms of the terminology used. But fundamentally, we are expanding an existing quarry. There will be effects on landform due to excavation. Those physical effects will be moderate to high. It's pretty hard to deny that when you're excavating back into existing landform. Low perceptual effects, and that's a direct result to the location of the quarry and being pretty much screened from the vast majority of views from the surrounding landscape. And in my evidence in chief, we do touch on the likes of Belmont Regional Park and some of the other localised views of the quarry site, and particularly of the fill site. I'll come to the fill site in a moment. So moderate high degree of physical effect, low perceptual effects, and overall agreement between Mr. Button and myself that's an acceptable degree of effect for the quarry pit itself.
I know experts such as acousticians and other similar scientific-based expert disciplines are very reluctant to translate their own industry language into RMA speak. But I'm going to invite you to do that if you see it fit. What I'm trying to ascertain is, what does low moderate mean in terms of an RMA regime?
Yeah, minor. And in fact, I think I don't recall the case directly off the top of my head. It might have even been Long Bay. There has been a discussion around the terminology used, and of course, the danger is that it starts to get used on an effect by effect basis. So you've got a visual effect over here that's minor, and then one over here that's more than minor. So we do try and keep it in the overall in the balanced context much, and I know you'll appreciate that, Commissioner, given your professional background. But fundamentally, it's accepted that minor is low moderate. Anything over that is more than minor, and when you start to get up into high and very high, we start to talk to those as being significant effects.
Right.
And then low and very low, getting down into negligible.
Well, can we just work through that in relation to the Quarry Pit expansion? So I'm pretty sure we're dealing with your summary evidence here. There are two elements there: the moderate to high physical effects on the landform, and then the low perceptual effects, presumably out of sight, out of mind concept. But how have you then arrived at an agglomerate rating of low to moderate? Is it simply because you've got a physical effect that's moderate to high, just more than moderate, combined with a low perceptual impact? How have you arrived at your low to moderate overall rating?
Well, it's not a purely quantitative. It's a judgment call, basically.
Right.
Is the short answer to that question. And I think the fact that it is just so isolated and is out of sight, out of mind, as you put it, definitely does, play a big part in that final assessment.
Okay, so just so I can understand, if at another site the physical effects were moderate to high, but the site was not as encapsulated or hidden, if you like, in a depression, that would presumably give rise to higher perceptual effects.
That's right.
And the visibility.
Correct.
Yes, and that would presumably result in an overall judgment of a higher rating than low to moderate.
That's correct. And in this one, it's important to acknowledge that perceptual's more than visual. It's the experiential components as well. And so that's the being next to things and hearing things and smelling things and feeling things. And given the location of the quarry, a wee way away from publicly accessible points, that plays into that low in the perceptual space as well. But as you've touched on, out of sight, out of mind is probably the easiest way to think about it in this context.
Yes, and in any event, you and Mr. Button are on the same page on that matter.
That's my understanding, yes. Yep.
Okay, thank you.
So then we come to the overburden fill area, where I've assessed a low moderate physical effect. Fundamentally, we're placing overburden on top of an existing hill form, and a low moderate perceptual effect dropping to low in the long term. The primary issue here is around visibility from Boulder Hill and from Belmont Regional Park. Any other publicly accessible roads and things, I think you mentioned you've been to Harris Road, things are really screened from Harris, Murphy's even more so. There are some very, very distant views from State Highway 58 itself, but distance and the complexity of the landscape tends to play a pretty big part in the degree of those effects. So we're fundamentally talking about the visibility of the overburden site from the higher land to the south, looking down.
The Boulder Hill, I'm obviously where Belmont Park is. Where's Boulder Hill?
Pretty much due south, give or take a few degrees. And in fact, I think in my evidence in chief, there's a viewpoint location map that was attached that shows all of the viewpoint, not only the photos but also the viewpoint locations.
Yes, there is.
Yeah. So it's effectively due south from the proposal, halfway between the quarry pit and the fill site itself. And so the hill in question from those views is down in the middle, what we would call the middle foreground. So centre to the view. Predominant views actually right out over Pawataha Nui and the wider Porirua landscape. So it's quite an expansive view. And the fundamental issue that we've been discussing, Simon and myself, and obviously myself with the applicant, is around the treatment of the fill batters and the fill site, and particularly the landform, and a real focus on trying to achieve a landform that is as close to, is naturalised in inverted commas. And in that regard, it's always challenging to fully naturalise an overburdened fill site. So the focus has very much been on sticking to the current gradient ranges that exist on the current hill site, and with a particular focus on those areas that transition from the steeper hill face, what would I call the batter face, and then up onto the top part of the fill site. So, and that was attached. There's some cross sections and a model attached to my summary statement that illustrates where we've gotten to with that. And again, there's agreement between Mr. Bunton and myself that that's an appropriate response, and subject to condition as well. So, plans will need to be submitted, they'll need to be certified, and they'll need to be agreed with council that it's doing as intended. Lastly, four key issues, not three. Proposed bund, which we've touched on initially. I think it's fair to say that, in summary, I don't think, based on landscape character of the existing site, that vegetation of the bund is needed. I think what is proposed, particularly the revised bund profile with its more gentle slope and tying into existing landform, it will be pastoral. It is pastoral currently. It will be pastoral once the bund is constructed and grassed, I think is an appropriate response to the existing landscape character. Mr. Button, I think initially was proposing planting along the top of the bund, and then looking at his summary statement, it appears that he's looking at planting along the toe of the bund now. But my position, I think, to make my position really clear, I don't think vegetation is needed. I can understand why Mr. Button is proposing it. Been involved in a number of infrastructure-based projects where bunding is, and actually we've referred to Royd and Quarry. I actually acted on behalf of council in a landscape capacity on that project where there is extensive planting of those bunds right around the site, and the bunds are a lot more similar to what the profile of this bund, gentler slopes 1 and 3. I'm not generally supportive of bunds that are over a 1 and 2 slope because the plants just end up dying and you end up with these river stop bank type bunds where things just can't grow. So part of my involvement in the project, which I described in my evidence as chief, was saying to the applicant and to Paul, I didn't think that more geometric approach was appropriate in this setting, either both from a character perspective and a viability of the planting perspective. That obviously is a comment made in 2 contexts. One, we don't want the person responsible for the planting to be going back every 3 to 5 years because they've had wholesale mortality. Plus, we don't want to be talking to residents and adjoining landowners about things and painting nice pictures and putting green stuff everywhere where that's not what ends up being the case. So I was, from my perspective and my experience, and because of the landscape character exhibited at the site, I think having a bund that is more pastoral in its appearance is an entirely appropriate outcome. And obviously it's achieving the mitigation from both a noise and a visual perspective that it's intended to achieve, I think regardless of what long-term planting might offer. I will say though that I do understand, Mr. Button and I have spoken about this on the phone on a couple of occasions. I do understand where he's coming from. He's also suggesting that the landscape character and the proliferation of vegetation, the wider landscape and shelter belts and all of those sorts of things are also reasons to plant the bund. I think we've just got a good old-fashioned disagreement of opinion on this one. Fundamentally, I think that we do agree, though, that the bund as it currently stands and is revised and added to my evidence is the most appropriate profile of the bund and extent of the bund as well. There's a bit of work done around the extent of the bund and rationalising that on site.
Okay. Can I ask you to just pause there? On the first 2, was there any questions on 3 and 4? Yeah. Okay. So just checking on whether Commissioner Burge wanted to ask you any questions on your evidence of chief, but we'll come to that at the appropriate time. But I just had a question on the bund, though. Did I hear an answer to a question earlier that from Commissioner Burge, I think, to one of the earlier witnesses, that there would be fencing on top of the bund?
Yeah, so I'll be honest, I wasn't aware that the fencing was going on the top of the bund. And as you'll see from the cross sections that we prepared, the fencing was going to stay on the back side of the bund, yes, closest to the road. At the risk of being on the fly, I think what we're talking about here is a post and wire fence. So again, we come back to this character discussion. Having a change or seeing a fence isn't necessarily an effect. And so from my perspective, if it was a closed, and this was part of the reason why we recommended removing closed-boarded fences from previous iterations, because they are out of character with the local rural setting. So I don't think that having a post and wire fence necessarily on the top of the bund is a huge issue, but my assessment has been based on the fence being on the back side of the bund closest, yes, to the road.
But you would not support a close-boarded fence on top of the bund? No. Are you familiar with the Aidenfield development in Christchurch?
I am, yeah. Yes, I am.
There's a bund and a close-boarded fence along the boundary of State Highway 75, which is the Christchurch-Akaroa Road through Horswell. You familiar with that?
Yes, I am.
Yeah, and similarly, I think there's one in Rolleston along State Highway 1.
Yeah, I'm not a particular fan of the Rolleston one,
no.
Commissioner. I'm familiar with that one as well.
No, okay. Are you suggesting that would have a counterproductive impact on visual amenity?
Yeah, I think you've got problems if your mitigation measures are creating effects.
Yes. Okay.
And I think in those settings, particularly in this setting, I think in the Aidenfield, and I can't recall if I've mentioned in my previous evidence, I reside in Christchurch, so pretty familiar with those locations. They've changed a lot now, but certainly when they were put in place, I think that's a resolution that's just entirely out of character with those settings, and it would be even worse here, in my view.
Yes, I'm certainly in answering that question. I wasn't condoning that. I just wondered if you're aware of it. For the record, there is a McMahon Drive in Aidenfield, but I can say there's no relation.
Oh, I was going to offer my congratulations.
Okay. Do you want to take us on to the fourth matter now?
Yes, the final issue around increased truck movements and specifically at night time. There is agreement at time on the level of effect. It's the night time or evening times, as it's more appropriately termed and discussed. And so I think in my evidence, I did touch on some of the challenges around the starting points between the two landscape experts when it came to nighttime or evening time operations and the use of lights and what our LVA was based on in terms of movements and light usage and what Mr. Button's original assessment was. I think that's a bit of a moot point now. I think we're both operating off the same parameters for the evening time operation during that 6 to 10 p.m. And I assess the daytime effects as low, moderate, and nighttime effects as low. I think primarily on the basis of the restrictions that have been put around the number of truck movements and the operation and the number of operational nights during the year, which has been discussed. So I won't labour that too much here in terms of what they are. I think the bund does play a big part in that. I think those properties at the lower part, adjacent to the access road, directly adjacent to the bund, are heavily reliant on that measure for those effects to be generated. The other thing I think too that you may have appreciated having been out on site and on the access road is the other factor, two factors actually that play a big part in the impacts of lights predominantly. It's predominantly lights in terms of visual effects at night, spilling into properties, but also being visible up and down the road. I think the geometry of the road and the distance of the viewer from the road plays a big part. And I think that for a lot of those properties that are located at the top of Murphy's Road, the geometry of the road and the travel of the vehicles, particularly now that there's high beam restrictions put on and no flashing lights, I think that's very low. I don't think that's going to be a substantive issue for a lot of those properties. And I think for those lower down, I definitely think that downhill truck movements, based on the way that the road snakes through the top of that ridgeline, that's the real substantive issue that we're trying to manage here from a light glare perspective at night. So that's why the bund is quite important to be located where it is located and to the extent that it's proposed.
Could I just ask you a couple of questions on that?
Absolutely.
I understand what you're saying in relation to the 6 to 10 p.m. Time frame, but would the same apply to the winter time frame of 6 a.m. to 7 a.m. in terms of lights?
I think they'd be comparable in terms of the environment. Yeah, yes, I do.
Okay. Could you just direct me to the conditions that control high beam and no flashing lights? Ms. Williams might be able to beat you to it.
There's probably a few in the room that'll succeed in that. I'll just get my hands on a copy if that's all right. While our team's looking for those, Commissioner, I believe they are included in the traffic management plan provision.
Yes, 67 onwards.
7 onwards.
And they're struggling to see them.
Condition 21, which is the quarry management plan, refers to we go. Yeah.
Minimise visual effects from nighttime truck movements on the access road, including restrictions. Okay. Okay, so that's something that the management plan has to address, as opposed to a prohibition on high beam lights or flashing lights. Am I correct on that? Yes.
It's currently how it's drafted. Yes.
Yes.
Yep.
Just like to ask you a question on that, if you wouldn't mind, Mr. Robertson. How critical, in your view, is the control of high beam lights and flashing lights in both that nighttime period and that winter morning period?
I think they're very important.
Yes.
The assessment from the outset has assumed, rightly or wrongly, has assumed no flashing lights.
Yes.
So since we did the original LVA right through to now,
yes,
flashing lights only really came up, I think, when Mr. Button raised it in his original evidence.
Yes.
But I see them both being pretty important, and particularly high beam, as I've described, for the yes, properties at the lower end of Murphy's Road.
Yes. The reason I asked that, and I'm not trying to be clever here at all, it's just that the management plan sets an objective, which is to minimise visual effects. It gives an example from nighttime, including restriction on the use of high beams and flashing lights. It talks about a restriction on the use. It doesn't talk about an out-and-out prohibition of the use. And I guess the question I have for you is, would you take more comfort from this matter being dealt with as a bottom-line condition, as opposed to something that the management plan will deal with in order to minimise effects?
I think we always take more comfort from certainty, Commissioner. Yes.
Okay.
Obviously, I don't have any understanding of what the working implications that are from a Quarry perspective, but from my perspective, where we've landed at the moment in terms of the effects is absolutely on the basis that high beam and flashing lights won't be used. Yep.
Mr. Baker, this probably sounds like semantics, but I guess this is one example of the difference between bottom line conditions and management plan conditions, where the bottom line specifies an outcome and the management plan specifies an outcome that might be achieved through some minimisations, and it goes to certainty. So I wonder whether, if only from a drafting assistance point of view, whether you could convert D3 into a bottom line condition for the panel.
We're happy to do that. We're happy to commit to that.
Yes.
That was the basis for that was the
Yes.
understanding, and we're happy to make that a condition.
Okay.
It's a private access road, so
I understand.
we can do that. So.
Yes. I spent a bit of time on that one, Mr. Matheson, just to indicate, because there might be other examples that fall into those categories. So that's the four matters well, based on what you've said, a reasonably high level of alignment between you and Mr. Button.
That's right.
Yes. Obviously, the bund is something that there's some nuanced positions, and we'll test that with Mr. Button. Was there anything else on your summary that you wanted to draw to our attention?
Oh, look, just that concluding statement, really, and that final paragraph 1.2.1, to say that adverse effects from a landscape and visual perspective will arise. We certainly don't have an assessment saying that there will be no effects of the proposal, and they will be discernible to some degree and to some people. But in my view, they won't be significant, certainly not up in that higher end of the assessment scale. And on that basis, I do consider that the proposal is appropriate and given the current landscape setting out at Willowbank Farm.
Thank you.
Thank you.
Any questions from the panel, remaining residual questions on the summary before we go to evidence in chief? No? Liz, are you happy to run on? So I'm going to ask Commissioner Burge to lead off any specific matters on your evidence in chief, Mr. Robertson.
Thank you. I just want to return to the bund issue, and I just want to be quite clear on the mitigation for it. I mean, you touched before and said it's to mitigate noise as well as visual. I just note in Ms Wilkinson's evidence, she's quite clear that the bunds are there for visual reasons, not noise. So I just want for clarity here is, are they, clearly they are for a visual reason, you've just explained that, but I also want to understand, you said they were there for noise as well, so I want to understand when Ms Wilkinson comes on, so maybe this could be passed on to her, we want to understand what it is that they're mitigating for a start. Yeah, and if it's a combination, that's fine. I just want to be clear. We want to have both people saying the same thing.
Yeah, my understanding is it's a combination.
It is a combination. Yeah.
And an example of that, Commissioner, is through the course of the process, site visits and refining that bund design was extended further to the north as well.
Yes.
As well as the rationalisation that predominantly related to my input, which was to the south, which we talked to Siri about with regard to noise.
Maybe that's what she's talking about, is the extension, maybe?
Probably that piece on the end.
That piece on the end,
yeah.
Okay. Yeah, so there is some noise mitigation going on with the rest of it. Not really a question for you, I realise that, but I'll save that. But I'm just interested that we had just a difference of opinion there.
Yes.
Yeah.
I wonder, Ms Williams, whether you could just pass this conversation on to Mr Hunt too.
Yeah, thanks. Sorry. Right.
Was this attached to evidence in chief? So there is I'll just attention being drawn to the plans that were attached to the original LVA, the landscape and visual assessment, the section of the bund. So there's the bund illustrated in yellow and orange.
Yeah.
The orange part is, my understanding is that's for noise, or that's the section that's relevant to noise.
Okay.
Particularly. Yep.
And that's attached to your...
That was attached to the application.
Yeah. This was part of the revised application, right? With the bund plans, with the revised bund cross sections.
Ms Brown, can you remember whether that was in volume 1 or volume 2? No. Oh, with the evidence. It wasn't with the AEE on the application as lodged. Okay.
Okay, so that's with the updated... Yeah. Okay. So, and I'll just harp on a little bit more about the bund while we're here. But so the fence on the top, as opposed to the fence at the toe or the base or the back, whatever way it is, you don't see any problems with the fence on the top?
I don't think it significantly increases or generates effect in of itself. I mean, I personally, I think from a visual perspective, I'd prefer for it to be at the back of the bund, roadside of the bund.
Yeah.
Not on the top of the bund. But at the moment, when you stand on those properties that can see the bund, you see a fence line.
Yeah. Sure.
On the crest of that intermediate ridge line where the road is located.
Yeah, I understand. So I'm assuming it's for farming purposes because will stock jump from the top of the bund? Would you mind just turning your mic on? Sorry, yeah.
Yes, and also on the bottom side of the bund, or on the back side, it'll be a lot steeper, so you're going to get erosion from stock and everything, say, along the top. And anywhere you look around the farm, there's a one of those fences running along the skyline somewhere.
Yeah.
So, yeah.
Yeah.
That's the main reason for.
Yeah, thank you for that clarification. Just in the updated project description that we got, it's not dated actually, which is a real shame, but at the back of it, it's got a landscape visual mitigation plan and it's dated June 22. That's that plan? Okay, cool. So...
We found it eventually.
So in that, yours looks different to mine. Mine's that one. That might be the page before, or yeah. So this is the one that I'm looking at anyway. Yeah. So on there, you've got a number 3 there. You're talking about some screen planting, but you haven't discussed that in your evidence anywhere that I've picked up. So I just wondered if you could just explain what that was for.
Yeah, so that's specifically for views from 233A, which aren't significant to begin with, but I undertook a site visit to go up and have a look at all of the previous mitigation measures, bunds and fences for the whole access road. Part of that was visiting that 233A site with the landowner, the then landowner.
Yeah.
And one of the observations that I was made is there is a short section of the access road beyond the bund heading up the road that is actually visible from their deck fundamentally. And over time, it's quite a distance away, so I didn't think that the effects were significant enough to warrant, mitigation at source. But I did think that there was some benefit in the longer term to put a section of planting through the top of that fence line to create a screen just to take care of that one piece of road. And that part of the reason was because the road actually bends away from their property, so I don't think they're going to get a situation at night time where there's lights sort of shooting up, towards their property. So that's just a bit of strategic planting to try and just ameliorate a little bit views from their living areas.
Okay. Yep. That's helpful, thank you. Sorry, bear with me with my technical challenging stuff. When you talk about landscape sensitivity, how does that get applied in an effects-based assessment? I'm sort of referring to your paragraphs 4.4 through to 4.11. So I'm just trying to understand landscape sensitivity and how you apply that in an effects-based assessment.
Bear with me, I'm just scrolling to the
that's all right.
4.4 point.
Well, it's just a question that popped out at me when I was reading those paragraphs. So it's not directly related to one in particular. It's just an overall how you do it. I'm not a landscape expert, so you're teaching me, if you like, how you do it. How do you assess landscape sensitivity when we're looking at an effects-based assessment?
So it's a methodology question, and it is one that has been directly canvassed as part of the Institute's upgraded guidelines. It's a little bit of a dark art, to be honest. But the thing that the guidelines actually pointed to more so than the consideration of sensitivity was people using it in a really mathematical way, where you could just draw a matrix that said sensitive and degree and kind of go, that's your level of effect, and it's just not that simple. But fundamentally what sensitivity denotes is just I guess it's your starting point for the landscape, and it's relevant to particular characteristics within the landscape, and then as you assess effects, particular effects. So if you've got a landscape that is really rare and is really intact, say from a landform perspective, has lots of nice geomorphological features and rocky outcrops and things, then and is unique in, say, a district context, then your sensitivity of that landscape is naturally going to be quite high, particularly to things like earthworks and things that impact on those things that make it quite sensitive. And sensitivity is inherently tied to identified values as well. So if it is recognised as a particularly sensitive landscape from a geomorphology point of view, it's really rare, then usually you get cues from other documents and other expertise as well. But fundamentally, the easiest way to consider sensitivity is it's an assessment that establishes, I guess, the starting point in the landscape and just how vulnerable it is to change. That's the other way that sensitivity tends to get described, is what is this place's vulnerability to change. The art then in the assessment of effects is to stay focused on the nature of the change and its impact on those values that make it sensitive. I think sometimes landscape architects get caught up in saying it's sensitive and we can't do anything, when a proposal might not have anything to do with the thing that makes it particularly sensitive to begin with. So there's a bit of.
Thank you. There was some submitters talked about, when you're down in Porirua or down at the Pawatanui Inlet, that there wasn't an assessment or a look at how that would look when you look back up. I mean, you've done it from the road and at the entrance to the quarry. I just want to understand, you know, further afield, like from those more sensitive environments where they're highly, you know, public, and how that looks coming back up to the site.
I think personally I've spent a lot of time in this part of the country. So I was based in Wellington for 7 years and was a co-author of the Transmission Gully NOR LVA assessments. So it was pretty intimate with the setting. I think distance, and from a professional judgment perspective, it gets to a point where you're just so far away from something that you can make an informed judgment that even though you might see a glimpse of something somewhere, it's not materially relevant to assessing effects. And so from my perspective, and I think it might have been something that's Mr. Button raised in his evidence, views from the Hutt Valley relative to the catchments, views from the Hutt Valley and also wider Porirua. I just don't think they're materially relevant to the assessment of the proposal. And I think that's another thing that from a methodology perspective that we need to focus on, is making sure that we're not setting this net really, really wide just for the sake of setting it wide, and then we end up giving people a whole bunch of information that's just not relevant. So I guess in that sense, there is a judgment to be made at the start. Some people use zone of theoretical visibility to do all that. I have an issue with those. They have their limitations in terms of what they portray. But I think in this instance, it's fairly obvious, given the nature of the landscape, that certain visual catchments are just a long way away. There's lots of intervening landform. It's a very complex landscape, and all of those combine to just suggest that the visual catchment actually is as we've defined it.
Sure. So that I did have a question about your zone of theoretical visibility. So you've just said it's not something that you apply, but others apply?
Yeah, look, the biggest constraint with ZTVs is it doesn't take vegetation into consideration. Mm-hmm. So it's purely from a contour perspective. And so you push the button and it gives you a big thing. And in my experience, look, and particularly in landscapes like this that are really quite complex from a landform perspective, and there's lots of vegetation in them, they don't tend to be particularly informative. In fact, they can send you on a bit of a wild goose chase. In flat landscapes where perhaps there's less vegetation or places that aren't as complex, they do have some validity in those sorts of settings. Yeah. And look, I understand that some people like to use them to just do a first desktop cut as well of their site visit planning. I guess that's just up for the individual to decide.
And that's not something you used in this situation?
Not in this situation. I have used them in the past. I have used them in the past on projects, and particularly early in my career when they were all the rage. And then one or two projects later realised that we could probably save ourselves some time and some effort and just get out there and get our boots on the ground and have a look around.
Sure. Yep. Okay. Thank you. That was two birds with one stone then. I just wanted to talk about fill area 2, and I know on the back of your summary, maybe if you could just take us through those final contour concept plans that you've got at back there, and just explain the differences. I'm not going to assume anything actually, you could just tell me. Just walk me.
No, it's actually the reason I'm smiling, because I was looking at Google Earth this morning in 3D view, and I was thinking to myself, there's possibly a way that we can make it easier for you to understand what's actually going on, particularly in relation to sort of the extent of the footprint in the actual view, what vegetation is being retained and those sorts of things. So I'm happy to put a little image together that I think makes that a little bit clearer.
That would be helpful.
What gullies are no gullies are being lost, but what small indentations are being infilled and those sorts of things. But fundamentally, what we're going to end up with is a section on top of the existing hill that is fairly consistent with the existing sloping landform till it reaches the point where it curves over, and then it just flattens. And one of the conversations that I've been having with Fulton Hogan is to make sure that what we end up with, and this will be subject to the approved plans, is not just something that's sort of laser level flat right, you know, that we do actually have some undulation, and I've talked to Paul about how that relates to his operation of the farm and the kind of spaces that he's looking for. So that's what we talk about, naturalise it. But from my perspective, the element that is the most relevant to making sure that it doesn't look like a big geometric landform is that front edge, that transition between the steep slope and the flatter slope, and making sure that that's curved. And what the cross sections do show is that we've set the expectation that we'll take the existing, I guess, transition profile and apply that to the future fill edge as well. It's a bit of mucking around for Filton Hogan, but I think in this setting, particularly in the context of SAL 005, the amenity overlay, I think it needs a little bit of a nuanced response.
Yeah, and that's what I was getting at too, was just how that all ties in so that it's complementary to the SAL. I'm also thinking from behind as well. So I know you just said about the front face, but the behind from like your views from Belmont Park. So don't want to lose sight of the back.
Yeah. Well, that's the one that we're actually most concerned with, because that edge is the one that's within the special amenity landscape overlay.
Okay, sorry, yeah.
Yeah, and it's also the one that the recreational walkers will give a look. So south facing basically is
Yeah.
But look, I think.
Sorry, that's what I was meaning as the back.
Yep.
Yeah. Okay.
All depends on where you stand, I guess.
Yeah.
But I think there's a really quick little exercise that we can do that probably provides you with a slightly better picture.
That would be helpful. Thank you. Yeah.
Just wondering when that might happen.
Tomorrow.
You always ask when the homework's due, don't you? Otherwise, it never arrives.
That's right.
I've been in that position myself so often.
Look, I think it's something that we'll gun to have done tomorrow. Yeah, I just need to get back to the office and make sure that I've got some resource to actually do it.
Yes.
So by the end of the week is fine, isn't it?
Yeah.
Well, yeah, let's have an update. I mean, if it can come in by close of business tomorrow, that would be ideal.
We'll aim for that.
Okay.
We'll aim for that, and obviously we'll be able to let you know if there's going to be a slight delay. It's not a task that should take a week. Put it that way.
No,
Yeah.
the reason why I have a slight preference for tomorrow is that just to give the availability for submitters and particularly Porirua Council to comment on that, and the availability of for Mr. Button.
Yeah, and now that I turn my mind to it, actually, and I'm looking at Peter, there might be some work that Phil's already done that we can just. So yeah, I think we'll aim for tomorrow. Close of play tomorrow.
Thank you.
Okay. Could you just let Mr. Button know that's coming? Thank you.
The bund that's associated with Phil Site 2, that's just going to be grassed in the long term. That's going to remain. It's not going to be taken away as such.
That's my understanding.
Yeah. So it will become part of the fill area.
Yeah, and from a visual perspective only, I'm unsure if it has any sort of overland flow path functions, but getting that bund in is really about screening from
Harris Road.
Yeah. And so from my perspective, from a visual perspective, if it was pulled over or pulled down and smoothed out once it was...
That's all right.
Then that's fine.
Just becomes part of the landscape.
Right. I think from that distance, and given that it's all going to be homogenous in its land cover, you're not really going to be able to discern the bund too much.
So I just wondered, when you did your assessment, we talked about lights a little while ago, did you... what sort of cap did you have on the truck movements at that time? Because I know we've moved a lot in truck movements.
We didn't have caps on the days, so it was basically all year, with the exception of public holidays and things like that.
Yeah.
And I can't remember off the top of my head what the movements were. 45, wasn't it? Yeah.
Okay.
So the original assessment, that's what that was based on.
Sure. You do rely on the nighttime visual assessment that Bothamiscal did in February 2020. Do you rely on that as well, or
I wouldn't say I rely on it, but I think it does canvass some really interesting, provide some really interesting observations.
Yeah. Okay.
I have.
But you undertook your own nighttime
That's right.
assessment.
Yeah,
okay.
I think they raise some really valid points, and I think points that I agree with around the nature of the effect and the extent of light spill and things like that in relation to proximity to properties.
Yeah, because I think they used the zone of theoretical visibility in that assessment too.
Yeah, that's pretty standard practice
Yeah.
for BOFs. They tend to use ZTVs for everything.
Okay.
And look, it's easy to do. It's a GIS. You push a button and it gives you a map. So it's certainly not any criticism on my behalf to...
No, I'm just trying to understand it
Yeah.
on my behalf too. Yeah. Thank you. That was all I had.
Thank you.
Mr. Robertson, I've got a question on the fill area 2 and on those very useful cross sections that were on in your statement. Just want to find out the finished profile there in terms of your liaison with Fulton Hogan. Did you provide guidance and say, in your view, the finished fill level should not be any higher than those levels, or were those levels given to you by Fulton Hogan and then you asked if that was going to be okay visually? Can you just let me...
It was the latter. The conversations that I've definitely had with Fulton Hogan has been around looking at the existing contour range. So that 1 in 10, we've gone through and done an analysis of how, forgive the terminology, how roly-poly is it exactly up there, and also the gradients on those front faces. But fundamentally, it was the capacity of the fill site was presented to us. Say this is what we're thinking we need, and responding to that.
Well, I have a question for you, and I might need to go back to Mr. Walsh on this too, is that would, in your view, it be possible to go higher with that fill area and still have acceptable landscape effects, particularly, I guess, well, from Walsh Road and from the regional park?
My gut tells me that you probably could, but I think it's a bit dangerous to kind of just shoot from the hip in terms of what the extent of that.
I understand that. It's probably an unfair question.
I think
possibly,
just to provide a little bit more to that, I think one of the key aspects is from where is it discernible. That is really one of the key aspects from a perceptual point of view is where can people actually see it, and will they be able to discern, say for argument's sake, a 2 to 3 or 5 metre additional height. So that's the level of analysis I think that we'd need to go through. If we get noticeably higher, then does Harris Road start to become more of an issue?
Yes, I'm just interested because there's a lot of overburden that Fulton Hogan needs to get rid of. And perhaps I can ask you, Mr. Walsh, did you consider going higher with that area, or did you have geotech advice that was as high as you could go? Sorry to spring that one on you.
No, we didn't have geotech advice advising us against it.
Okay.
But we did make a judgment call based on past experience.
Yeah, because it's a long way to haul that stuff up. Is that one of the issues?
Correct, both from actually its construction, but also what we thought the effect on Harris Road would be.
Okay, yeah. Okay. So, I mean, you've made a judgment call on that, and you're happy with how that's turned out.
Correct. I should add that once you get up higher, the actual increased volume is very little for the effect you potentially have.
Yes, it's getting smaller and smaller as you go up. Okay. Yeah, thanks very much for that. No, thank you. That's all I had.
Yeah, thank you.
I'd just like to work through the condition framework that's relevant to your area of expertise.
Sure.
Just to identify whether there might be some gaps. I've just been, whilst my colleagues have been questioning, I've just been going through it, and I'm working off the 12th of August edition at page 27, which is the long-term consent for Porirua Council. Yeah.
Yes.
You got that? Good. Okay, so the conditional framework follows what you normally expect. Condition 1's the general accordance condition, and I've highlighted, Mr. Robinson, the matters that are relevant to you. So it highlights the supporting information and technical reports that were lodged with the application, starting with the landscape and visual assessment prepared in last year. That's item D. You see that?
Yes.
Yes. And then there's some reference to an initial Section 92 response and a supplementary response. That's items L, Roman numeral 2 and 3.
Yes.
And then there's the landscape visual mitigation plan, which is Roman numeral 8. All on page 27.
Yes, that's right.
And that's June 2022. So that's quite a recent. In fact, that's that's probably the most recent of all the general conditions, isn't it? Yep. That plan, yes.
Yes,
yes.
That's right.
And
sorry, part 8.
Yes.
Yes, that's correct.
Yes, it's only a couple of months ago.
This is
prepared by Becca.
That's right.
Yes. Okay.
So just to clarify, the only other piece of information that's been generated since that one is this, which was attached to my supplementary evidence.
Right. What is it?
That's the fill site. The fill site plan with the cross section.
Yes. Okay. So, okay, just bear with me. So we turn over the page and we see that those matters prevail in terms of the general accordance condition, unless there's some contradiction or inconsistencies between the application and the further information, and if there's any consistencies with the conditions of the consent conditions prevail. So there's no need to go beyond condition number 1 unless there are conditions that follow that potentially could update or contradict those conditions in condition 1 relating to landscape and visual. That's your understanding of the way the conditions have been?
That's my understanding.
Yes. So if we carry on through and just see where that might occur, I get to condition 12, which is the first, well, I guess this is the chapeau to all the management plan conditions that are listed. Quarry management plan, the noise management plan, the blasting plan, the traffic plan, the biodiversity offset plan, the lizard plan. And then there's the rehabilitation plan. So I guess what I was expecting to see a landscape and visual management plan there, but it's not there. And presumably the reason is because it's come in and is now referenced under condition 1, under clause 8 of that condition.
That's right. That.
Yes. Okay. I guess it doesn't really matter where it's located as long as it's there.
Yes.
Okay. Ms. Williams, have I got it wrong?
No, that's a fair assessment. I do note that conditions 42 and 43.
I haven't got there yet.
Sure. They refer to a planting plan, not management plans.
I know.
So the suite that you're referring to are purely management plans.
Yes.
Yeah.
Thank you.
The point of clarification.
You're keeping me honest.
Sorry, yep.
Okay. And then we come to a title called Quarry Management Plan on page 32. It's just, it's the heading above condition 21.
Yes.
But you'll see prior to that, under condition 19, there's a quarry rehabilitation plan. And you or a professional landscape architect will have a direct involvement in that plan, presumably.
That would be my expectation.
Yes. And so that's the first reference to a landscape involvement other than what the suite of conditions in condition 1 require. And is that because, is there any duplication between that condition and what might be under condition 1?
I guess my perception of what the QRP would be, the quarry rehabilitation plan, is specific to the footprint of the quarry proper.
Yes.
So Mr. Walsh raised an issue that we encounter all the time in quarries, is around vegetating bench slopes and media and final earthworks of the top of the battering those back, similar to what we're talking about with the fill site. So those are the sorts of matters that I would expect to be in the quarry rehabilitation plan.
Yes.
As distinct from the mitigation measures that are in the plans.
Yes.
And the information identified.
Yes. Because if we go back to condition 1 and 1D, the landscape and visual assessment, that's largely an assessment of effects, isn't it? And it will mention mitigation, and it might take mitigation a certain way along the line, but then presumably your RFI response to the Section 92 request and then the supplementary response, and then ultimately the landscape visual mitigation plan would have tied that all together, presumably.
That's right. Which is essentially what this plan does. It says
Yes.
the bund and the small section of tree planting that we talked about.
And apology, I haven't read the detail of the landscape visual management plan, mitigation plan, but does it contain anything on rehabilitation, or is it all left to the QRP later on?
Yeah, so is the question you're asking more around specifications and those sorts of things?
Yes,
around
it is.
Expectations?
As opposed to assessment?
So practice would suggest that a landscape specification, how you put plants in the ground, how they're managed, and particularly around mortality, is something that accompanies the final plan to go to council.
Okay.
That will also happen as part of the quarry rehabilitation plan in
Yes.
relation to those landscape works.
Yes. In any event, because of the condition that says where there's conflict, the condition shall prevail. So even if there were some provisions in the landscape, let me get the typology right, the landscape visual mitigation plan, the LVMP, even if there was content in that, presumably it will be superseded by anything that's in the QRP.
I don't think they talk to the same issues spatially. I think they're talking about fundamentally, one's talking about the quarry proper and the other's talking about the bund planting and the visual mitigation planting.
Okay.
And probably the treatment of the question's probably more around where does the treatment of the fill site sit, which is this information that was appended to my supplementary evidence, which I don't think is...
You don't think it's referenced?
Referenced in...
Okay. I hadn't got to that point yet, but thank you.
Sorry for jumping ahead.
No, that's a good point.
Sorry.
Let's park that.
Sorry, Commissioner, maybe I can assist with that as well. So the QRP is designed, so if you look at condition 96, sets out the requirements of the QRP.
96?
That's at the end of the quarrying in 20 years or 30 years or whatever. So that's how the quarry is going to be rehabilitated after the end of quarrying. So that's why condition 19 talks about 5 years prior to quarrying ceasing, there'll be the development of the QRP. So that's reintegrating the quarry area back into the landscape again at the end, whereas what we've been discussing now is the mitigation measures that are occurring during and at the outset of the works,
Okay,
if that
that's
makes
good.
sense.
And I noticed 96 does cross-reference back to 19.
Yeah.
Thank you. Okay. Under the quarry management plan, Mr. Robertson, condition 21D, Roman numeral 3, on the bottom of 32, again, that's that issue about the management plan minimising effects, and Mr. Baker's going to convert that into a bottom line condition about headlights. Yep. Okay. There's a method in my madness here, and it'll become apparent at the end. The next...
Join the journey.
Hopefully it's not just you and me. I suspect it is. 38, page 38, the design of the bunds and fill site, conditions 39, 40, 41, and then over onto the landscaping of the bunds, 42, 43. Now, I acknowledge that in the copy that I have in front of me, 42 and 43 are struck out, so that's the applicant's position. Is the plan that you just held up, does that bear any relationship to the design of the bunds and the fill site?
I think just going to 42, 43 strikeout, I think that's a reflection of the disagreement around whether there's planting required on the bund.
Yes. Yes, it is.
So that's probably my fault that they've been struck out, because I'm saying that planting's not required.
Yes, and that the strikeout would indicate that, wouldn't it?
I think so, yes.
Yes.
Yeah.
Okay. Good. So my question to you is 39, 40 and 41, particularly the plan that you just held up earlier, the cross-sections, does that talk to those matters?
Yeah, so 41, I was just talking to Amy about that. So 41 covers that.
Yes. So the consent holder shall submit a detailed design of the final contours at least 20 working days prior to the proposed date of commencement. So is this something that you prepared earlier? Is that, so to speak?
That's correct, yeah.
Okay.
This was very much about Mr. Button and I trying to reach agreement on what an appropriate and concept response was to that whole naturalisation issue.
Okay. So in providing it now, and have we received it officially?
So it was appended to my my summary statement.
Presumably that could change between now and 20 days prior to the proposed date of commencement?
It could, but
nuanced.
I think if you move, exactly. I think you'd accept some nuance, but if the fundamental tenets of what's been put on here, so particularly around that front edge and the gradient variations.
Yeah, so your intention in showing it to us in your summary is to show what it might look like.
That's right.
Not to replace the process and outlined in paragraph condition 41.
Correct.
Okay. Okay. And then, unless I've missed anything, the next relevant condition to your area of expertise is condition 53 on page 40. And that's just I guess that's a bottom line requirement that the earth buns are to be progressively topsoiled and hydroseeded. So it's just a day-to-day management.
That's right.
Yep. Okay. And Ms. Williams or Mr. Baker, yell out if you think I'm missing anything. I then get to condition 82, which is squarely on the realm of ecological mitigation and offsetting.
Sorry, Commissioner, I think that...
Have I missed one?
Condition 49, which requires fill site completion report, including cross-sections, crosses over with 41 as well.
Yes, it does. Thank you. Okay, through to 82 now. So clearly that's going to be largely the domain of the ecologist, but would you imagine having some input into that? The ecological mitigation and offset and monitoring? I mean, it talks about a plan demonstrating the location area where regeneration planting is to be implemented, or is that solely the domain of a terrestrial ecologist?
I'd like to be involved, but I think that we'd probably just end up talking about the same thing, which is really around the appropriate selection of plant species to create habitat, and that's where I'd be handing over to the ecologist to exercise their expertise.
Okay. And then I get to the, as Mr. Matheson pointed out, condition 96 is a quarry rehab plan. And there's some input there for you, presumably?
Correct.
Yes.
And that's one, I guess, mechanism that we always expect to see to have involvement in.
Yes.
As landscape architects.
Okay.
Yes.
No, thank you for that. So the reason I've done that is it's important for me and the panel to see how the condition framework has evolved, how condition 1 references the initial assessment matters, the responses that come in by way of RFI, and in this case the LVMP that came in during, I guess, ahead of any evidence anyway. Yes. Otherwise we might have expected an LMVP to be a sub-line under the management plans, but what I'm asking is that there's no damage done and it not being there as long as it's there. Yes, okay. Okay, that's good. And so I'd expect to see that similar sort of logic applied to traffic and noise, all the other disciplines. So I guess I'll spend a little bit of time on that just to labour the point. But Mr. Baker, you might want to take us through that tomorrow. Just maybe using one or two examples that are critical.
It's a good
noise, traffic.
Yeah, can do.
Thank you. So there's no further questions from me on that, Mr. Robertson. It was just the panel understanding the process first and foremost, and then inviting some application of it tomorrow. Liz, anything further? Nigel? No. Okay. What's the feeling, Mr. Matheson? Are we going to push on to the next witness, Dr. Mulling, or should we take tea? Or
no, well, I think we could maybe run through, and then have questions afterwards or something.
Okay, let's do that.
Thank you, Dr. Mulling.
Let us just get our material.
So again, just similar with the others, if we just focus on your summary statement and key points of the rebuttal would be good. Thank you.
I've got the summary. It's interesting that there's different fonts. This looks bigger and bolder.
It does.
That's my printing. Just bear with us for a minute. I'm just bringing that up on the screen. It's more reliable, that one, than that one. Yeah. Yep. Yep.
And then it should be the tab.
That one?
Yeah.
Oh, here it is. Yeah. Dr. Mulling, we were just mulling over the concept of whether the approach of doing the summary first is better or we go the evidence chief, but we think that the summary is best because that'll focus our attention to the evidence in chief matters.
Yep.
So we have all your documents now in front of us.
That's good. I can hear myself quite loudly. Might be a little bit further back. First wanted to mention, I think it was stated before, is that the project has, prior to designing where the field would go, done quite a bit of extensive work on trying to avoid. Yes, it's maybe the speakers are right above me because I can hear myself quite strongly. Now, I wanted to mention that prior to actually where the design of the location of the quarry, that there's been quite a bit of extensive work of trying to avoid any high value areas. In my experience, it doesn't happen often. Most of the times the ecologists come in later where there's already lots of design, and we just get asked to minimize everything as much as possible. Given that there's still a few areas that we've found that will be impacted, that will be and that we can't remediate on site. Similar as with the visual effects, we are removing quite a lot of soil, and to make that happen, there's a few things that would be impacted. Some of those are aquatic habitat in the form of intermittent stream, intermittent and perennial stream, and a farm dam. Other than that, there is a few areas of indigenous vegetation, not massively extensive, moderate in value, and also not very old. With not very old, I mean less than 20 years old from historic photos. And the last thing that we are likely impacting is potential lizard habitat. There's several sites that might have lizards. and although that's not confirmed yet. In general terms, it's of the opinion that we are quite in most instances aligned with the experts from PCC and Greater Wellington in terms of what the impact is and that the appropriateness of the remedial actions. The minor points of disagreement that are outstanding in terms of with PCC have to do with the use of gorse as a nursery plant in Pig Gully. That would only apply to the area that we're proposing to let that regenerate by natural occurrence. Do you want me to directly give an explanation why we find it as a good plan? Yep. The area is quite, as you've seen, quite steep, quite wind exposed. Most of the plants that are actually on the top edge actually are bent over through the wind. This will be, and we've seen it on the planting that's been happening for the current quarry as well. That certain areas, especially around the quarry, have a much lower growth of plants at the start, just purely because of the wind exposure. We felt that letting gorse go through, which is generally much hardier, will actually give a good start of the native plants to come through as well, mostly to protect them from the wind. That said, in calculating the area, we have, that's in the initial work, have calculated that using the dock system, that approach would still mitigate for the biodiversity loss that we're having. That sort of excludes the area of gorse. So anything that would regenerate as gorse and afterwards replaced is sort of additional in that regard. So we've been relatively generous with the area that we are proposing in terms of the impact. Let me see. And sort of related with that, there's minor disagreement on the target of native canopy cover in the grassland in Pig Gully, where Dr. Mackay has proposed 50%, where we have 10%. Yep, so that's as far as I understand the two remaining issues, open issues with PCC. In terms with the submission from YEPS, I think there were several items that we disagreed on, or there's a disagreement on. The first one is the effect of noise on avifauna. We've seen the area is generally, of course, grassland, so there's not that high of a variety of avifauna to begin with. In some evidence from Greater Wellington, we've actually seen in recent years that during the operation from the current quarry, the birds very close to the quarry have actually increased. That's not saying that there's no effect, but I expect that will be less than minor, especially given that looking at SNA areas that are about 400 meters away. In terms of the occurrence of bats, there's quite a few relatively recent surveys happened in the relatively close proximity, and they all have shown sort of no bat occurrence. The closest one was in relation to State Highway 58 upgrades, where there was an extensive survey sort of at the bottom of Murphy's Road, and it also didn't find any bats. Given that there's a very low probability, we have from the start directly said that a full survey for for the presence of bed was not necessary, and that is also partially due to not having many trees that will be felled that could have potential habitat. The next point is, I've already touched on that in the evidence of Dr. Sturman, that she finds that the offsets, the amount of offset for the riparian loss is not sufficient, and especially due to she would like to see the maintenance period be extended to 20 years. I quite disagree with it. As I mentioned before, we've already been quite generous in that regard in the amount of biodiversity offsetting that we're proposing. And a 20-year period is quite standard. I don't see any direct reason to prolong that. Let me see if I had any other points in there. And the same sort of thing goes for the aquatic habitat. We've actually accumulated a few items. We've actually included ephemeral stream as well, mostly for the reason that it was previously, likely before the farm dam was there, was perennial. So we've included that into the calculations, but it's been pointed out by Ms. Walker that it actually wasn't needed. Again, overcompensating for the actual effects. 1.13, the effects on the downstream, as Mr. Madison already mentioned, is that we're definitely not contradicting that the ultimate environment, ultimate downstream environment, the Pautanui Inlet, is quite valuable. But there's given the calculations that have been done by Mr. Pope, we expect that the amount of sediment going down is actually quite low, especially compared to what's already put in there. And suspect that the effect will be less than minor. General request for additional positive outcomes. I've left the mention of a bond to Mr. Madison. I think he's covered that in quite good detail. Sorry, I've lost my train of thought a little bit.
You're at 114 over onto 115?
Yep. But yeah, in general, I feel that the activity will impact low to moderate ecological values in a highly modified area, primarily utilized for grazing. Actual impacts of the proposed activity can be appropriately managed through management and offsetting measures enforced by appropriate consent conditions, and potential effects are managed by reducing the risk of sustainable and incidental impacts that are also enforced through proposed consent conditions. And overall, I'm of the opinion that the effect will have a less than minor effect if the mitigation measures are conducted.
Does that take us to the rebuttal component now?
Yeah, if we want to.
There might be a little bit of repetition here.
Yeah, exactly. So
just perhaps just bear that in mind when you're drawing your attention to any particular matter. guess to help you, Dr. Mulling, is there any particular topics in this rebuttal where you have a strong disagreement with Dr. Sturneman?
It was, I have to say, mostly I think for the need of additional research or surveys. I think she suggests that we should have a specific survey for sedimentation into the Porirua Inlet. Well, I think that we have enough evidence enough evidence that we can gather to make an informed decision in that regard, and the same for a bed survey as well, which I've touched on before.
Could I just test that with you, just using those two examples, especially the sedimentation, and I'm conscious we're yet to hear from Mr. Pope. So when you make made the statement that you don't believe there's any need for further additional surveys on the effects of sedimentation on the inlet, what are you relying on in making that comment?
That is in two parts. Indeed, the research, the calculations, the modelling that has been done with assessing what the amount of sediment is that can potentially come or is expected to come down from the quarry.
Yes. And you relied on Mr. Pope there.
Yes, indeed. The second one is the research from. I think I have that listed here from surveys from the harbour itself, so annual deposition rates and distribution rates from sediment throughout the harbour.
In terms of its current situation.
Yeah.
Yes.
Yeah.
So that covers, those two parts cover off the nature of the existing receiving environment.
Yep.
And the amount and quantity and type of sediment that would be added as a result of this proposal. Yep. So that, taking those two matters together, the nature of the receiving environment and the type and quantity of sediment that might find its way into there. Why is it? Well, how can I phrase this? Can you understand why Dr. Sturneman might have some concerns about those two factors and require additional research or information?
Yeah, so definitely. That's what I mentioned. That we definitely know that there's that it's a very high value area that we are impacting. That we might impact. It's mostly the sort of the quantity that we expect that it will do is it's such a low percentage of what's actually already happening, is that it will be extremely difficult, if not impossible, to actually quantify what potential extra effect or effect it will have. We're talking about an increase of less than 0.5% in that regard, what we're expecting.
Yes.
So deducting that effect, I can't directly see how we're going to do that.
Yes. Yeah. Miss, and I'll elicit the assistance of Commissioner Burge here. I think she'd referred earlier in the morning to a policy framework that talked about maintain and enhance.
Maintain, but where degraded, enhance.
Yeah.
So that might be the starting point for Dr. Sturneman, that it's not only necessary to maintain, but I mean there's a certain degree of degradation in the inlet, isn't there?
Yes, definitely. And I do want to note that we also expect that the planting of the Pig Gully will eventually reduce the amount of sediment to a level below what it currently is. So that would be, you can consider that enhancing. But For the quarry, it's an immediate impact. We can directly see how much it's going to be and model it. For the reduction of Pig Gully, that's a bit more difficult because that's, again, dependent on how the plants...
Can I understand what you just said? Because I think it's quite important. That you're saying that from the current land use or current situation affecting Pig Gully, regardless of the proposal to use it as a... Is it a full one of the... Is it the Porirua 2? No, that's nearby.
Pig Gully is the offset.
Offset, right. Okay. So that the normal practices that are associated with, the current practice associated with farming in that area, or the lack of farming and the erosion that occurs naturally, you're saying that that would be greater than what will occur as a result of the offsetting proposal?
Yes, I think and that's long term. So we're expecting about 7 tonnes per hectare of annually of sediment to come off the quarry. If Pig Gully would be fully restored in that regard, or fully, if the vegetation is fully intact again, there's potential reduction of approximately 8.9 tonnes per hectare. But of course, they don't happen at the same time, so that makes it a little bit...
Okay.
Yeah.
So are you... I mean, I don't... Are you suggesting that it goes to the enhancement component of that policy?
It finally exceeds, and I would have to refer to Mr. Pope, but I think in long term, I think it was also the footprint of the quarry itself would in long term also be lower than it is currently.
Yes. Okay.
But yeah, there is definitely, as it is presented at the moment, a short, not quantifying what short term is, but there's a short term increase for potentially a long term decrease.
Sorry, can I just jump on there for a
please
second?
do.
Is that the case, like in that situation, I'm looking at Pig Gully, that those gullies that come down go directly into a forested area. So you're saying that the sediment that could come off Pig Gully now, wouldn't it get held up there anyway? Is that not? So it technically
no, it's the grassland itself. That's the source.
Sorry, it gets what?
The grassland itself, so the pasture itself, and especially if it's depending on how steep it is, will be a source of sediment, which contributes to the total amount that goes into the Porirua Inlet.
But you know what I mean. There is a forestry block right in front of it,
Yeah.
so it would get held up there. Are you talking?
No, because the sediment would come in from the sides. As soon as it's in the stream, the vegetation wouldn't do too much with reducing that sediment. It's actually the vegetation should prevent it actually going into the stream.
Sure.
Yeah.
Yeah.
What else would you like to tell us in terms of rebuttal? Oh, the other example was the bat.
Yep.
Bat monitoring. Did you want to talk to that also?
I think I've made most of my points in terms that from literature there doesn't seem to be any populations close by. I think the closest ones are in Upper Hutt. The combination of positive records being far away and negative records close by has prompted us not to do another survey to confirm that in that regard. That in combination with the lack of habitat actually on the impacted site itself.
Okay. Just finally from me, to Dr. Mulling, have you had any direct involvement in the drafting of conditions relating to the relevant management plans and the offset
Yes,
conditions?
I've reviewed and given my recommendations on most of those, yeah.
Okay. To Mr. Baker, presumably. You gave those to Mr. Baker, did you? Yes. Okay. Okay. Let's just see if we have any questions on your summary and rebuttal. Otherwise, we might focus on some aspects of the evidence in chief. Mr. Bird, should we start with you?
Just interested in Dr. Sturnham's idea of, not quite sure how she puts it, but it's beyond the 10 years.
Yeah.
Currently, there's a period of 10 years of offsetting. She thinks it should be extended to 20 years or for the duration of the consent. I understand your reasoning, but I guess what I'm wondering, you've also described at how the site is particularly difficult. It's wind driven, it's steep, it's, you know, that's why you're saying, oh, we're only planting these areas because we're going to let this happen because it's too hard.
Yeah.
So why wouldn't you monitor that for longer than 10 years?
The current proposed conditions don't exclude that, actually. It sets the target, and if it takes longer than those 10 years to get to those targets, I think there's a feedback system for us to for it to continue until it does.
And that's where the canopy comes in.
Yes, exactly.
So and this is the issue with gorse as well. So it's sort of tied up. So I'm trying to understand how, because I know there's one thought is that the canopy, you know, your idea of a canopy is 10%, somebody else's idea of a canopy is 50%, and you say that gorse is going to take up that other.
Yes, exactly. So that's why. So if we would handle gorse, then the percentage of natives would definitely increase. We've just proposed to. That's the wording that it needs to be native canopy cover. So we definitely would like to have quite much more than 10% canopy cover, but we've been proposing that it's not all native in that regard.
Yeah.
That will, like I mentioned before, gorse is quite often used as a nursery plant. It does generally take about 20 to 30 years for the natives to grow through that. That's against the balance that we've had at the beginning, is do we minimize the amount of area that we propose to mitigate and fully restore that with full effort, or increase the size of the mitigation area that we're proposing and reduce the impact, the management that we need to do with it.
Sure. Okay. So you're confident that given the the type of environment, being it quite exposed, you're confident that what you have proposed will go ahead. And I'm just in mind that I think it was Mr. Kai talked about you've got quite a complicated planting schedule, and I don't know if just my basic understanding of gardening, I plant the ones that are going to grow. So I'm just interested in why you've got such a complicated planting schedule and such an extreme.
Yeah, no, that's a good question. I actually have to refer that one of my colleagues has made the planting plan in that regard. So I've relied on her expertise on that.
Sure.
But I also do see Dr. Mackay's reasoning, and I'm quite happy to discuss with him in more detail what it should be within the management plan in that regard. I'm not 100% sure if that needs to be squared off in here in that regard.
Yeah, so maybe there's a situation where you can plant things that are more likely to grow rather than maybe your exotics or your special plants.
Yeah, definitely.
And maybe that could mean less gorse.
There's two distinct areas. So we have at the moment really one area that's allocated for no planting at all. So there's quite a lot of seedlings in there. So we do expect that a lot of self-seeding, and that's the good thing with Pig Gully is that there's already quite a lot of vegetation in there. So there's a seed quite mature, relatively mature as well. So there's a good seed bank nearby, which often is not the case. So we do think that self-seeding, for that reason, is quite good here.
Yeah. That's something that we noticed too, that there is, you've got something to start from at least.
Definitely, yeah. And I have to say as well, with the plant selection, we have taken into account that we have a very rare plant on site there, which sort of we're trying to avoid some of the standard plants like Manuka and Kanuka because they might actually endanger that specific plant that's there.
So is that plant within Pig Gully, or is it?
Yes, exactly.
It is actually within. Yeah. So your planting program, if you like, will ensure that is got some special attention.
Yes. So we've the areas that we want to plant are actually around that to take it out of the wind. And we've also proposed that we can look at propagating the plant and manually and potentially distributing throughout the region for additional benefits in that regard.
Sure.
Yeah.
Are we still on rebuttal or carry on?
Carry on. Well, I think we're well overdue for a coffee break, so we take that now, come back in at 10 past, and we do plan to get to you, Mr. Pope. Can I just signal to you, Mr. Baker, and I'm reluctant to set you more homework, but in light of that example I gave earlier with Mr. Robertson about the condition framework, certainly by the close of proceedings on Friday, it'd be useful to have what I would call a wiring diagram that links the conditions or summarises the conditions under each of the topics. It doesn't have to be a diagram. It can be a tabular approach that links the condition one, which would obviously be common to all of the topics, and then the specialist conditions. But if you want to do it as a diagram, you're welcome to. That's the first part of the homework, and the second part is just
on that. Know what you need. I think a table form would work
tabular
well.
form.
Yep.
Yes. The other one is the functional relationship between the management plans, and that might benefit from a diagram. It may be quite simple that they're all sitting on the same row, but if there's, does the construction environmental plan, or for example, form more of an umbrella management plan compared to the others or not? So just having that in a graphic will be of a lot of use to the panel.
Yeah, both of those can be done. Yeah.
Yes, thank you for that. Right, come back just after 10 past. Hey, we're just going to finish off some questions that Commissioner Burge has for you on your evidence in chief, Dr. Mullings, and then we're going to go to Mr. Pope, and then I think we'll have a wrap up at the end of the day, Mr. Methven, to see where we're going and how we're tracking. And I'm all care and no responsibility in terms of keeping record of the instructions I issue willy-nilly, so I'm hoping someone's doing that on my behalf. I know Mr. Baker is, and I think
I've certainly got some homework.
If I can start, we just had a quick chat during the break. I would like to state that we are happy to go away from the course in that regard, if that's...
Mr. Just to be clear, Mr. Nation doesn't really want a seed source of gorse at the top of the gully for obvious reasons. So,
That's what I was alluding to. Yeah.
Dr. Mullings kindly has given some thought to some alternatives, but
I could see a relationship between fences and gorse, and coming from a rural background myself.
And notwithstanding that it is a good seed source or bedding source.
Nursery. Yeah. Yes.
Sorry, Dr. Mulling, I interrupted you rudely again.
Yes.
Can you continue?
Just before we do go to that, will that involve a change to a condition or conditions?
No, well, we'll have a look at that. My memory is it didn't specify that. That's one of the matters to be addressed in the management plan. So,
Yeah.
It does in some part because it's related to the percent coverage.
Okay, well, yeah. So we'll update that, but I just thought Dr. Marling should just update everyone here, and then we'll give some thought to whatever consequential changes we need.
Yeah.
Thank you.
I just wondered too if some further thought could go into the difference between 10% and 50%. It's a little bit like the 50 metres and 400 metres. I don't know, we just seem to be at huge ends of the pole. Can't we come a little bit closer in that canopy cover? So the other thing I just wanted to go to was your paragraph. This is in your evidence in chief, paragraph 8.1. And I'm just interested in the table there, and I just want some discussion around, you say that there were some calculation errors, and, when I look at that table, there's some quite vast differences. So I just wondered if you could sort of put some meat around those bones, if you like.
Yes, no, I can exactly tell where they come from. Pig Gully was actually one of the areas that was initially also scoped out for a fill site. So in the initial one, you might have seen that we had an area of about 90 hectares that we've surveyed. They've all been put into GIS as a single layer, and especially the wetlands. I just took the number of the total, but everything that we assessed rather than was in Pig Gully. And the same happened with the retirement area, and the total area is related to the retirement area. That's the same difference. That was during. I think when I was making this statement, I actually noticed that that was the case. For the wetland area, as we're not mitigating for any wetlands areas, it doesn't have any effect on what was proposed. For the retirement area, I did redo the calculations throughout the DOC biodiversity offsetting system, and it still remained to get to the same conclusions as it did before. So that would still be enough or sufficient to mitigate the biodiversity loss within a 10-year period.
Okay. So you're confident that that now is correct and that doesn't have any sort of ripple effect, if you like?
Yep.
Yeah. I know we've had a bit of discussion about the avifauna, and there's been some further information supplied on that. I just wondered, did you actually sort of look at nighttime effects of birds? And I was thinking of the moorpork, actually, and whether that was resident and what sort of nighttime thought you gave to it.
The moorpork didn't come up in our... we haven't spotted it, but also it didn't come up in any of our desktop assessments of being sited nearby or within in that radius. So no, we haven't taken into account that effect.
Okay.
Given that I think there's not that much nighttime work going on, I don't see that directly overlapping.
Well, it sounds like there could be quite a lot of nighttime work happening between 6 and 10 if the crushing and machinery and all that sort of thing. So I just want to, I guess probably the first part of that question is, did you actually look at nighttime effects on avifauna?
Not straight away, like you said. No, we don't. From the species that we've seen, there's not many night active ones.
So you wouldn't see any effect from nighttime activities on bird life in that area?
I can't exclude it in that regard. But again, the species that we've seen, there's not many threatened species there. The ones that are potentially there are daytime active and are unlikely to use the area or the nearby area as a full residence in that regard. That would indeed be more towards the SNAs, where we expect that the levels are so low that shouldn't have any more than minor effects.
I just wanted to understand the stream diversion and how it's considered, whether it's considered in terms of remediation or offset, and why. I just haven't been able to get my head around that part.
Yeah, no, that's a bit of a technical one in that regard. I want to first start that I think the package doesn't really matter in which category it falls. In my opinion, where the stream is located now, we're very close to actually placing it back. It goes from the same starting point to, it stays within the same tributary. It connects the same streams. Of course, we are replacing it from one spot to the other, but that would also natural meandering and changing of a stream would naturally happen as well. So, from my point of view of saying that it's directly offsetting as soon as you move it a meter is a bit strict and not in guidance of the natural behavior of a stream. So we're still reconnecting the same section of stream that was there before. It's the same within from the headwaters to the mouth. It is the same piece of stream that we're still replacing. That's why I see it more as remediation rather than offsetting.
Sure. And so the new channel, if you like, which will be, as I understand it, on one of the benches.
Yep.
And I think I've read that it's obviously going to be fairly hard to establish any riparian vegetation along there. So you're not attempting to establish any vegetation there, or is?
I think that will be part of the what is the Quarry here rehabilitation plan afterwards, after decommission.
Okay.
But yeah, that's as far as possible. I don't within the assessment, I've assumed that it's not possible to get close enough. So I don't think it will be on the same bench. It might be a bench above and a bench below. But definitely not close to the stream, because that will probably take up most of the bench.
Okay.
And that's also the reason why we've split up mitigating for the extent of the stream and the quality of the stream.
And the riparian, but yeah.
Yeah.
Sorry, just bear with me a minute. I'm just... So, as I understand it, just sorry, back to the stream diversion, I know I could be wrong. Greater Wellington think of it as restoration offset. Is that right? Is that like a point of difference between?
It's a difference in which category you place it. I don't see any consequences of that different placement, so I'm still happy to call it offsetting as well, as the outcome will be exactly the same.
Sure. Okay. So the loss of the farm dam, you've taken that as 100 metres. You've included 100 metres in the perennial stream to account for the farm dam. Is that correct?
Yes.
So is that just like the length of the dam? Is that why you've done it 100 metres?
It's the length from the start of the upstream streams that feed the dam to the centre of the channel that
to the discharge of it.
To the discharge, yeah.
And so I understand there are eels in the pond?
Yes.
Yeah.
Yeah.
And so that's obviously a habitat loss for them.
Yes.
And so how would that be accounted for?
We've first of all, I think there's, and I have to rely on others, is that there's special provisions for farm dams in that regard, that they fall on the lost my frame of
That's okay. So I guess my question is,
yeah.
Are you accounting for the loss of that? Let's put the farm dam, if it's this or that aside, just for a minute. I just want to understand whether you've accounted for habitat loss for eels.
We have accounted for that 100 meters of habitat, because that's what before the dam was there. We haven't accounted for the area of the dam.
Okay. Yep, that's clear.
Yep.
Thank you. Oh, we had a little discussion earlier about legal protection of Pig Gully. I sort of saw you twitching when we had that discussion. Did you have something to contribute there about looking at some sort of long-term protection for that?
It was sort of referred to me in that regard. I completely agree that it should be protected. What the best legal way of doing that is not my expertise in that regard. So it was not twitching of that it doesn't need to be protected, but it's not directly my question. What's the best way of doing that?
Okay, I just thought you might have an opinion on what sort of protection might be available, just given your experience and expertise.
No, I'm mostly familiar with Kiwi2, but as they say, there's some problems with that. So I think it's quite clearly what needs to be protected, and whichever form that best suits for that should be implied.
Sure. So you had some, just referring to first paragraph 18, I just wondered if you could just clarify whether that is actually a repeat of paragraph 15, or whether it is actually different.
Oh, it looks like that's a double up indeed.
Yeah, that's okay. I just wanted to clarify myself. And at 20.3 is sort of where we get into conditions a little bit, but I just wondered if you could, this is something that's been sort of indicated that, some further discussion at the hearing might be helpful. I just wondered if perhaps you could just outline your concerns with that condition.
I understand that this might. What it is, that's in terms of an upstream and downstream change in macro invertebrates. I completely agree with of the use of it. The problem I see with it is that the habitat upstream and downstream are quite different. At the moment, it's farmland versus forestry. So, in general, you would already expect the upstream one to be lower than the downstream one. How it's worded at the moment, it would take quite a lot more to actually get to that 20% negative difference on the downstream end. I could see the intent of the late edition, but I didn't see the effectiveness of it in this case.
Okay, so just related to that clause.
Yeah.
So clause E is, yeah. The rest of that condition you don't have an issue with. I mean, others might have an issue with it, but I'm just talking about you.
No, I don't think so. No.
Yeah. Okay. And condition 50A, you've made some changes there. In 4 and 5. Are you essentially combining 4 and 5?
Yes.
Yeah. And that's
So that was more a change of indeed wording. Seemed to be a bit of a dull.
Yeah, so it's efficiency.
Yeah.
Yeah. And then condition 60, following on from that, you've got inclusive of existing riparian planting.
Yes, so what the proposed planting is to make sure that we have a 20-meter riparian zone on both sides of the stream. At some spots there's already, say, 5 meters there. What we wanted to make sure with this is to clarify that we're aiming to supplement up to the 20 meters and not 20 meters past what's already there.
Yeah. Okay, clarification, yeah. So we've got, quite a few management plans associated with your field, shall I say. And I just want to run through that. So we've got the lizard management plan, biodiversity offsetting and management plan, streams and wetlands works management plan, terrestrial state of the environment monitoring. I wasn't quite sure what that one was.
I might have missed that one. Which condition is that?
Is this the Greater Wellington condition, Commissioner?
Sorry?
Yeah. Oh, well, I don't know. It's at page.
Oh yeah, that's what I've referred. Yeah, that's not in the conditions. No, that's that last one is something that Greater Wellington does throughout the region. So it was attached evidence. It's not part of conditions.
Okay, sorry.
Yeah.
Yeah.
It's a separate program.
So yeah.
Yeah.
And then there's some construction management plans for stream diversion, riparian planting, lizard habitat creation, fencing and pest management.
Most of that would sit into the biodiversity offsetting and management plan.
Yeah. Okay, thank you.
Normally we've split it up a little bit because normally you would have the lizard management plan would involve all the mitigation for the lizards as well, because we've incorporated all the management types into one area rather than having them all over the place. In that regard, we have tried to combine them into one document so that it makes it really workable afterwards, rather than having many documents.
That makes sense. That was my point.
Yeah.
And just on to a few that's sort of come in through the course of the proceedings. Jamie Mackay has suggested an interim review at 5 years. Did you? I'm not sure that you addressed that.
That's already in the biodiversity offsetting management plan. That's where that's already included, and I think there we have a 1-3-5 year review.
Okay. Yeah. Thank you. That was all my questions.
Nigel? No. Thank you, Commissioner Burge. Just a couple of mop-up ones from me, Dr. Mulling, and I'm going to focus solely on conditions. Before I do, though, the impression I get from your summary statement is that there's a large amount of agreement between yourself, Dr. Mackay, Dr. Singers and Dr. Greer, and more agreement with Dr. Mackay now in relation to the statement you made after the afternoon tea adjournment regarding gorse.
Yep.
Correct?
Yep.
Good. I noticed that Dr. Mackay is online. Dr. Mackay, are you listening in? Doesn't look like it. Yes.
I am.
Here we go.
No. Sorry, my keyboard ran out of battery. I'm back.
Yeah, that old chestnut.
Yeah.
Thanks, Dr. Mackay. I was just making sure that you were listening in and that you caught up with the change that Dr. Mullings had proposed after the afternoon tea adjournment.
Yes.
Regarding
I did wonder
gorse.
what the Sorry, I did wonder what the reaction of farmers would be to a big patch of gorse in the middle of the farm. So, yeah.
Okay. Good. Well, we'll hear from you on Friday. But
Friday,
what I would encourage, and it probably doesn't sound like there's a big need to do this, but if there's any further need to discuss fine-tune matters between yourself and Dr. Mullings, please take that opportunity. The same applies, obviously, to Dr. Singers and Dr. Greer also. Yes, from a regional council point of view, Ms. Walker?
Yeah, I understand they're all in agreement.
Yes, okay. And of course, this applies to all disciplines. I mean, no one should be waiting for directions from the panel on conferencing. It's almost the ambulance at the bottom of the cliff. So if there's an opportunity to further nuance agreements between professional witnesses who have signed up to the code of conduct, then we expect that to happen without the need for, direction. So, I guess we've seen some live changes here in the last hour or two, so that's important. I guess the same also applies to you, Mr. Robson, with Mr. Button. I mean, it seems like you're largely agreed, but if there's a further opportunity to discuss that issue regarding planting at the toe of the bund, we would just encourage you to do that. Okay, that rant over. Dr. Mullings, the two key conditions that I'm interested in, and Commissioner Burge has largely commented on them, is the biodiversity offset and monitoring plan, which is condition 60 under the Greater Wellington set of conditions, and the same plan, which is condition 82 under the Porirua conditions. Now, they share the same title, but presumably they achieving slightly different outcomes, or is that too much of a simplification?
The split is between the aquatic habitat versus the terrestrial.
Yes.
Yeah.
Okay. So it's that simple.
It's that simple. Yeah.
Yes. So aquatic being Greater Wellington and terrestrial being Porirua. Thank you. Good. That's all I have for you. I guess, Mr. Baker, again, sorry, I'm returning to you. Can we just use this as an example again? And I'm going to focus, for no particular reason, on the Porirua condition, which is condition 82. And the starting point before you get to 82 is obviously condition 17, which requires the consent holder to prepare a BOMP and submit it to certification. So condition 17 is largely a mechanical type condition, isn't it? And there'll be similar sort of mechanical conditions for all the management plans, won't there?
Correct.
Yes.
Just one point of clarification. The plan we're talking about there, biodiversity offset and monitoring plan, it will be one plan.
Different sections?
Yeah. So it'll capture both aquatic and terrestrial sitting in one plan.
Understand
like
that.
you said, for slightly different purposes for the councils.
Yes. I guess what I'm trying to socialise with you is that there might be some efficiency in dealing with what condition 17 captures at the beginning in relation to all management plans.
Yeah, we've I've got a format which does have a general management plan sections with all the mechanical bits, and then the individual ones separate. So we've been discussing that, and I think that will allow us to cut down quite a lot of the duplication.
Agree. Yeah.
But because it's if you actually have the management plan when it has to be submitted by in a table, and then the mechanical changes, and then the management plans with the objective and the contents, I think it will simplify.
I agree, and failure to do that runs the risk that you have a misalignment of wordings between the mechanical aspects applying to management plan 1 versus management 2, plan 3. So if that mechanical wording at the front end could also include what I'm calling the loop process. Also, do you understand what I mean by that? The process of certification and what happens in the event that certification is not achieved.
So the set that I've sort of passed on is you can make amendments, you need to do that, you can't do anything before it's certified. The amendments have to be consistent with the objectives. In the event of an amendment, a further amendment, it's got to go back for recertification. If they decline, then you go back and do it again and resubmit it, and within certain timeframes. And then
it's certainty of process so that everyone knows what happens in the event that certification fails, what happens in terms of... And to the extent that, and this might be something you may not have thought of, and that a resolution process where following the second or third application, certification is not possible. And what happens in terms of that resolution?
Yeah, I've struggled with that from a legality perspective in terms of short of sending people off to some sort of arbitration process, which is normal in a bond sort of condition because of the nature of it. It is a bit more difficult, and it's sort of hard because the consent condition can't force the council to go to mediation or arbitration.
No.
Which is why it's sort of a bit more problematic, and it's a bit of a failure probably in the Act for as long as it remains. But I think generally, ultimately, it does rely. I mean, people do often say to me, well, "What if the council don't agree?" And say, "Well, you can't do it. You know, you ultimately have to get to that point or apply for a variation." So, as long as it's clear that the changes don't take effect until it's certified, and if it's not certified, then you can't rely on a change.
Okay.
As long as that's really clear, then I think ultimately it's up to the consent holder and the council.
I guess the motivation then is with the applicant.
Consent holder.
Yes,
yeah.
yes.
I mean, it's the risk on the consent holder, but.
Okay. Can I just say two things then? It sounds like you do have a template for dealing with that. The most recent fit for purpose example that I saw, and Mr. Baker, you might be familiar with this, is the Naronga to Petone shared cycle path. One of those early conditions was retrofitted to include that general mechanical component that applies to all management plans. So you may or may not want to look at that, but that's a recent example that, and I was on the panel for the fast track approval on that, so I'm familiar with that.
Yeah, thank you. We can get our hands on that.
And I think Becca might have been the applicant. Yes, yes. The other thing is, as I was saying this morning, it's always important to have a clear, I mean, the important thing with these management plans is that they need to be legible. The conditions need to be legible. And I'm just having read through them, they all start off and end in different ways. And I don't want to be picky about that, but the biodiversity one, for example, condition 82, well, it's not until you get, I mean, conditions 82, 83, right through to 91, it's not really until you get to condition 87 that you sort of get a feel for what the objective of the management plan is. So it's, 5 or 6 conditions in. And I would have thought it might be more appropriate to have an objective up front as to what the management plan is seeking to do, then what it should contain. Because largely that certification process will become a tick box exercise, for want of a better word, because it's not transferring a discretion for approval. It's making sure that that the management plan is fit for purpose by reference to the condition that says what it should contain. So I'm not suggesting rework just for the sake of it, but to the extent that you have time between now and the end of the week, that might be useful. And that was all from me. Okay. I think if we've still got an appetite, Mr. Matheson, I'd like to get to Mr. Pope if we can, and that just gives us a little more scope for tomorrow.
Yeah, very happy to. Just while Mr. Pope, while he may be getting Mr. Pope's evidence, the only point I did skip over it, from a avoid, remedy, mitigate, offset and compensate, the only point in my submission that you need to be concerned about the difference is in respect of the 104D 1A test, in which you can have regard to adverse effects that are avoided, remedied or mitigated, but you can't take into account offsetting or compensation. In the 1A test, you can in the 1B test, so the objective and policy test you can, to the extent the policies refer to offsetting and mitigation, but not in the 1A test. This is normally much more of an issue if you fail the effects test, then you're relying on the policy test and then question what fits into which category. But there are some very, very fine definitions being applied in different areas about the difference between mitigation and offset that quite confuse me. But so, and ultimately, if one just sits back and says, well, if you're restoring a wetland that's 80 kilometres away from one end of the Whangamarino wetland to the other, that's probably not mitigation. If you're mitigating it 10 metres away and doing that then from a legal perspective, my position's always been, well, that's mitigation, it's not offset, because it's actually... But a pure ecology view I know is that that's compensation, because you're not picking the wetland up and moving it. So anyway, I don't necessarily think a lot of those apply here. I think the characterisation as remediation is probably a good one. I mean, diversion of streams is generally considered more in that nature, given it is still a stream. It's just been moved. So anyway, I don't think it's going to be an issue, but I just wanted to make that clear in case it was.
It is late in the day for us to take on these legal concepts and get ahead. We will invite you to distill that into writing.
Yeah. That's what I was going to say. Can you write that down?
Yeah.
No, happy to do that.
Essentially what I'm getting is that that it's not within the tent under 1A, but it is under 1B.
If the objective policies refer to offsetting and compensation, which most of them do nowadays, and certainly the NPCFM does.
Yes.
terms of hierarchy. Thank you.
No, hang on, sorry, there's just one other thing. That reminds me, I omitted to ask you a question earlier about the statutory framework. And I just wondered whether the NES FM had any impact or relevance.
I suspect that's where, as I understand, no NES wetlands have been discovered, despite their prevalence everywhere else in New Zealand. But I think that's where Dr. Mulligan was coming from when he was talking about the farm dam, which is not a natural inland wetland because it's a created dam. So I suspect that's where that was coming from. But my understanding is GWRC and everyone's agreed that there's no NES wetlands.
Thank you.
I should quickly clarify that. I'm just finding my page. Hang on.
Oh, yeah, they're open.
So I think before, right at the start, you might have mentioned the NES contaminated land early on. I think the clarification was we have actually applied for consents under the NES freshwater, and if you've been up to the top of the site, fill site 2, at the bottom of that there's a small farm pond that you might have stopped at.
Yep.
We had quite a bit of debate with Greater Wellington over the state of that in terms of the NES freshwater, and came to the conclusion it was a constructed wetland, and we have conservatively applied for a consent for that matter. So I addressed that in point 3.4 of my main evidence, covering off the consents that we're seeking under the NES freshwater.
Okay.
But that's diversion within 100 metres, isn't it?
Yeah. So we are seeking consents
within 100 metres of a wetland. Yeah.
Yeah. So it's the diversions works within 100 metres, not works in the actual claiming wetlands.
And you've done that under abundance of caution.
Correct. Yeah. So Rule 54, and also Rule 57, which included the reclamation of intermittent ephemeral perennial streams.
Yeah, that is the NRRP, isn't it?
The NES freshwater.
Oh, sorry, the NES.
Yeah.
Yes. Okay. Is there anything you wanted to say, Ms. Walker, at that stage? You'll have an opportunity, but...
Yeah, I just wanted to clarify that the two rules where the non-complying activity are both in relation to wetlands, both under the Natural Resources Plan and the National Environmental Standard for Freshwater, and that the PNRP is more direct effects, construction activities in and around the wetland, whereas the NES is to do with the damming and diversion of water, mainly to do with the small construction works in the wetland, directly in the wetland, and the diversion of water through the clean and dirty water diversions while they're establishing the fill site. Okay,
so two questions arising. If it hadn't been considered to be a constructed wetland, would the application still be a non-complying activity?
Just to clarify, we don't consider it to be a constructed wetland. We consider that there were wetlands present on the site, and the applicant constructed a farm pond within the wetland for the purposes of stock watering. But Mr. Singers will talk to that more in his evidence.
Right.
Sorry, and your question?
You're right, it's still non-complying under the PNRP.
Correct, for the activities associated with constructing the culvert.
So regardless of the NES, it would be non-complying under the PNRP.
Yeah, it would be more likely to be non-complying under the NES because that's within a 100-metre distance.
Yeah.
And the clean water and dirty water diversions will be within that distance, as will the discharges from the SRP.
So those references to Rules 54 and 57, was that to the PNRP or the NES?
NES.
NES, yeah. I believe it's 108 of the PNRP, it's a non-complying activity.
108?
Yeah.
Okay. And we're largely treating the PNRP as operative, aren't we, for the purpose of this?
Most of the appeals are resolved.
Yeah, that's good to hear.
Aware, yeah.
Well, no, I'm functus officio, and I hate to think. You just can't go back there because you'll destroy yourself. Won't you, Commissioner Burge? Yeah, what happens after you release the decision is subject to this thing called mediation, which doesn't seem to have any rules. You wouldn't believe it. Yes. Anyway.
Okay.
Let's get on.
Mr. Pope.
Thank you, Mr. Pope. At 4:52, your day in the sun. Now let's see if we've got everything. I've got your summary statement, I think. Have we?
Would you like me to read the whole thing?
No. No, I wouldn't.
Is it good afternoon or good evening?
You did have a summary statement, didn't you?
Yes.
Yes. And thank you. And okay, we're good to go.
Great.
Same approach. For your key summary points and any rebuttal, and then we'll delve a little bit deeper into those in the evidence in chief. And Commissioner Mark Brown will be leading the questions on that.
Thank you. I did have some slides there, but the question for you is whether it's actually helpful or not. Yep. Okay. That one
The
there.
missing one, yep.
Yep, sweet. My name's Glenn Pope. I'll be covering erosion and sediment control for the applicant. Try and breeze through as quickly as possible. The quarrying activities will result in the diversion of 2 streams into new courses, and obviously the quarry itself. I guess a description of the quarrying activities has been given by Mr. Walsh, and defer to that. However, it might be useful to just run through a couple of these slides from an erosion and sediment control perspective to give some clarity to what we're doing. Just looking at the stage 1 slide. Stage 1, as Mr. Walsh explained, is at the southern extent in the middle of the quarry footprint. There's a sediment retention pond shown there, but that won't come until they start taking down the overburden. And just as a representation of how that overburden stripping process will happen, these were put together by Fulton Hogan just to demonstrate how the overburden will be stripped down in stages. And as part of those stages, we'll be relying on decanting earth bunds to deal with smaller catchments until we get down to the last stage of that strip, where a sediment retention pond would then treat the entire catchment from that area.
Mr. Pope, is that the sediment treatment pond? Is that in the same position as the current position?
No. So in terms of the existing quarry footprint, SRP-A, which is the existing sediment retention pond that you would have seen on site, would treat...
Where's your pointer there? I can't... Where's it?
Which one's the pointer?
I can do it for you if you like.
That's it. Yep, that's it.
Okay.
So that's your existing pond.
I can orientate myself from there, yes.
Right. So to the south, which is down stage 1, that has its own sediment retention pond, while that area is being stripped down, which is to the left a little bit, SRP1. Up and right.
Is it the purple area?
Sorry,
yes.
I'm going to go.
This mouse, I can give it to you if you like.
Yeah, it'd be great. Thank you.
Sorry.
No, that's all right.
We're not quite that flash yet.
Okay, now we're cooking.
SRP1, there we go. So just to quickly run through, that's essentially how all of the overburden stripping will be undertaken in different stages over time. This is just showing us stage 2. So at this point, stream 3, where are you? There will be diverted into that new channel, and then stage 2 will be stripped down in the same fashion with decanting earth bunds, and then wake up. Come back. I've lost it.
Sorry, it's a little bit temperamental.
Thank you. SRP 2A is sitting there just on the other side of Stream 2.
Yes, we can see that. Portrait orientation. Yes.
I'll skip on. This is the overview of the fill area, which is to the east of the quarry site. We've got 2 sediment retention ponds here, SRP 2B. Come on. There. That will take the majority of the catchment area in stages. And this is SRP 2C. Down in the southeast corner, and that will be limited to about 1.5 hectares catchment size. And the methodology for the overburden filling is that it will be done in stages, and those stages will be limited to 3 hectares maximum at any one time to limit the amount of open area. So you can imagine that it will be done in sections, and I couldn't say exactly which way that would be done, whether it's from the south to the north or the north to the south, but that will all be confirmed. Stage 3 will be, there'll be a road cut up to the very top of the existing ridge line, which you may have seen and driven around. And that will be stripped down in stages, and it's too hard to say at this stage what those stages would be. While gravity fall down to this, during the overburden stages, stripping, 2 further sediment retention ponds may be constructed, or will be constructed, which are both sized for around about 4 hectares maximum catchment. Mm-hmm. Eventually, once the overburden is stripped off and it gets into hard rock quarrying, then the hard rock quarry runoff will all be dealt with, including the runoff from stage 1 and 2 areas within the quarry pit and the existing sediment retention pond.
Yes. Will it need any upgrading, the existing pond, or in terms of its size? Is it of an appropriate size to deal with those later stages?
As far as when it gets to that point, there will be a substantial amount of impoundment volume in the quarry pit itself, which means that the pond itself does have a catchment limitation, but the impoundment within the quarry will add a detention volume there that can then be released slowly, or more importantly, will be reused as part of the quarry operation. So that would limit the runoff that the pond actually gets by gravity fall. And once you get into stage 4, then the pond is essentially high and dry for most of the time. And there'll be quite a reliance there on impoundment within the quarry pit. So I just wanted to
run through... get that word, impoundment?
Impoundment. It'll be a big pool. Yeah.
Thank you.
So just that'll all be pumped up to the pond from the...
I should have explained
from
that.
the impoundment. Yeah, can you explain?
Yes, that's right. There'll be a pumping arrangement in place that will be... there was talk as well of potentially putting some sort of monitoring equipment on that to measure turbidity as it's being pumped. Yeah.
Yeah, so when you said that pond will be high and dry, that you meant you have to pump up to it.
Yeah, that's right. Once the quarry pit goes below the existing level. As far as the mitigation bund construction goes, that will be treated through the use of super silt fences and decanting earth bunds. Fairly standard earthworks operation. There'd be a lot of staging there to limit the overall catchment area. I'm sure you've got many of those, but I will move on. So I prepared the erosion and sediment control plan and the adaptive monitoring plan for the application. Just quickly, the erosion and sediment control plan is prepared with reference to industry best practice and in particular the Greater Wellington Regional Council's Erosion and Sediment Control Guide. The adaptive monitoring plan sets out how we would monitor the construction and discharge from erosion and sediment controls utilised during the job, during the quarry, activities, and also looks at the discharge quality and freshwater effects monitoring over time. Importantly, the AMP must be read in conjunction with the ESCP. The AMP is not a standalone, it's not a document that we just rely on in lieu of any other planning. Together, these documents provide the basis for the planning and sequencing of earthworks activities, the manner in which construction runoff will be managed, and the means by which the effects of sediment discharge will be monitored and managed for the life of the quarry. Maybe if I go into the point about the downstream monitoring point. Is there any...
Just before you do, and of the three of us, I probably know less about erosion and sediment control, so sure. just to test that I haven't got it completely wrong. So for each of these stages, there's a series of fencing, decanting, earth buns, and in most cases at least one sediment pond, if not two, capturing sedimentation. Correct. Yes. And when all three stages have been undertaken and we're into the stage 4 approach, everything really goes to the existing sediment pond. That's
to one device. It's entirely possible that that device may have been upgraded.
Yes.
Or changed position.
Yes. Okay. Secondly, you've produced as part of the application, or at least ahead of the hearing, a draft erosion sediment control plan and the adaptive management plan.
Yes.
Both.
Yes.
Yes. Okay. And so the condition framework requires those to be updated, and I'm just checking on the wording. Presumably certified.
I believe so, yes, from memory.
Or is it a case of self-certification, in this case by a CQEP?
No.
No, to clarify, the ESCP condition requires council certification.
Okay, right. Do you have a is that a standard procedure?
Yes, if
okay.
it's a large-scale earthworks consent, yeah.
Okay, good. Good. Okay. And presumably it's the adaptive monitoring plan would suggest that this is something that's continually changing, and the erosion sediment plan might have to be updated from time to time.
Correct. Yep. Earthworks very dynamic.
Yes.
Quarrying is very dynamic. Yes.
Okay.
The weather is very dynamic.
Yes. And so the final FMP, and I'm reading from condition 39 here of the Greater Wellington conditions, based on the draft. Oh, sorry. I'm getting confused, sorry. That's the flocculation management plan I think I'm talking about.
Yes.
Okay, so condition 36, the ESCP shall be in general accordance with the draft one. In accordance with the Greater Wellington's Guide for Disturbing Activities. So is that the old equivalent to TP 91, is it?
It's all been upgraded since then.
Yes.
Auckland Council ran a process in 2006, or prior to 2016, and then in 2016 the GDO5 guidelines came out,
yes,
which was an upgrade of TP90. As far as I understand, Greater Wellington have essentially adopted GDO5.
Okay. Okay, so I should have really started at condition 5, shouldn't I? Which is the consent notice to prepare and submit a final erosion and sediment control plan for the manager for certification. Thank you. Okay, and okay, and so the final plan really will reflect what wasn't known at the time that it was produced. The draft was produced, and be updated and modified accordingly, presumably.
Correct, and provide a finer level of detail around staging, location of controls, etc.
Okay, Thank you. I know that's high level description, but it's probably as far as my understanding goes. So thank you for that.
No problem. Without reading all of this out, there's been a lot of back and forth about I think it's the policy around setting the reasonable zone of mixing, and I've never disagreed with the council's position on that. I think what I was, in terms of the downstream monitoring point that we proposed in the adaptive monitoring plan, that was purely from a practical perspective based on how I saw the receiving environment at the time. Since that time, and even since I finished my evidence, I've been back to the Quarry site and seen the result of some storm damage, significant storm damage, I guess you would say, to the stream earlier this year. And I've reviewed my position in light of Ms. Walker's report as well. And in terms of the downstream monitoring point, I think it is more appropriate to have it at that 50-metre location. Looking at the 400-metre location now, between where the pond, the sediment retention pond from the Quarry pit discharges and the 400-metre location, there has been substantial storm damage to the banks of the river stream, as well as the catchment within that location. So there could be ongoing sediment effects from natural occurrences that may throw out the threshold monitoring that we've outlined in the AMP. So there's also, as I understand, a agreed process to repair the fish ladder and reinstate that area at the base of the fish ladder, which will likely present an opportunity to have a much more robust location for putting a sampling point in. Fulton Hogan have committed to an automated turbidity meter for that location with telemetry. In summary, that would be a more appropriate location, and there's an opportunity to install that in a much better way compared to the situation that I had previously seen on site. So, somewhat contradicting myself, but taking into account some significant storm damage and the current situation, and looking ahead into the future as well. If a more robust sampling point can be established now, then that would be a better location to do it, along with access for people to get down there.
Sure.
It's fairly hairy beforehand. Yeah.
And that site visit was just last week, I see in your evidence.
Yes.
And that was following quite a major weather event.
Yeah, I believe it was July.
Yes.
June, July. Oh. June. 250-year rain event.
I think the wettest July on record, and even Mr. Matheson, the same applied, I think, to Auckland too.
Yes.
Yeah. Although it's always raining in Auckland, isn't it? If it's not, it's about to. Okay. Sorry, Mr. Pope.
That's all right. I just wanted to address one point from Dr. Sternman's evidence as well, on behalf of Judgeford Environmental Protection Society with respect to ecological effects. I won't attempt to comment on the ecological effects. However, Mr. Mulling in particular relies on my universal soil loss equation calculations in his assessment of sedimentation effects. I've noted in my evidence, specifically at section 7, that in addition to the proposed management practices outlined in the ESCP and the AMP, the reuse of water within the quarry operation over the longer term will further reduce the risk of sediment discharges. I say this because the USLE calculation and you may have questions about this, I'm not sure, but it's difficult to put an operational quarry situation where the sediment treatment device sits high and dry above where the water actually is into a universal soil loss equation situation. That relies on all water going through the pond as part of a normal, through the controls as part of normal rainfall in, rainfall out. So the reuse of water within the quarry, especially in the medium to long term, the impoundment, of water within the quarry, reuse, and then the controlled discharge through the sediment retention pond will further reduce, in my opinion, the expected sediment loss to the environment, further than what is shown in the USLE calculations that I've undertaken. So in turn, that leads me to suspect that maybe the sedimentation effects as well might be further lessened. But I would defer to Dr. Mulling specifically on that. By way of conclusion, the erosion and sediment control plan, in my opinion, represents best practice measures for the control of sediment discharges from land disturbance activities and will minimise discharges from the proposed quarry activities, and the implementation of that is supported by a comprehensive AMP that will enable ongoing monitoring and continuous improvement to occur for the life of the quarry activities.
Thank you, Mr. Pope. Nigel, we'll let you lead off on questions on the summary and evidence in chief also if necessary.
Just on the summary, I was expecting you to talk about the issue of possible monitoring of turbidity for each SRP, following on from my questioning of Mr. Walsh earlier on. Because in his evidence, he said that, in his primary evidence, he said that that would be discussed at the hearing, and Fulton Hogan were going to consider that. And then his earlier evidence, I understood that was going to be addressed by your evidence. So can you help with this one?
So this is around the question of automated systems on each sediment retention pond.
Yeah.
Yes. So I guess in the first instance, I haven't had a chance to discuss that with the council specialist yet, and I would like to do that, and taking your advice, Mr. Chair, around those sorts of issues, it would be great to be able to do that as soon as possible, obviously.
I think the panel agrees too.
Yep. Specifically around automated sampling, usually in my experience that would apply to long duration earthworks activities with continuously open large areas of earthworks where we're trying to physically measure the discharge sediment, the absolute discharge sediment, how much sediment goes out the pipe and down the stream. Yeah, in my opinion, due to the staged nature of the earthworks operations associated with quarry activities, I'm not sure that implementing automated sampling on every single device will provide any greater benefit in terms of monitoring the discharges from those devices compared with the manual approach that's outlined in the adaptive monitoring plan at this point, in my opinion. Yeah. I think that's how I would summarise.
Yes. So that remains an area of uncertainty or disagreement between Greater Wellington and yourself?
I'm not even sure if it's a disagreement yet, and I would like to explore that with Mr. McLean in particular, if that's appropriate.
Yes. Would it be just yourself and Gregor McLean? Would it also involve Ms. Walker and
I think
others?
It probably needs to.
Yes.
I think I'd like to be involved in those discussions.
I think that would be good. I'm conscious that Professor Irons is still online. I don't want you to think, Ms. Irons, that we're necessarily excluding your witness from these discussions. Dr. Sternman is certainly welcome to attend these matters. It's just about her availability and the willingness to participate.
Yes, I can certainly ask her tonight. I was actually just thinking, all the discussions that have been on about, you earlier suggested that they just, get on with it.
Yes.
I was going to email them tonight after this.
Yes, I was going to come to that at the very end in terms of all your witnesses, but certainly in relation to Dr. Sturman, I think that would be much appreciated by the panel if she could participate.
Yes, yes, I will certainly check. I know she's been working at night because she's a very young child that she's looking after.
Understood.
So, but I'm sure we'll figure something out.
What I'm going to do is ask Mr. Pope to take the lead on this and involve, at a minimum, Ms. Walker and Mr. McLean. Dr. Mullings, do you think you need to be involved in that also? I know that you're relying, there's a degree of cross-reliance between yours and Mr. Pope's evidence.
Definitely. If it might be good for us to be on standby in that regard.
Yes.
If it comes up, it very much depends on where the discussion goes.
Yes. It just strikes me that tomorrow morning might be such an opportunity. We'll be finished with this topic, and we're moving on to. Tomorrow.
Hopefully, Miss Wilkinen and Mr. Hunt have stopped talking by then. But anyway, I haven't seen them come back.
Well, hopefully, that's a good sign. But it just seems that there might be an opportunity tomorrow morning for the 4, 5, or 6 of you to get together, and whether that involves a Zoom attendance from Dr. Sturman's Professor Irons, I'll leave that up to her and yourself.
Yep, certainly.
Thank you. Sorry, Nigel, I've intervened again.
If I may, Mr. McLean isn't available tomorrow. So,
is he not?
Yeah, if potentially we could have a discussion after this,
sure.
That could work.
Okay, well, look, I'm not going to direct that. I mean, it's completely up to you, but just be conscious that every opportunity should be extended to Dr. Sternman to be involved in that.
Mm-hmm.
Or at least, if there are agreements, for her to have an opportunity to review those and provide her own discussion. And maybe, Professor Irons, that's maybe the more efficient way to proceed.
Yep.
Given her domestic responsibilities?
Yes.
Yes. Okay. Well, I'm very happy with that. That's more on this. Okay, thank you.
That's all the questions I have on the summary. I've got questions on the environment. I'll go ahead with those.
Let's do it.
Yeah, okay. So, Mr. Pope, got a question on your USLE calculations.
Yes, sir.
I've done USLE calculations myself, not smaller projects than this one, so I am familiar with them. But my main question is, they're really useful.
Yes.
But they are quite important to this consent application, because what you say they demonstrate is that in the longer term the sediment's going to reduce. I do have a question though with your calcs for the existing runoff, whether you did allow for the existing pond, that existing pond up there, and what treatment that would do for existing sediment. When I had a quick look through the calcs, it didn't seem like you'd separated that out. And I know they are quite approximate, and you can only go down to a certain fine grain. But my question, remains about that. You know what I'm saying? So
I absolutely understand. As far as my calculations go for the existing situation, I haven't factored in that the quarry pit is operational with erosion and sediment controls installed.
Right. Yeah.
It's simply the landform.
So it's almost like pre-quarry, or if the quarry wasn't there at all?
Yes, that's right.
But if the pond was there before the quarry, presumably? I might be being a bit pedantic. I guess what I'm trying to get at is what, perhaps my question is better, if the pond should have been allowed for in the USLE calcs, in other words, what that's taking out now, what sort of difference do you think that would make? Can you answer that question?
Yes, I can. If I had redone this with the existing pond operational, it would have further reduced the sediment loss.
That's the existing,
from the existing quarry footprint.
Yeah. So that do you know how much by? Because what your calcs show is it's good in the long term because you're actually reducing it from the current. So if you've reduced the current, then it's slightly reducing the benefit. See what I'm saying?
I do.
Yeah. So have you got some idea on? Am I just being pedantic? Is it quite a small amount? I mean, that's what I'm asking you to say. Is it do you think, based on what my question is, it's an amount that really will not make any difference to your calculations? I guess that's my question.
It would be 95% of 9.43 tonnes per year. So that would reduce the existing situation by about 9 tonnes per year, so that would be 55 rather than 62 and a half.
Well, I've got 64 pre-development, 64.4. Yeah. So it's a noticeable amount, isn't it?
Yes.
Do you think that changes your overall conclusions on the benefit?
Not overall.
No.
I think that the existing situation, even with the existing quarry, the larger catchment is still very steep parts of the site, and there's still a large input from those parts of the site into, when I say the system, into the receiving environment. With the erosion and sediment controls that are proposed, there's high levels of efficiency in terms of sediment removal prior to discharge. There'll be further staging that can't be accounted for within the USLE as it is, and further improvements in terms of impoundment within the quarry pit as well, which I feel aren't able to be accounted for in the USLE calculation itself, and in my opinion will further reduce the levels. I can't quantify it, but...
Yes, I understand that because that's the USLE calcs don't allow you to do that. I understand that issue. But yeah, so your evidence is that you're confident that in the longer term the overall sediment is going to be reduced from the current sediment loads. Yeah. So it's an improvement. Okay, thank you. Now, just bear with me, I need to find your evidence here. So in terms of the monitoring, using turbidity monitoring, discharge monitoring, talked about the proposed automatic turbidity meter at location within 50 metres downstream. So that seems good progress in terms of sorting that out. So the actual exact levels and testing regime requirements will be established by the conditions of any granted consent once the quarry is operational. That's what you said. I'm actually just trying to find exactly where that is. Can you just clarify that? So if that's going to be in the ESC or the AMP, that will be in the adaptive monitoring plan.
In relation to discharge monitoring?
Yeah.
Yes, it would be.
Yeah.
Yes.
So you do your sampling of total suspended solids to get a relationship with turbidity, and then from there you work out how the monitoring is going to work.
So we'll be doing the manual monitoring from day one.
Yep.
Fulton Hogan have already taken it on themselves to start doing some correlation monitoring. So every time they take a turbidity sample at the moment, they take a sample and get it tested for TSS as well. This is to try and expedite the process of getting a correlation of sorts between TSS and NTU turbidity. That is always difficult to get perfect. I'm probably not expecting us to be able to get a perfect correlation. In the proposed condition 48, I think, sets out a process for how we'll establish that. And then I think the point you were going to is when we start doing the turbidity monitoring, at a certain point we get to a turbidity level of discharge from a pond, and we're then required to take a TSS sample. Is that?
Yeah, no, I think you've covered it. That's just that correlation, and then that's used to further refine the monitoring.
Yes.
Yep. Yeah, okay. Now, I did have a particular sort of probably quite a technical question about rainfall, trigger rainfalls.
Sure.
So, yeah, I think you said a rainfall trigger of 20 millimetres in any 24-hour period, or 7 millimetres in any 1-hour period will be adopted initially. So that's a bit of a so you've got 24 hours and 1 hour. So there's presumably going to be periods between 1 and 24 hours that the rainfall is going to be somewhere in between that. So you need to have some sort of flexibility with that. So that's how you see it. That will be an interim trigger, and then that will be need to be refined or reviewed depending on how things behave.
So those triggers, those rainfall triggers, are fairly common across this type of monitoring, and I've adopted those particular rainfall triggers from communication with Greater Wellington Regional Council. Other rainfall triggers that I'm familiar with are 25 mil in 24 hours or 15 mil in an hour. Those are more commonly
You've gone lower than that, yeah.
used where in my neck of the woods, further up the country. But I accept that those are the triggers that have been requested in this instance, and I understand that those have been in place on the existing receiving environment and water quality monitoring plan, existing consent.
Yeah. So if you had a rainfall of, say, for 6 hours, then you'd have to just do a linear interpolation between those to see if it was over the trigger.
It would, yeah. So the triggers for monitoring would strictly be, as it's written, as it's proposed, if there's a 1 hour total of 7 mils or more, then that triggers monitoring. If there's 20 mils in 24 hours or more, then that triggers monitoring. There's no other trigger in there.
Well, I guess I'm thinking, so you had 5 mils in 1 hour, and then in 6 hours, do you then wait for 24 hours to get 20 mils? How does it actually work?
It's a rolling 24-hour period.
Yeah.
So,
okay.
In any 24-hour period.
It just seems a big gap between 1 hour and 24. That's all. Yeah. Okay, but that's what's worked from your experience. That's been useful. That's been appropriate in the past.
Yes. The 1 hour period is looking at the maximum 1 hour intensities.
Yeah.
So that's looking to pick up that really short, sharp rain event.
Which is what mobilises the sediment.
Correct.
Yeah.
Yep.
Yeah.
And the 24-hour period is looking at a longer duration event, even though the total might be less.
Yes.
Still get a longer duration. Yeah.
Okay. Yep.
If I could just intercede there, if you don't mind, is there any point of dispute that you're aware of from Greater Wellington on the information you've just given in terms of the 1 hour and 24 hour?
No, it's actually adopted from Greater Wellington's
guidelines,
almost standard approach, I think.
Okay. You confirm that?
Yeah, I can confirm that's just from our standard earthworks condition set.
Yes, thank you.
Okay, and my last question relates to incidents in the, I think it's the end of the environment, the ESC plan or the AMP plan. You talk about environmental incidents will be managed according to Fulton Hogan policies. And then it talks about failure is defined in this AMP as a device physically failing as a result of deficient design, construction or maintenance. I mean, I wonder if there's a bit more helpful definition. So what would be some examples of failure of a device? Can you just give us some examples now, please?
Just general examples could be that the emergency spillway and outlet pipe on a sediment retention pond wasn't sealed properly and that blows out in a major storm event for some reason. Could be the forebay being damaged by very intense inflows into the pond, eroding the support underneath the level spreader, which might blow that out into the pond. It could be an embankment of the pond giving way. So any sort of, I guess I could summarise it as any device failing in such a way that it no longer functions the way it's meant to.
I guess it's assuming that this document's going to be used by someone who's experienced in doing this sort of work, because I'm just thinking that it might be useful in the document to have some examples or a checklist. But would it have a checklist of things to look for in the SRP? Like just examples of what you're talking about, checking the spillway, checking that sort of stuff. So that would be part of it.
Yes, it will do. There's, I can't remember the specific condition, but there is actually a condition point there that talks about developing a checklist for all of the site auditing that's required under the conditions of consent.
So that would be part of the environment, the ESC, the Erosion and Sediment Control Plan.
Yes.
Would include those detailed checklists.
Would it be in the ESCP or AMP? It'll be in one or other.
One of them, yeah.
Yes.
Yeah. Okay, thanks. That's all I have.
Could I just add to that? At other quarries, we already have fairly pragmatic plans with diagrams showing such events and what to look for the quarry.
Yeah, fairly standard practice. Yeah, okay. Yep. Right.
Just a quick point of clarification, the condition that we were talking about there, 36D.
D, yes. You. I just found it. So that reads, Nigel, a maintenance schedule for all sediment control measures and a template checklist to be used for weekly compliant audits by the consent holder to fulfil the requirements of condition 8 and 28, sorry. And 28's talking about so it's the Erosion Sediment Control Plan, yes.
Yep. Okay, sounds good.
Okay, thank you, Mr. Pope. I'll just check. Yes.
Sorry,
Thank you,
I do
Commissioner
have some
Birch.
questions. Right. I have got some of them crossed out though. Mine are just a bit more generalistic. Some of your language in your report, when you talk about the guidelines, you talk about it broadly matching or generally matching. I just want to understand, is that the reason why you use those words, is it because it meets the guidelines as far as it's relevant to this application? Is that why you use that, or are there specific things that don't match the guidelines? I'm talking about Greater Wellington's guidelines.
Sure. As far as I'm aware, everything I've designed meets the guidelines. I think in some cases it probably goes beyond the guidelines.
Mm-hmm.
In terms of some of the staging that we have built into the ESCP for specific catchments to try and limit the amount of sediment that's generated in those catchments in the first place. Yeah.
And you also reference to industry best practice and best practice. Are they the same? Are they interchangeable?
Basically.
Yeah.
Yeah. There are things that might be considered industry best practice that aren't in the guideline documents. Yeah.
Because it's moving along.
Yeah.
That's right. Yeah. There are things in there that are becoming more commonplace, particularly around chemical treatment, pond management, and erosion control techniques that aren't specifically outlined in the guideline documents.
Okay.
Yeah.
Okay.
5.2, you say that all discharges will flow overland. So I just wondered what you meant by overland, because it's not really what I observed yesterday on our site visit. The discharge from the sediment retention pond is, channeled. It's not. So I just wondered what you meant by all discharges flow overland.
It probably might have been better phrased as most discharges will be overland. The current discharge from the existing sediment retention pond is flumed to the stream directly currently.
Yeah.
I understand that might be being looked to change, but for the most part, in terms of the other sediment retention ponds, most of those will discharge to land just before they enter water.
Just before 2 metre, 2 metres?
Yes.
Yeah, okay. So then it will just disperse and...
Yeah, there's always an erosion control structure of some sort at the outlet from a sediment retention pond.
So I just want to understand what sort of responses would occur if an exceedance occurred. What sort of tools in the toolbox are available?
Sure. And
what sort of time frame between sort of exceedance and management response?
Yep.
So sort of paragraph 5.4 of yours, you're sort of discussing, monitoring activities and things.
Sure, I want to try and be as comprehensive as possible, but I don't want to bore you.
Yeah, please.
So, as soon as a exceedance, the reason that we've gone for turbidity monitoring in this case, I think I pointed out in my evidence, is we're trying to get an instantaneous result from each pond rather than having to wait for days to work out whether we've broken a threshold in the AMP. So we do that. So we should know on the day at the time whether there's an exceedance of the threshold for further action. First thing that might happen would be a review. It might be immediately obvious why something has happened, or it might take a more detailed review, which would ordinarily be able to be completed that day, and potentially the fix for the problem may be able to be completed that day as well. For a more complex issue, potentially it relates to the amount of catchment or the erosion control measures that are within the catchment failing or not operating exactly as they should be, that may not be able to be addressed immediately, but there would certainly be a plan of attack straight away, and those measures would be undertaken as soon as possible in the coming hours or days as weather may allow, especially if machinery access is required for those issues to be rectified. In terms of freshwater monitoring effects, so where those thresholds are broken, there is a step there for a freshwater investigation in terms of effects, looking at a sediment deposition, with an ecologist then making a call on what level of effects there are and whether anything should be done about it immediately in terms of the sediment discharged to the stream, but also that will more than likely there would have been already at that point an assessment of the catchment of that device and the function of that device and whether improvements can be made. I think the conditions of consent actually stipulate timeframes that those actions need to be reported to the council. Does that give you an idea?
Yeah, no, that's helpful. Thank you.
Oh, sorry, I think your question was what sort of actions might be taken. And just, I think I've been quizzed on that by Mr. McLean previously as well. And I did put in my evidence at 5.13, some of the possible things that may need to be done specifically to remedy.
In your evidence or your?
Yes.
513, did you say?
Yep. So removal of sediment from devices, adjusting chemical treatment systems, carrying out further stabilisation of exposed catchments, fixing failed devices, installing new devices, controls.
Yeah. And you're confident that, obviously all those things require money, and you're confident that there's access to funds to be able to do that, respond in a timely sort of fashion?
I certainly am, and maybe Mr. Walsh may like to comment as well, but
I've asked him the same question before.
I don't foresee that being a problem in my area of expertise.
Is there anything in particular in terms of your assessment and your recommendations for erosion sediment control that reflects anything that reflects the sensitive nature of the receiving environment over and above another situation that you've worked on that might not be discharging into such a sensitive environment?
I could say from an overall perspective, the attitude of the applicant and the Fulton Hogan in particular, in terms of the operation of the quarry and the commitment to the measures that have been proposed, Fulton Hogan in particular have supported the implementation of quite a restrictive TSS condition in terms of end of pipe discharge from devices. That in particular I see as quite restrictive on the operator, but also will drive the innovation that's necessary to limit the overall discharge of sediment to the Paotahanui in particular. I'm not aware of too many consents that have a end of pipe discharge standard the same as this one is proposed to have. Most would be a reasonable zone of mixing downstream point, which might require further actions to be taken. Whereas this one is a straight thou shalt not. Sorry.
Yeah.
I think that's fair though.
No, that's helpful actually, because I've been struggling through this process to look at, okay, what are we doing that's different to this for this quarry to any other quarry, knowing that we've got such a sensitive receiving environment. So that's helpful to have that clarified. And I guess probably sort of related to that, and it's sort of the direction that's coming through from the planning documents. I'm just sort of wondering what factors can be employed to minimise the discharge.
The implementation of a very comprehensive erosion and sediment control plan and the implementation of a really well-designed monitoring program to ensure that discharges aren't exceeding the levels that we've assessed they will. Now, getting into the finer detail of that, some of the measures that we've proposed, like limiting catchment sizes, rather than just opening the entire thing up all at once, the old, there's words for it that I probably shouldn't repeat in the hearing, but the old cowboy attitude of just rip into it.
Mm-hmm.
What's being proposed here is definitely not that. It's the exact opposite of that, and it's probably going to restrict the operation of the quarry quite substantially, I would have thought, but it's in recognition of the receiving environment and the need to limit the sediment discharge to the greatest extent possible.
What are the non-sediment contaminants that would be present? I just sort of seen some indication that there's non-sediment contaminants. I just wondered what they are and whether they're treated any differently to sediment-laden water.
Sure. I haven't covered that specifically, but in any operation where there's machinery involved, then there's oils, lubricants, fuels, any of the byproducts of quarrying operations, machinery, that sort of thing.
Mm-hmm.
I mean, we are proposing to chemically dose the sediment retention ponds, but that is industry best practice.
Yeah, and I wasn't talking about that so much as because I know that that's a treatment option that you're choosing to take. It was more, what other contaminants are potentially present.
Sure.
So when you say that you haven't covered it specifically, I don't know if anyone else has covered it, or is it not something that is an issue in quarry management?
I'm sure it is, and I would probably defer to Fulton Hogan on that one, because they no doubt have specific policies in place, health and safety, environmental, around storage use, cleanups,
how machinery
incidents,
is operated,
all of that sort of thing.
Yeah.
Yes.
Okay. So that's, sorry, I'll just quickly, so that's a sort of like operations management that you have standard procedures.
Correct.
Yeah.
So things like spill kits for if we have a burst hose on a machine to isolate the spill, mop it up and dispose of it off-site in an appropriate manner. Procedures around where maintenance activities can be undertaken, etc. Yep.
So it's not something that's going to go flying into the sediment retention pond.
No.
Yeah, that's not one of your management responses.
No.
Okay. Just one other, I'm not sure if this is your sort of field or not, it probably is to a certain extent. There's been talk about vehicles needing to be washed or wheel washed or something before they leave the quarry. There's been talk about it, but I haven't seen anything in concrete about whether that's happening or not, or whether it's mooted or, so I'm not sure if that's yours or Mr. Walsh's.
I think where there's such conditions exist at quarries, they're usually where the exit is much closer to the road and where there is an unsealed road. One of the mitigation measures by which we avoid wheel washes is to put in an extent of tar seal, a sealed road. And indeed, I don't know of another quarry with 3 kilometres of sealed road to help address that issue.
Sure.
Presumably, those sort of matters are covered in the quarry management plan anyway.
Yes, and we also have, I think, conditions for sweeping the road, etc., should there be material on it.
Yeah. Okay. Thank you. That was all I had.
Okay. Not much from me at all, Mr. Pope. Just one question, in fact, and that's you referred to the end of pipe discharge for TSS levels. Is that condition 47 that you're referring to on the Greater Wellington?
Sorry, just need to get a copy of those conditions.
Yes, it's the 12th of August document.
Yes.
47 and 48.
47 and 48.
Yes,
Yep.
okay. And there's still, under condition 49, a reasonable mixing zone requirement as well, over and above that.
Yes.
Yep. Okay, and that seems pretty standard wording, Ms. Walker?
The mixing zone?
Yeah.
Yes, I suppose there's 2 additions, which were the ones Glenn noted in his evidence that were late additions. And that was the quantitative macroinvertebrate community index of no more than 20%.
Yes.
And the decrease in visual clarity of 30% upstream, downstream change.
Yes, so B and E. Thank you. Thank you. Okay, nothing further from...
Sorry, I just have one question. You get a question from me too, because you're lucky. And this just came, I suppose, I mean, the GWRC's position is 10 years for a consent. If it were a longer term consent than, say, 10 years, say 35, say, what would your position be or recommendation be to a full review of the sediment treatment devices after, say, 10 years in terms of updating for best practice, or is that something you think might be useful, or a report could then be provided to the council? What would you say to that?
Yeah, I mean, best practice changes all the time, and we'd probably expect that best practice would be taken up and implemented in any event. However, as part of, there's an annual review process for the quarry that's embedded in the conditions of consent as well. That could be an opportunity to do that over time, but I'm certainly not adverse to having a specified time frame and at some point in the future where a specified review could be undertaken of the erosion and sediment controls, any discharge requirements, monitoring, that sort of thing, that might reflect updates in legislation or best practice as it changes over time. Sure.
Excellent. And then one other update.
Sorry, just before we go, supplementary on that. Were you referring to the physical proprietary devices themselves? I thought.
Well,
what you were.
Yeah. Well, no. I suppose, and this is something which we'll cover off in reply as we need to. But I was just interested in Mr. Pope's view, and also I see Mr. McLean was on the line as well. I suppose the point was more just to sort of indicate with longer term consents what has been quite successful elsewhere for longer term consents and in the Waikato catchment for the river, which is obviously very sensitive and going through a similar sort of process, is sort of these sort of BPO type reviews at key stages through a consent in order to just to give the applicant the opportunity to have a look on site, do a report to the council, and then that also specifically triggers a review power if the council needs it as well. Because often the reason the council says we want a new consent is so that they can get all the information in front of them to then make a decision. Whereas if after a period of time a report gets provided to them, then the work's done, rather than having to sort of go out and do it themselves. So I guess, I mean, given sediment is a key issue here, and it's a very sensitive receiving environment, it just seemed to me.
Sure.
So that, it just seemed to me something that you could consider.
Okay, if you're going to go down that line, and I understand why you might, it would be useful if you're proposing to link the BPO reviews to a Section 128 matter. It would be very good if that discussion could occur on a without prejudice basis between Ms Walker and Mr Baker.
Yeah, and that would be on the understanding that I guess GWRC's preference is still
Yes.
shorter term, but it was a shame. I mean, one of the other suggestions we did make is, and we did want to talk about it. It's going to be difficult to put it in the consent conditions, but Fulton Hogan and Willowbank is certainly open to something similar for any sort of cultural health indicators that might be developed as well. We're not going to write in the consent conditions what they are because they need to be developed. But again, that's a sort of, from a cultural health indicator report, those are again something that can usefully be looked at in periods of time in order to actually check in on those.
Yes.
And again, those have been proposed elsewhere and I guess taken up on the basis that it provides a useful view through time and over time to check on that. So,
Yes.
I'm happy for, obviously, for the planners to discuss, and if there's a framework for that could incorporate
Well, I guess
those
the
in
thing
itself.
arising from me, Ms Walker, is that all we're asking for is for you to partake in the dialogue. I mean, if you still retain your position, that's your prerogative. Just recall that I've asked you to give some consideration to the legal principles that Mr Matheson raised earlier about consent duration and how he's applied those in this particular instance. So it may be that if you do disagree and don't change your position on the duration, we might ask you to assist in a drafting exercise with Mr Baker to assist the panel in the event that they might want to go down that line at what that sort of condition framework might look like.
Thank
Sorry,
you.
just to clarify, in terms of providing annual reviews or robust reviews that they're suggesting?
What I'm understanding from Mr Matheson is that he's put a question to his Mr Pope that that there could be an alternative to a 10-year duration, and that might be through having a review condition at the 10 years that under the BPO, I guess, auspices that avoids the need for the consent to lapse and for a new consent to be applied for. And so all I'm saying is that your position at the beginning of this hearing is clear as to the 10 years. I've asked you to consider the legal principles and how they apply to this site as to whether that changes your view. If it doesn't, I'm saying that's your prerogative. In the event that it does or doesn't, it would assist to see what the wording might be, and some wording between yourself and Mr Baker, in the event that the panel decides to adopt that approach.
And thank you. And just to be clear, it's sort of the equivalent in sort of industrial or manufacturing consents. It's often termed a sort of technology review. So it's the applicant does the review, not asking the council to do the review, and it's not the review condition. It's a report that's prepared, updating on advances in technology or treatment options or whatever, and then it's put to the council, and then the council can use that. I mean, as Mr Pope said, it is it's better to adopt these things as you go along, but it's often a useful, I suppose, mark in the road at certain points, given that 10 years is a long time in freshwater. We'll probably get 3 more MPSs by then, but it is...
Or none.
Anyway, it's an option, so that was the idea.
Okay, well, let's
Just a point of clarification there from the first matter Bell raised is I feel like we're going down a path of talking to reviews. My understanding of the ESCP and the AMP is that the AMP allows us to continually monitor the ESCs and how they're used across the site. That is a process that should be happening anyway, and the whole earthworks plan is centred on the AMP process of continually updating and reviewing the ESCP. So I'm not quite sure what these reviews will add over and above what should
My understanding is, and you're quite right, what you've just said in terms of with the AMP and the being updated. But what I understand Mr Matheson's suggesting is that as an alternative to a 10-year duration, that there's a BPO type review built into the consent that, and I suspect the quid pro quo is that he's suggesting that it should be a 35-year consent with these 10-year reviews built into that process. Is that what you're suggesting, Mr Matheson?
A longer term. And I guess the point is, you're quite right, the report might be very short and it might say, well, there've been these 8 innovations and we've updated or we've incorporated all of them already. Or it might be there's this cool new chemical that does this or it does that, or there's now a non-chemical that does the same thing. And so it's all of those sort of options, which is just a matter of having a requirement to actually take a pause and look at it.
And I believe that requirement will come at the annual review, which the applicant must do, and it's dictated by the conditions of the AMP, where they should be looking to updates in science and best management practices across the site. So I believe that process will be happening anyway.
And the condition framework would suggest it will.
Yes.
What I'm understanding from Mr Matheson, though, is that putting that to one side, he's drawing on that, and perhaps with the addition of additional reviews under the auspices of BPO, that there may be an alternative to having a 10-year lapse period for the Greater Wellington consents. Now, I'm not suggesting we agree with that. All I'm saying is that he's suggesting it. He's put the question to Mr Pope. Mr Pope answered it in terms of what might be involved in that. And I just want you to be in the tent on that discussion. And as I said, if you disagree and you still maintain your position, that's your prerogative. The panel would want to know why you disagree, why you don't accept that approach. But we'd also like to know that in the event that the panel wanted to adopt that approach, how that condition might be worded, or conditions might be worded. And that would be on obviously a without prejudice position to your overall recommendation for a 10-year consent.
Cool.
Is that clear?
Yep.
Thank you.
Thank you. Just the last point, just to confirm, Mr Walsh is going to confirm the exact dimensions tomorrow, but the understanding is that the bench with the stream diversion is 15 metres rather than 7.5, so that will allow some planting, but we're just going to double check that. So that was designed specifically to allow, but we'll come back to you and check that.
I guess my question there was too, is realistically, how is it possible? Yeah. So there's 2 parts to that.
Thank you. It's been a very long day. Just before I let everyone go, Mr Matheson, we've achieved the timetable on the first day by going an hour later, but hopefully that'll put us in good stead for tomorrow.
Blame me for that, but you don't have to hear from me tomorrow, so we should be well ahead of schedule.
I certainly wasn't apportioning blame to anyone. Do you have any sense of what's been happening with Ms Wilkening and Mr.
Yes, there's been some further progress made just from the email. Yep, so things have been further narrowed. I do feel we'll get through tomorrow a little quicker. I think this was the gruntier stuff today. So.
Sure. And also on traffic, do you have a feel for what may or may not be happening there?
I had a chat to Mr Kelly before. They have conferenced, and he's been tasked with preparing a joint statement.
Oh, most excellent.
Not complete agreement, I understand, but they've at least conferenced today.
Thank you. That's good. And we're still planning to kick off with Mr Noonan tomorrow, first thing. Okay. And does anyone feel the need to convene earlier than 9 o'clock tomorrow? Famous last words, right? Okay, that's good. Mr Birch, anything final? Nigel? No? Thank you.
Sorry, Ash, can we leave the stuff here or do we have to vacate?
Yes, you can.
Thank you.
Thank you, everyone. See you at 9 o'clock tomorrow. Sleep well.